Yes, madam.
Petitioner is a professor in the respondent institution, my lord, had filed a complaint regarding academic misrepresentation without having given me an opportunity of being heard or even the reply filed by the respondent against whom I filed.
Day after tomorrow.
They've passed an order, my lord.
Yes.
My lords, petitioner only seeking mandamus. He is a practicing advocate, my lord. Someone trespassed his house and abused him. FIR not
Trespassed advocate's house and
yes, my lords, practicing advocate. Kindly have it tomorrow, my lords.
The pending matter, my lord. Since we need it at 2:30, today is the last date for editing the NEET PG applications, my lord. It's a caste certificate issue. This court had already granted stay of the impugned orders and also allowed the petitioner to pursue his education under the category. However, my lord, it's the online
pending matter.
Pending, my lord.
Cannot be taken at 2:30 tomorrow.
My lord, today is the last date, my lord. We had
They
already
used to
moved the
move it
matter
yesterday, Mr. Counsel.
Yes, my lord.
They moved it yesterday.
My lord, we have moved it on Friday, my lord. It was supposed to be listed yesterday, but in the registry there was some confusion whether it should go before this court or court of MIR. Then we clarified to them. We even pursued the in the registry, but it did not get listed, my lord.
Need to namun then.
Caste certificate.
Post before the appropriate mention. Cash certificate.
2:30, my lord. Today
the other side will not know that it is being listed today. You should be more responsible.
My lord, we pursued both the days, my lord.
The other side will not come. You can't be listing pending matters tomorrow.
Tomorrow. Yes.
Sorry? Comply with the office objection, then it's come. Then make a submission before the register, they'll post it before the court.
I'm requesting for fresh for 2:30, not GM policeman. The police, without registering an FIR, are trying to settle an election dispute to a trust. The Chaturmas is on, the social festivities are going on. We are the lawfully elected body. The police are trying to summon us, not when the Chaturmas is on.
Shamant, police matter, settling matters.
Commercial street, not summoning, it's a purely civil dispute. They're summoning us without registering an FIR and trying to settle it.
Get in. Chaturmasandre in commercial street. That has nothing to do. It's a police not to interfere. Serve it on.
Lordship, in my case, the petitioner is an advocate. Petitioner is an advocate, Lordship. He has been falsely implicated for representing one co-accused. He has been falsely implicated in an FIR for representing and receiving a legal fees for which we have an agreement, retention agreement. Now police is, they are making endeavor to arrest me. They are visiting my office. They are visiting my house. That is badly affecting my, it is listed at the end of.
Tomorrow.
That's one GM
Serve
case.
a copy.
One GM case or matter, my lords, challenging the calendar of events, my lords. Nomination is supposed to start from 31/7.
Our calendar of events you can't challenge before this court. Regular course.
Tomorrow, my lords.
Has it been resumed? Tomorrow. Yes. Who are on?
Office had raised the objection that is not as your language. But had given
on 20th August, Your Lordship. From 13th, the Karnataka legislative session commences. I may not get the leave, Your Lordship. Therefore, the matter may taken up before 5th, any date, Your Lordship.
Was before the appropriate bench on 11th.
Regarding the survey of the forest land, Your Lordship has disposed the matter last week of collected matters.
Regular course it will come. Why do you have to move? It will come in regular.
Private property is notified for acquisition and they mark it online.
ಇಲ್ಲ ಸರ್ ಒಂದು ಅರ್ಜೆಂಟ್ DC ಫೈಲೇ ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಒಳಗೆ ಇಟ್ಕೊಂಡು.
Acquisition won't come before us.
They've not even.
But is notified for acquisition
No, nothing is happening. The local panchayat are not there.
tomorrow.
Employing women.
That's been dealt with. Day after tomorrow.
Tomorrow.
It is no urgency. No urgency. Yes. But fifth thought.
Two persons are there, then it will be on the basis of.
Drawing of lots. So, tomorrow. Mandamus, regular course. Good. Yes. It may be a civil dispute day after tomorrow. Parole 5th. Yes, Mr. Chanchud. Yes.
My lord, one is a fresh matter, whereas the other two matters, my lords, it's a pending matter, my lord, wherein we've challenged the tender. The respondents have come up with a notification, my lords. So therefore, if it is posted tomorrow,
Matter, we'll have it tomorrow. Pending matter will come in the regular course.
please, grateful, my lord.
Yes, Mr. Chanchud.
Using a memo for end of the list. This is a threat of dispossession, Your Honor. It's a property belonging to HMT. Is it property belonging to HMT. The forest without any justification grounds.
We have already passed 2-3 orders of that.
I don't think so. This is a latest order, Your Honor. It's the latest order, and today there is a threat that we will be dispossessed, Your Honor.
230.
230.
Now, why is this happening? When it is seized of the matter, there is a third set of notices.
Yes, Madam.
First
I will
notice
just demonstrate that, Your Honor.
We will check second notice state, third set of notice.
Yes, Madam. I will demonstrate it that.
I will get the instruction.
Jarkavande Kaval, survey number 1.
That's it, Madam.
Read with 17 and 18.
HM.
Why are you doing this?
Survey number 1 of Pinya village and 17.
We'll have to
18 of
make
Jharkhand.
observations if this is what they do. Yes.
End of the list, Madam.
End of the list.
Well, Your Lordship said it in the usual course, my lord. Now, my lord, the matter is, my lord, posted on Saturday for orders, my lord. The DC, my lord, for endowments, my lord, is not releasing the file to the staff at all.
Pending matter,
No, my lord, fresh matter for day after tomorrow, my lord.
fresh matter day after.
My lord, because in the application, my lord, the matter is posted for register protocol stating that, my lord.
If there are compliance. it will
Please,
go
my
before
lord,
the
please, day after tomorrow. I'm grateful.
If complied, post before.
My lord.
Yes, Mr.
Fresh
Arvind.
matter, my lord. Tomorrow, the SP Hassan has passed the adjournment order, my lord, on day for yesterday. Therefore, I have to exchange matter tomorrow minutes.
Hearing ಆಗಿದೆಯಾ?
Illa.
ಆಗಿಲ್ವಾ? Tomorrow.
It's a pending matter. I have filed early hearing application. Work committee is constituted.
Pending matter will come in senior.
ಅಲ್ಲ, ಅದು hearing ಆಗಿಲ್ಲ ಸರ್. Hearing ಆಗಿಲ್ಲ. ಕೇವೇಟರ್ ಇದ್ರು ಅವರಿಗೆ.
ಯಾವುದೇನು ಸೀನಿಯಾರಿಟಿ ಬರುತ್ತೆ.
Please, early hearing application ಮೇಲೆ.
ಕೊಡಿ ಅದು.
Fresh matter, with regard to the allotment, where DC has passed on.
You get the chance to make your submission for mentioning. Get ready and make it properly.
DC has ordered for the allotment, and with regard to that, we have to put challenge on that.
What allotment?
The property allotment, with regard to that, fresh matter.
Tomorrow. Next time when you make a mention, get better prepared. Yes.
legal officer has directed us for payment of interest.
Hmm.
KDB has not been paying interest to me. I'm trying to raise it from mandamus.
KDB to pay interest on?
Earlier, there was an allotment of property. There was a conditional order, I had to deposit an amount. I succeeded in the writ penal, but allotment was not given, therefore I had to withdraw the money. Thereafter, I have given a representation for payment of interest.
Your principal has been paid interest.
Principal has been paid interest on.
Day after tomorrow. Yes.
I got, I had the WP forest fund. So honorable court has ordered us to produce certain documents where my land is started. I have it from the last 2 years. Meanwhile, my senior has also expired. Another urgency is that they have validated my. I'm a farmer, so my livelihood is from the cultivation.
It's a pending matter. Come in seniority.
My request, yesterday is to memo move.
We can't make exception. Everybody has urgency. Can't make exception.
My lord, my request ambassador petition. My writ of mandamus, my lord. Already say.
Writ of mandamus kodiyappa Bharat. ಏನು urgent? Mandamus ಏನು urgency ಇಲ್ಲ ಕೊಡಿ.
230 my senior engaged please request my lord.
Mandamus ಗೆ.
My lord ಏನಾಯ್ತು ಹೇಳ್ಬಿಡ್ತೀನಿ my lord.
ಡಿಸೆಂಬರ್ ಗೆ ಹೋಗುತ್ತೆ.
ಇಲ್ಲ my lord request ಹೇಳ್ಬಿಡ್ತೀನಿ my lord ಏನ್ ವಿಷಯ ಅಂತ ಹೇಳ್ಬಿಡ್ತೀನಿ my lord ದಯವಿಟ್ಟು ಕ್ರಷರ್ ಬಿಸ್ನೆಸ್ ಮ್ಯಾನ್ my lord. ನಮ್ಮ ಕ್ಲೈಂಟ್ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾರೆ ಅದರಲ್ಲಿ ಲೋಕಾಯುಕ್ತ ನೋಟಿಸ್ ಕೊಟ್ಟಿರ್ತಾರೆ ನೋಟಿಸ್ ಆಲ್ರೆಡಿ ಸರ್ವೆ ಎಲ್ಲ ಆಗೈತೆ ಮತ್ತೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಹರಾಸ್ಮೆಂಟ್ ಮೇಲೆ ಪ್ಲೀಸ್ ರಿಕ್ವೆಸ್ಟ್
ಕೊಡಿ ರೆಗ್ಯುಲರ್ ಕೋರ್ಸ್
230 minutes.
Lords, election matter, my lords, I have given a memo tomorrow or day after tomorrow, my lords, we have challenged the calendar.
Fresh matter, pending matter.
Fresh matter, my lords.
ಹೇಳಿದಲ್ಲ KSR.
Please, my lord.
It will come day after tomorrow.
Day after tomorrow.
Yes.
GM police, my lords, we have waited for it of mandamus.
Mandamus, why do you have to give it? It will come.
They are not taking any action against the respondent.
There's no need to mention a mandamus matter, Mr. Counsel. Give the memo, it will come. Pending matter.
The matter is this, there is a tender that was called for by the PWD fund. By the application that is being presented because previously have been filed and it's still pending for this one and entry order.
Day after tomorrow. Yes.
Pending tender matter. Mentioned it yesterday. My lord,
Pending will come in senior.
May I please, one submission. My lord, what has happened is the impugned tender which we have impugned. Tomorrow, fresh orders are being given based on that tender only. Else will be put to irreparable loss because even in the next tender, 5 years experience will be counted and will not be counted, madam. We'll be out of our entire production.
Yes.
Kindly we list it tomorrow.
Adjournments. List number 1, page number 6, serial number 44.
Serial number 44, madam. Appearing for the petitioner. Already informed to the other, kindly weeks time.
You are appearing for?
Petitioner.
The request of the counsel for the petitioner, released on 27th August.
Serial number 38, madam. 38. Not interim order may be extended.
Interim order 38.
Yes.
Yes.
Kindly order next week.
At the request of counsel for the petitioner, 28th August.
Yes.
Page number 7, serial number 45 to 50.
My lords, 49, my lord, short of. Serial number 49.
Yes.
Short accommodation.
You are for?
Petitioner.
Have you informed the respondents? Don't mention. Next.
Page number 8.
45, 2 weeks time.
ಯಾವುದು?
Serial number 45.
45. ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
Yes, now last time, 2 weeks time.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? Yes or no? Don't mention.
Page number 8, serial number 51 to 53.
Serial number 53, madam.
Yes.
53 ನಲ್ಲಿ opposite ಪ್ರತಿ ತಿಂಗಳು 55,000.
You are opposing.
Opposing.
Rejected.
Last time your lordship has fixed the date as 11/8. After hearing him,
My lord, I will request that
he has sought so much of efforts to get early date. Your lordship said there is no time you can.
Now it is listed today. Let us see. Yes, next.
So today, my lord, I got some independence. Next week, any day.
You cannot mention like that, Mr. Counsel, when it is being opposed.
Please, please.
Page number 9, serial number 54. Page number 10, serial number 55 to 60. Page number 11, serial number 61 to 65.
serial number 64.
Hmm?
Not present.
64 dismissed as not pressed. Memo.
Page number 12, serial number 66 to 71.
70, madam.
70.
70.
Ah.
Petitioner, madam. Kindly place.
At the request of counsel for the petitioner, 28th August. Interim order earlier granted is extended till next. Interim order check.
74, my lords. I appear for respondent number 1.
Hmm.
In 2 weeks time to file objection.
Have you informed
Yes,
everybody?
Informed, Mr. President.
Everybody.
Yes. No, I have not informed Mr. Mohammed Niaz. I
Then
informed
don't
my
mention. Then don't mention.
I informed the petitioner, my lord.
Then don't mention if you're not informed everybody.
Yes.
Hmm. Yes.
I am for the petitioner in serial number 73, my lord.
Yes.
I have 2 weeks time to file my objections. I appear for the respondent number 2.
Yes, any objections?
No, my lords, maybe urgent.
73, counsel for respondent number 2 seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, by 21st August, failing which will be taken as not filed, matter proceeded with. Pre-list on 28th August. Grateful.
Deeply obliged, my lord.
Page number 15, serial number 76 to 80. Page number 16, serial number 81 to 87.
Serial number 84, Lordship, I appear for the petitioner.
Hmm.
The other side of the state, I have informed IC for the
84 at the request of counsel for the petitioner, 28th August.
grateful, Lordship.
87. The request of counsel for the petitioner, 28th August. Yes.
Serial number 88, my lord. Counsel for respondent 2 and 3 is disabled before this honorable court. The register might be
Post the matter before a court of which a bench of which SGRJ is not a party.
Much of it. Serial number 95, letter for withdrawal.
95 memo for withdrawal.
List number 1, fresh
Serial
matter.
one submission.
Yes, madam.
Serial number 34, I am representing on behalf of the
30?
serial number 34, Mila.
Oh.
I am representing on behalf of the petitioner.
Ah.
Today has some small personal inconvenience. Next week,
Request of counsel for the petitioner, 28th August.
please much of it.
List number 1, fresh matter, serial number 1, HS Lingaraj.
Limitation.
Yes.
Hmm? Limitation disbursement.
Serial number 2, Kavita D.
For the petition, I'm challenging the annexure K, my lord, senior citizen order, my lord. Annexure K, page number 109, my lord. In this case, my lord, I have not contested, they have not given opportunity to file my
Where is the order?
objections.
Page number?
Page number 109, my lord, annexure K. After this order, my lord, the respondent number 2 to 7, they have created subsequent order, sale deeds, my lord, third party interest in ink page number 115, I'm enclosed, my lord, annexure M. In the, as per the party, Panchayat Parikat, my lord, I have got this property. The senior citizen who is my father,
Your advocate appeared, Prativadi Para, Vakil Sadri Prakaranadali, Vicharne Hajaragi. They have appeared.
There, Swami, but he didn't file his objection.
That is between you and your lawyer. You can't say you are not given an
No, my
opportunity.
lord, because of advocate mistake, party should not suffer, my lord. Because after this, immediately, my lord, within a
Madam, don't
month-
make allegations against your
No, no, my
advocate who
lord,
is not
It is my
before us.
fraternity, my lord, I can't.
If you have this one, take action.
Please, my lord.
And
After-
AGA accepts
within a
notice for
month, my
respondent
lord,
number
they
1.
have
Assistant
subsequent.
commissioner may have to be made party. Assistant commissioner has to be made party.
Assistant.
ಅದಕ್ಕೆ ನೋಡ್ತಾ ಇದೀವಿ. Where the tribunal is not made a party.
No, my lord, I've made a party.
Tribunal is not a party. File an application.
My
File it today. ಇವತ್ತು ಫೈಲ್ ಮಾಡ್ತೀರಾ?
Today itself.
Pass over.
Serial number 3, Mohammed Shamir.
Petitioner, sir.
Yes.
This is a constitutional challenge to the Karnataka Platform-Based Gig Workers Act.
Gig workers. What was the order we passed on last?
It's connected to 19746 of 2020.
Here is a copy of the order. And AGA for respond number 1 and 2. Who is for respond number 3?
I appear for respondent.
Respond number 3. Karnataka Platform-Based Gig Workers Welfare Board. State.
Fourth respondent. Do not serve.
Karnataka Platform-Based Gig Workers Welfare Board. Who is the
It's not the state.
That would be the state, your lord.
What has happened in the other matters?
Notice has been issued.
Notice has been issued. Issue notice to respond number 4, returnable by 24th August. Issue notice to respond number 4. Connect with WP number 19746 of 26. The coordinate bench of this court has passed an interim order dated 3/7/26. The benefit of the said interim order would be equally applicable and available to the petitioner in the present matter. Connect with WP 19746 of 26.
Number 39 also is similar.
When it reaches, please.
Lordships, if I may
We
make
need
one
the file
request.
to pass orders, sir.
If I may make one request, in the order passed by the coordinate bench, the date fixed for compliance was 23rd of July, which has since passed. So your Lordships may kindly grant me now 3 weeks, because there, the petitioners, after they filed the petition, were granted 3 weeks to make a deposit of the amounts payable under the act. So similarly, from today, 3 weeks may be granted, which would be 21st of August.
The time period, benefit of so and so is extended to the petitioner. However, the time period for compliance would have, time period for compliance of 3 weeks would have to be calculated from today.
Serial number 4. Gaurav GK.
Yes, Gaurav.
But the petitioner, my lord, the elected office bearer of a society, my lord, consumer court, my lord, has taken cognizance of.
Challenge a consumer for court order and challenge it before this court.
Issue is this. I have also questioned the virus of section 41, the Consumer Protection Act. That, my lord, similar matters, my lord, are being listed on the 29th, my lord, before this honorable court.
We're trying the virus. Since the virus of section 41 of the Consumer Protection Act, you're not made the union a party.
No, my lord, may be permitted to.
If you're challenging the virus of a central enactment,
Certainly, I understand, my lord. Due to
you'll file the application today.
I'll file an application.
So,
Lord, I'll file an application by day after, my lord. It may be relisted on 29th. Similar matters are being listed on that.
counsel for the petitioner seeks for and is granted 2 days time. Relist 29th is tomorrow.
Please. I'll file it in the meantime.
You'll have to file it by tomorrow.
Yes.
Relist tomorrow, 29th.
Serial number 5.
In general parole.
Parole. And AGA for respondents, relist on 5th.
Great.
Number 6. Manjula D.
Appearing to the petitioner, my lord.
Yes, madam.
There's an interim order by subdivisional officer, Annexure D, my lord. Kindly direct them to implement the order. Order of Assistant Commissioner. Annexure D.
And AGA for respond number 1, 2, 3 and 4. Issue notice to respond number 5 to 8, returnable by 7th September.
My lord, interim order may be granted.
How can we give a, you are asking for a mandamus, let them come. Next.
7. Data cases.
This might have protest premature release.
And AGA for respond, relist on 5th.
Serial number 8. Chandrakant Arvind.
Yes, Mr. Gole.
My lord, I appear for the petitioners. Petitioner is a national my lord, kabaddi player.
National?
He had national kabaddi player.
Kabaddi player.
Kabaddi player. He had, along with one Mr. Satish, my lord, petition number 2. He had filed objections contending that the association, my lord, is wrongly constituted, and that the registrar, my lord, respond number 4 appears to have taken a decision that the page number 60, my lord.
60.
I'm sorry, 90, my lord.
90.
Annexure N, page 90. He has in fact found, as a matter of fact, my lord, there are 2 registrations, and that there is a fraud committed. And in spite of that, my lord, for want of documents, my lord, the district registrar has rejected my petition. Complaint.
Where is that finding?
That you also will find, my lord, at page 100. ದೂರದಾರರು ಆರೋಪಿಸಿರುವಂತೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಅಮೆಚ್ಯೂರ್ ಕಬಡ್ಡಿ ಅಸೋಸಿಯೇಷನ್ ಒಂದೇ ಹೆಸರಿನ ಎರಡು ಸಂಘಗಳನ್ನು ನೋಂದಾಯಿಸುತ್ತಿರುವ ಎರಡು ಆರೋಪಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಒಂದೇ ಹೆಸರಿನ ಎರಡು ಸಂಘಗಳು ನೋಂದಣಿಯಾಗಿರುವುದಕ್ಕೆ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಮೇಲ್ನೋಟಕ್ಕೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಅಮೆಚ್ಯೂರ್ ಕಬಡ್ಡಿ ಅಸೋಸಿಯೇಷನ್ ನಂಬರ್ 20 ಈ ಸಂಘವು ವಿವಿಧ ದಿನಾಂಕದಲ್ಲಿ ಸಮಗ್ರ ಜಿಲ್ಲಾ ಬೈಲಾ ತಿದ್ದುಪಡಿಯಾಗಿದ್ದು ವಿಳಾಸ ಬದಲಾವಣೆಯು ಸಹ ಆಗಿರುವುದು ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳಿಂದ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಹಾಗೂ ನೋಂದಣಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ರಲ್ಲಿ ಮೇಘನಾಸಿ ಡೆವಲಪರ್ಸ್ ಅಂಡ್ ಬಿಲ್ಡರ್ಸ್ ಲಿಮಿಟೆಡ್ ಸೈಡ್ ವೆಲ್ಫೇರ್ ಅಸೋಸಿಯೇಷನ್ ಎಂದು ಇರುವುದರಿಂದ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಅಮೆಚೂರ್ ಕಬಡ್ಡಿ ಅಸೋಸಿಯೇಷನ್ ಇದರ ನೋಂದಣಿ ಸಂಖ್ಯೆ ಸಂಬರ್ಸೋನ್ಸೋ ಎಂದು ಇರುವುದು ನೈಜತೆವೆಂದು ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳಿಂದ ಕಂಡು ಬಂದಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರ ದೂರು ಅರ್ಜಿಯನ್ನು ವಜಾಗೊಳಿಸಲಾಗಿದೆ.
What is your complaint that there are
My complaint
two associations?
Association number 1.
What documents? What document have you produced to show that there are two?
Documents, my lord, we have produced the documents Annexure A and Annexure C.
Annexure J.
Annexure A.
Annexure A, page number 36. Page number 36.
There are
Annexure C is page number
36, my lord. 36 is original. It is survey number, I'm sorry, yes, number 352/7475.
Annexure C.
It is the same.
No.
Allah, Annexure C nalli.
May I intervene, my lord? I appear for the Sangha. Registration 352 of 7475 remains. There has been some mistake
Annexure J.
in the year 2012 and 2012 returns under section 13 were filed. An acknowledgement is issued at page 66 annexure J.
929.
Yes.
Referring as 9/29/2003-2004. It's obviously a mistake in the sense this 9/29 of 2003-2004 belongs to one mega city developers builders employees association. This mistake has continued for some years continuously, though when our address was changed, we filed application for noting the change of address. That is done under 352 itself. And this is the present writ petition is filed by someone who is not the member or anything.
He is a state level player, is what?
Yes.
He is a state level player. He was a state level player. That's right. With regard to this society, he is neither a member nor affiliated
State
to
level
society.
player is not a member of the amateur.
That's what he has opted. They wanted a rival association to be formed, etc., which came up last year and they lost in that writ petition. Thereafter, now this has come.
Secondly, my lord, the elections are not held at all.
That you file an application for 25 inquiry.
No, elections, that we have filed objections, my lord. We have filed detailed objections, my lord. Certain information we have also submitted, for which the respond number 4, my lord, has collected all the documents, including the old documents which my learned friend
In
senior.
this matter, your only contention is that there are two societies which have been registered. With the
No,
same
other
name.
conditions are also there.
That has been considered, and that is the impugned order which has been passed.
No, now the impugned order is passed, my lord.
On that
without,
aspect.
No, without considering the documents, my lord, which the respondent number 4, my lord, himself has appeared. He has taken note of it. You have produced documents.
What are your reliefs which you have sought for in this?
Secondly,
You
there
have
are
given
no elections
representation
held,
at
my
L
lord.
series.
There are no elections held at all.
You have given your representation
Yes,
now at L series.
respondent.
Correct them to consider your representation.
No, the respondent number 4, my lord, he has now rejected my
Obviously.
petition. Obviously ಅಂತ ಆಗೋದಿಲ್ಲ. ಅದು ಯಾಕೆ ಅಂತಂದ್ರೆ
352 ಒಂದೇ ಸೊಸೈಟಿ ಇರೋದು, ಎರಡಿಲ್ಲ.
ಅಲ್ಲ ಅದು ತಪ್ಪು ಅಂತ ಅನ್ನೋದು ನಮ್ದು ಬೇರೆ ಬೇರೆ ನಂಬರ್ಸ್ ಇದೆ. ಬೇರೆ ನಂಬರ್ಸ್ ಹೆಂಗೆ ಕೊಡ್ತಾರೆ
ನೋಡಿ ಪಾಪ 929 ನ ಕ್ವಾಶನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ. 929 is some other association.
ಅದೇ ಅಸೋಸಿಯೇಷನ್ ಇದು ಸೇಮ್ ನಂಬರ್ಗೆ ಇಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪೇಜ್ 100 ನಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಅಮೆಚೂರ್ ಕಬಡ್ಡಿ ಅಸೋಸಿಯೇಷನ್ ನಂಬರ್ 20 ಸಂಕೀರ್ಣ ಕಸ್ತೂರಿಬಾ ರೋಡ್ ಬೆಂಗಳೂರು. ಈ ಸಂಘದವರು ಪ್ರತಿ ವರ್ಷ ಸಂಘದ ಲೆಕ್ಕಪತ್ರಗಳ ದಾಖಲಾತಿಗಳನ್ನು ಸಕ್ರಮ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿ ಸ್ವೀಕೃತ ಪತ್ರವನ್ನು ಪಡೆದಿರುವುದು ದಾಖಲಾತಿಗಳಿಂದ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಹಾಗೂ ಸದರಿ ಸಂಘದ 22-23 ಚುನಾವಣೆಯನ್ನು ಇಲಾಖೆಯ ಅಧಿಕಾರಿರವರ
ಪೇಜ್ 100 ಬನ್ನಿ. ಹಾಗೂ ನೋಂದಣಿ ಸಂಖ್ಯೆ 929-0304 ಅಲ್ಲಿ ಮೆಗಾ ಸಿಟಿ ಬೆಂಗಳೂರು ಡೆವಲಪರ್ಸ್ ಅಂಡ್ ಬಿಲ್ಡರ್ಸ್ ಲಿಮಿಟೆಡ್, ಆಮೇಲೆ ಏನೋ ಇದೆ ಮೆಂಬರ್ಸ್ ವೆಲ್ಫೇರ್ ಅಸೋಸಿಯೇಷನ್,
ಅದು ಬರೋದೇ ಇಲ್ಲ.
929 is theirs.
ಅಲ್ಲ ಅದು ತಪ್ಪು.
We'll ask the state to give us this one. If we get the certificate of mega city,
ಆ ಮೆಗಾ ಸಿಟಿ ಇದೆ ತಪ್ಪು ಅಂತ ಇವರು ಅದನ್ನ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಅನ್ಬಿಟ್ಟು ಫೈಂಡಿಂಗ್ ಇದೆ.
ಅದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, ಅದು ಕರೆಕ್ಟ್ ಆಗಿ
ಇವ್ರು ಅಂತ ಇದ್ದಾರೆ ಅಸೋಸಿಯೇಷನ್.
929 ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರೆ ಯಾರ್ದು ಕ್ಯಾನ್ಸಲ್ ಆಗುತ್ತೆ?
ಅವ್ರದ್ದು ಕ್ಯಾನ್ಸಲ್ ಆಗುತ್ತೆ.
ಯಾರ್ದು?
ಅಸೋಸಿಯೇಷನ್
ಮೆಗಾ ಸಿಟಿ.
ಮೆಗಾ ಸಿಟಿದು ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಗುತ್ತೆ.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ.
ಅಲ್ಲ ಮೆಗಾ ಸಿಟಿ
You want somebody else's registration to be cancelled. There's a mistake which has happened. They corrected the mistake.
ಅಲ್ಲ ಅವರು ರಿನ್ಯೂ ಮಾಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ 329 ಫಸ್ಟ್ ಇದ್ದಿದ್ದು.
Annexure A and Annexure C are the same registration, Mr. Gole, of 342, 352.
Annexure A and Annexure J. Annexure J.
ಅಡ್ರೆಸ್ ಬದಲಾವಣೆ ಎಲ್ಲಿದೆ?
We'll call for the registration of mega city 929. Once we get that certificate, if it is mega city, then there is a abuse of the process of court.
ಅಲ್ಲ ಈಗ ಬೇರೆ ಎಲ್ಲಾ ಕೇಸಸ್ ಎಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿದೆ. ಆಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವರ್ಗೂ ಹೋಗಿದೆ ಮ್ಯಾಟರ್ಸ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು ಇವಾಗ ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಸಿಷನ್ ಆಗಿದೆ.
ಏನಂತ?
ಸ್ಟೇ ಆಗಿದೆ.
ಏನ್ ಸ್ಟೇ?
ಸೇಮ್ ಕಬಡ್ಡಿ ಅಸೋಸಿಯೇಷನ್.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೊಡಿ.
ಅದೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್
ತಗೊಳ್ಳಿ. How has this got anything to do with this issue? There's a dispute between the federation and that's a different issue. Between party, there could be various litigations. This litigation has it gone to the Supreme Court. We'll get the certificate of 929. If the certificate is of mega city developers, then we'll dismiss this by imposing exemplary costs.
ಅಲ್ಲ ಇವಾಗ ನಮ್ದೇನಪ್ಪ ಕಂಪ್ಲೇಂಟ್ ಅಂತಂದ್ರೆ ಇವರು ಮೆಗಾ ಸಿಟಿ ಡೆವಲಪರ್ಸ್ ಅಂತಾನೆ ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇವತ್ತಿನವ್ರಿಗೆ ಇಲೆಕ್ಷನ್ ಮಾಡಿಲ್ಲ, ಅವರು ರಿನ್ಯೂವಲ್ ಆಗಿಲ್ಲ.
Election will direct them to consider your representation. You are only given a representation which will direct them to consider.
ಅಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್
ಏನು ಅಬ್ಜೆಕ್ಷನ್? ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ತೀರಾ?
ಹೌದು.
ನಿಮ್ ರಿಟ್ ಪಿಟಿಷನ್ ಗೆ?
ಹೌದು, ನಾವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಿದೀವಿ.
You will file
Allah,
objection.
after coming to know of the fact of,
You'll file objections to what? You are the
yeah,
petitioner.
that two registrations ಆಗಿದೆ ಅನ್ನೋದು ಒಂದು, ಎಲೆಕ್ಷನ್ ಆಗಿಲ್ಲ ಅನ್ನೋದು ಎರಡನೇದು.
ನೀವೇನ್ ಹೇಳ್ತಾರೆ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ಬೇಕು.
ಅಲ್ಲ, ಈ ಟೂ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿದೆ ತಪ್ಪು ಅಂತ ಅನ್ನೋದು ಒಂದು. ಎರಡನೇದೇನಪ್ಪಾ ಅಂತಂದ್ರೆ ಇಲೆಕ್ಷನ್ ಆಗಿಲ್ಲ, ಇಲೆಕ್ಷನ್ ಹೋಲ್ಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಅವ್ರಾಗ ಅವ್ರೆ ಆಸ್ ಪರ್ ದಿ ಬೈಲಾಸ್ ಓನ್ಲಿ ಮೈ ಲಾರ್ಡ್, ಪೇಜ್ 41 ಬೈಲಾಸ್ ಅನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ.
You are challenging this order now. That's all you have challenged.
Yes.
Don't expand the whole thing by your oral submissions.
Allah, I have raised.
We are concerned only with the prayers that have been sought for. On your oral submission, we can't expand the scope. Your only issue here is 929 has been misused and their double registration. As regards, that is what was considered in the impugned order. You are given representation, those are different. That is not considered in this order.
ಅಲ್ಲ, ಇದಕ್ಕೆ ಅವ್ರ ಆನ್ಸರ್ ಏನಿದೆ 100 ಪೇಜ್ 100ಗೆ ಹಾಗೂ ಸದರಿ ಸಂಘದ 22-23ನೇ ಸಾಲಿನ ಚುನಾವಣೆಯನ್ನು ಇಲಾಖೆಯ ಅಧಿಕಾರಿಯವರ ಸಮಕ್ಷಮದಲ್ಲಿ ನಡೆಸಿರುವುದು ಸಂಘದವರು ಸಲ್ಲಿಸಿರುವ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. After which, my lord, office bearers, my lord, they have been elected on their own without conducting elections.
Everybody to be made a party. Union of India.
My lord, this is not a necessary party, my lord. Union of India kindly.
They have made them party, so we'll have to issue notice.
Made them party,
want to
but,
file an application, delete
no
them.
role to play, my lord. Can they?
You are appearing for Union of India?
Yes.
The BMI accepts notice for respondent 1. You file an application for deletion. Amateur Kabaddi Federation of India. How are these people all making a party? They are not parties to that proceeding.
ಇದು ಯಾವುದಕ್ಕೂ ಅವರು ಯಾರಿಗೂ ಇದಿಲ್ಲ.
Mr. Gowley, this is a complete abuse of the process of court.
As far as
that is to annexure N.
ಹೌದು, ಅಧ್ಯಕ್ಷರು ಕಾರ್ಯದರ್ಶಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಅಮೆಚೂರ್.
Why are you making
ಕಬಡ್ಡಿ
Federation,
ಅಂತ ಇದೆ.
State of Karnataka, Commissioner, Registrar, everybody a party?
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಇವಾಗ ಆರ್ಡರ್ ಮಾಡಿರೋದು.
How is respond number 1 and respond number 2 relevant?
Later I will delete them.
We'll delete them now. What has been challenged is annexure N, which is an order passed by respondent number 6 or 5.
ಇಲ್ಲ, ಅದು
ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿ
6
on a complaint filed by the petitioner against respondent number 7.
Registrar is the highest authority, my lord. He may.
The Union of India was nowhere concerned with the said proceedings, nor was the Amateur Kabaddi Federation of India concerned with the said proceedings. Similarly, the Commissioner, State Youth Center, was also not a party to the said proceedings. Hence, the arraigning of respondent number 1, 2, and 4 is completely misconceived. Respondent number 1, 2, and 4 are deleted from the array of parties. And AGA accepts notice for respondent number 3, 5, and 6. Who accepts notice for 7 and 8?
7 and 8, Mr. Prasad has filed caveat. We will appear for 7 and 8 and explain that number was wrongly.
Accept notice for respondent number 7 and 8. Learned AGA is directed to place on record copies of the registration certificates bearing number 352 of 7475 and 928 of 0304.
929.
929 of 0304 by the next date of hearing. Released on 18th August. IA1 of 26 is allowed.
Serial number 9, Sampath Kumar.
Record for petitioner, madam. It's a writ of mandamus, madam. Not on the basis of the complaint filed by the my lord, petitioner, UDR was registered initially, my lord. Upon investigation, my lord, instead of my lord filing the charge sheet before the jurisdiction.
You want to file the final report and then you want to file a protest petition.
Please, my lord.
You're presuming both.
No. Already final report has been filed before the my lord Tahsildar. That is not correct, my lord. In view of the 173 subclass 2, my lord, it has to be filed before jurisdictional magistrate only.
Lordships may kindly
Because of which,
peruse
my
the
lord, I am
prayer
deprived of filing a.
194, my lord. This is unnatural death, my lord, UD.
Please, my lord.
That, my
174.
lord, under 194 BNSS, it has to be filed before the executive. Kindly see their prayer, my lord.
Not the same question, my lord, arisen before the my lord's Madras High
And
Court.
the final report has been filed?
Please, my lord.
Before whom has it
Before
been
the
filed?
executive, my lord. Kindly see page
That has to be submitted to
24,
the-
my lord, Taluk
24.
Magistrate.
It is filed before the my lord Taluk Magistrate.
They say, my lord, it ought to have been filed before the magistrate.
BNSS,
Kindly peruse 194 BNSS. Says in
Now there is a complaint filed of unnatural death.
Please,
You
my lord.
hold an inquest at 124,
Please, my
194. Now criminal proceedings have been registered.
Please, my lord. And they have filed the charge sheet saying that, my lord, kai bidalagide. They have closed the B report.
The
as
charge sheet will have to be filed before the court sees of the matter where the criminal complaint has been filed.
If it is pertaining to unnatural death, my lord, 194 says, my lord, it has to be before the executive.
Not the report.
That is
mentioned-
only for the purpose of conducting an inquiry and reporting on suicide. That's an inquest to be held. But the criminal proceedings are pending before the concerned court.
To file a protest petition.
You have to file the report there. Once a final report has
Please,
to be
my lord.
filed before the, it's not been committed, so it is before the magistrate. So the magistrate who is seized of the matter, you will have to file the report. Alva?
Please, my lord. May I read 194 again, my lord?
Not the
Procedures that a police officer must follow in learning of a death that involves a suspicious circumstances are outlined in section 194. This covers suicide so and so, as well as death that gives rise to plausible suspicion that someone else committed the crime. The in-charge police officer must notify the closest executive magistrate who is authorized to conduct inquest right away. This guarantees the matter is quickly brought to the attention of the higher authority, only for the inquest purpose. May I, my lord? If my lords may kindly see page 32, my lord, what they say.
Now, the report mentioned in that provision, my lord, that is only with respect to inquest report, not the final report.
Page 32. Yes.
Lord, what they say in this report, my lord, PM, second paragraph, my lord, PM ಮಾಡಿದ ವೈದ್ಯರು ಹಾಗೂ ವೈದ್ಯಕೀಯ ಮಂಡಳಿಯ ವೈದ್ಯ ಅಧಿಕಾರಿಗಳ ಅಂತಿಮ ಅಭಿಪ್ರಾಯದಿಂದಲೂ ಮೃತ ಸಂತೋಷ್ ಬಿನ್ ಸೋನ್ಸೋರ್ ಅವರು ಚಿಕಿತ್ಸೆಗೆ ದಾಖಲಾಗಿ ಚಿಕಿತ್ಸೆ ಫಲಕಾರಿಯಾಗದೆ ಡೆಂಗು ಲಕ್ಷಣದ ಜ್ವರದಿಂದ ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ ಹೊರತು ಸಂತೋಷ್ ಅವರು ಸಾವಿನಲ್ಲಿ ಯಾವುದೇ ವೈದ್ಯಕರ ನಿರ್ಲಕ್ಷ್ಯತೆ ಇಲ್ಲ ಎಂದು ದೃಢೀಕರಿಸಿದ ಮೇರೆಗೆ ಹಾಗೂ ತನಿಖೆಯಿಂದ ಡಾಕ್ಟರ್ ಮಧುಸೂದನ್ ಅವರು ನಿರ್ಲಕ್ಷ್ಯತೆ ಇಲ್ಲವೆಂದು ದೃಢಪಟ್ಟಿರುತ್ತಾರೆ. As such, my lord, they have filed this B report.
This is a report.
Please, my lord.
Nobody, it's for them to file a protest memo. But the crime number 22 of 23 has been registered.
22 part 22.
At Annexure B.
Please, my lord.
Lord, may I pass on one judgment, my lord? Similar question
The
was.
final report has to be filed in that proceedings.
My instructions were that, my lord, if it is death due to unnatural death, my lord, then my lord.
Yes, but if there's a complaint, what is their recourse then after that?
Please, my lord. Please, my lord.
They can only file a protest memo.
Please, my lord.
So it will have to be filed in judgment. Lord.
A similar question of the set of facts, my lord, arised before the, my lord, Madras High Court. Para number 4, my lords. Para number 4.
Para number.
Not where a first information report is registered under section 174 of CRPC. In the course of investigation, the police finds that no offense
Where
has
are
been
you
made out.
reading? The para number 4 is this court framed the following question.
Please, my lord, the point number 1, my lords, I'm reading. Point number 1. Where a first information report is registered under section 174 of CRPC, and in the course of investigation, the police finds that no offense has been made out, where should the final report be filed? In the instant case, it is found that the final report has been filed by the police before the revenue divisional officer Tanjavur. Now, the reasoning will commence from my lord, para 11. Para 11. The above discussion makes it clear as to what an inquest report is all about. It is this inquest report that is contemplated under section 174 subclass 2 of CRPC that is to be forwarded to the district magistrate or subdivisional magistrate. On the receipt of such inquest report from the police, section 174 subclass 4 independently empowers certain categories of magistrate to hold inquest. The legislature has thought it fit that it is necessary that inquest should also be conducted by an independent authority apart from the police. This power conferred under section 174 of CRPC is more in the nature of the fact-finding inquiry, and it does not have the characteristics of a judicial or quasi-judicial proceedings. The object of the inquiry is nothing more than to furnish materials on which action might be taken, and the report by itself given by such magistrate is more recommendatory, and it does not amount to a decision or determination of rights of parties. Such report ultimately will have to be submitted only to the police. This report will form the part of the materials collected by the police in the course of investigation. Ultimately, the police will have to independently investigate the case and file a final report after completion of the investigation under section 173 of CRPC. Then, para number 12. All the learned counsel appearing for the petitioners and also for the respective bar associations anonymously submitted that police have wrongly understood the term report used in section 174 subclass 2 of CRPC and has given it the meaning of a final report, whereas the meaning to be assigned to the said report is only the inquest report prepared by the police under section 174 subclass 1. It was also submitted that the purpose of inquest report prepared under section 174 subclass 1 of CRPC by executive magistrate is only to aid the investigation officer in the course of investigation. Therefore, it was submitted that a final report, whether it is positive report or a closure report, can be submitted by investigation officer only before the concerned jurisdictional magistrate under section 173 subclass 2 of CRPC. And my lord, based on this, my lord, a procedure was laid down by the Madras High Court. It commences from my lord, para 24. Para 24, my lord, point number I, very next page, my lord. The police on conclusion of the investigation shall file a final report under section 173 subclass 2 of CRPC only before the jurisdictional magistrate and not before the executive magistrate. This will apply in both cases where a final report is a positive report or it's a negative closure report. In the case at hand, my lord.
Yes.
Please.
And AG accepts notice for respondents. Petitioner is before this court seeking for the following reliefs. The one Santosh and expired on 9/12/23. A complaint had been lodged alleging that his death has been caused without properly administering the necessary medical treatment. On the basis of which UDR, unnatural death report in UDR, came to be registered in UDR number 22/2023 under section 174 of the Code of Civil Criminal Procedure. The inquest was carried out in terms of section 194 and a report was submitted on 10/12/23. However, the final report was not filed before the jurisdictional magistrate seized of the aforesaid criminal proceedings. It is in that background that the petitioner is before this court seeking for the aforesaid reliefs. The submission of learned counsel for the petitioner is that once a proceeding has been registered under section 174 and an inquiry is done under 194, 174 criminal procedure code. Idರಲ್ಲಿ
that is equivalent to 194 of BNS.
Under 194, 174 ಅಲ್ಲ, 194. The inquest being carried out by the executive magistrate would form the basis of a final report to be filed by the jurisdictional police upon investigation. The inquest report of the executive magistrate is not the final report. And on the, in support of his submission, he relies upon the decision of the Honorable Madras High Court in 2018 SEC Online Madras 14216. More particularly, para 4, 6, 8, 9, 10, 11, 12. And 24 thereof, which are reproduced here under reference. A period of the exhaustive and well-reasoned judgment of the Honorable Madras High Court would clearly indicate that though the said matter was in relating to section 174 of the Criminal Procedure Code, the very same reasons would equally apply to a proceedings under section 194 of the Bharatiya Nagarik Suraksha Sanhita 2023, in as much as section 174 and 194 are in pari materia with each other. The Honorable Madras High Court, after considering the said provision of section 174 in pari materia with 194, has held that the mandate is clear, requiring a police officer to forward a dead body with a view of it being examined to the nearest medical officer appointed on that behalf. Thereafter, an inquest report is required to be made by the inquest officer with respect to the apparent cause of death, which is to be prepared in the presence of 2 or more respectable inhabitants of the neighborhood. He has to describe the wounds, fractures, bruises, and other marks of injuries as are found on the dead body, etc. The information as regards a cognizable offence having been received, an FIR being registered, the inquest report conducted either before or after the FIR being registered would continue to be valid and the same would not be final in nature. The inquest report contemplated under 194 is to be forwarded to the district magistrate or the subdivision magistrate on receipt of the said inquest report from the police. Certain categories of magistrates can hold the inquest. The said report, said inquest report, the report of such magistrate, which is an inquest report, will form part of the materials collected by police in the course of investigation. Ultimately, the police will have to independently investigate the case and file a final report after completion of the investigation. After considering this aspects, the Honorable Madras High Court in para 24 extracted supra as answered the issue raised and laid down certain procedure to be followed by the executive magistrate as also the police officers. The same, though again referring to section 174, would be equally applicable to section 194 of the BNSS. In that view of the matter, the submission of learned AGA that under section 194, the report is to be only submitted to the executive magistrate and not before the judicial magistrate seized of the matter cannot be accepted. The report of the executive magistrate, as held by the Honorable Madras High Court, would form some of the documents collected during the course of investigation, a part of the documents collected during the course of investigation. On the basis of the said inquest report, the police, the investigating officer would have to file necessary final report before the court in the present matter seized of UDR number 22 of 2023. By following the due procedure.
Please.
In that view of the matter, this court passes the following order. Writ petitions allowed. The mandamus is issued directing the third respondent to complete the investigation and file the final report before the court seized of UDR number 22 of 23, that is the additional civil judge in JMFC Court, Sakleshpura. The Director General of Police is directed to forward a copy of the order passed by the Honorable Madras High Court, reported in 2018 SEC Online Madras 14216 to all investigating officers, along with a copy of this order, and file a compliance report within 4 weeks from today.
Yes.
Though the above matter is disposed, relist on 25th August for reporting compliance.
Deploy.
Serial number 10, Girish R.
For petitioner, general parole matter, my lord.
Parole AGA, released on 5th August.
11,
I prefer petitioner, same, my lord. Same.
Lord AGA, 5th August.
Also serial number 24, my lord. 24, serial number 24.
12 viewers.
Sorry.
Vidit Kumar,
12.
An order of externment, my lord. An order of externment.
Have been provided a hearing opportunity?
My lord, I have given my explanation. The except saying that your then explanation is samanjaswagilla anta ಹೇಳ್ಬಿಟ್ಟು.
Then you file an appeal.
The appeal is there. This case falls under the exception, Your Honor. This case also falls under the exception. I am permitted to argue.
An exception in it.
Section 60, which says that the
Police Act.
Any order passed under section 54, 55, 56 or by the government under section 59 shall not be called in question in any court, except on the ground that the authority making the order or any officer authorized by it had not followed the procedure laid down in subsection 1 of section 58, or that there was no material before the authority concerned upon which could have based its order, or on the ground that the said authority was not of the opinion that the witnesses were unwilling to come forward to give evidence in public against the person. Yes. Here it's a case, Your Honor. The accused is selling the refilling of the gas. The offense is under section 285.
Don't argue anything on merits. On procedure, you can argue. If any of these are not being followed, we'll consider it.
Yes, sir.
If on merit, then it will be appellate, statutory appellate.
Yes. Here, in all the cases, the complaint are the police.
That
So,
is
sumo
again,
gets registered.
again, you are going on merits.
No. Why I'm saying there is no question of tampering the witnesses, because the witnesses are the government officials or the police officers, and there is no.
That's not for this court to consider.
Not in the order they have to say. The
Except
order also they
notice
have to
for
say.
respond number 1 to 4. Petitioner is before this court seeking for the following leaves. What is being challenged is an order of externment passed under section 55 of the Karnataka Police Act 1963. Before the said order was passed, the petitioner was issued a notice and was given an opportunity to make his submissions. The explanation submitted by the petitioner has been considered, though not in favor of the petitioner. But in that view of the matter, the petitioner has a statutory appellate remedy in terms of section 59 of the Karnataka Police Act 1963, there being no violation of principle of natural justice, not there being any jurisdictional error, foundational jurisdictional error, requiring this court to exercise its powers under Article 226 and 227 of the Constitution of India. The writ petition stands dismissed, reserving liberty to the petitioner to avail of the statutory appellate remedy under section 59.
I have heard that many appeals are filed. In none of the cases, the interim applications are considered. At least in the event the application is filed, to consider.
Any interim application filed by the petitioner would necessarily have to be considered by the appellate authority in accordance with law.
13.
The government releases a routine non-technical consultation tender. Lordships may please take page number 18. Page number 18, my lords. It's providing third-party quality monitoring system services for the lake development within the limit of Bhadravati Taluk. This is classified as a least cost selection procedure. Point number 3, my lords.
Yes.
What this procedure means is whoever, my lords, gives the lowest estimated cost, he is entitled to get the tender. That is the mandate under the Karnataka public procurement rules. May I just pass over, my lords, the rules?
Yes.
Under section 28D, my lords, I have just highlighted the section 28D, my lords. Lordship may please take the last point, least cost selection. The consultant with the lowest evaluated price shall be selected. It is a positive mandate given to the government. Pursuant to this, my lords, Lordships may please take.
First is the technical qualification.
I have
thereafter the least.
Yes, my lords.
Yes.
I have qualified under the technical bid. Please take page number 19, my lords.
Yes.
For 3 bidders for this tender, one is Yunis Mrityunjaya and Santosh, who is the petitioner. Please take the next page, my lords. Page number 20. The estimated contract value, my lords, is 17,72,000. First tender, my lords, bids 17,770. Second tender, my lords, which is at page number 21, bids 17 lakhs 5,000. Third, my lords, is the petitioner's bid, 16 lakhs 99,000, which is, my lords, clearly the lowest amongst the bidders for this tender. I am, my lords, entitled to secure the letter of intent and the tender.
Yes.
After this, what happens is the government, my lords, cancels the entire tender. I have not been given any intimation, no cancellation letter, nothing. Please come to page number 30, my lords. Identical tender, my lords, for the same work came to be issued, my lords, last week, which is, my lords, page number 30, providing third-party quality monitoring system services for the lake development within the limits of Bhadravati Taluk. Same identical tender.
It might be uploaded in the portal, my lord, regarding, I'll seek instructions.
Your right to terminate or cancel this one is in terms of section 14. It's only restricted to section 14. You can't cancel the entire tender for any other reason than under 14.
Please.
The fact that you have reissued the tender, 14 will not apply. And AGA
Lord,
accepts
R2 has
notice
to answer.
for respond number 1. Shimoga Bhadravati Urban Development Authority,
AV Gangarappa.
AV Gangadharappa for respond number 2 and 3. Considering that after cancellation of the tender issued on 10/4/26, where the petitioner was the least
Lowest bidder, my lords, L1.
Was the lowest bidder. Another tender has been issued on 16/7/26 for the very same works on the very same conditions. The operation and further proceedings of the tender bearing number so and so dated 16/7/26 at Annexure D is stayed till the next date of hearing.
Highly grateful, my lords.
Counsel for the petitioner to furnish 2 sets of the petition on counsel for respond number 2 and 3 and file acknowledgement thereof with the registry by end of day 4th August, failing which the interim order will stand automatically.
Grateful, my lords. My lords, 17, my lords, instead of Bhadravati, it is Shumoga Taluk.
When 17 comes.
Yes, my lords, grateful.
Serial number 14.
Yes.
Petition is for defreezing the bank account. Petitioner resides
Defreezing the bank.
Please, my lords. Petitioner resides in Gujarat. She has her bank account in HDFC in Gujarat, my lords. An unknown person has filed a complaint before this SEN here in Bangalore, because of which they freezed it. From past 2 years, it's based on the complaint it's been sitting, my lords. There is no FIR file, reason being they had asked for additional documents
There's a
and the
command,
complaint.
cyber command help center which has been set up. You go on Thursday 30th.
Please.
To try and help you out.
Please.
And AGA for respond number 1 and 2. HDFC.
Francis Xavier.
To Francis Xavier for respond number 3. To approach cyber command on 30th, relist on 13th August.
15.
Complaint against fair price distribution agent, my lord. On the basis of the complaint, the inquiry was conducted by the respondent free office of the Tahsildar, and they gave a report saying that illegality and everything is taken.
And AGA for respond number 1 to 4. Issue notice to respond number 5, returnable by 7th September.
Please.
16.
Yes, Mr. Sharif.
I appear for question. I mean, seeking mandamus to consider representation. Right, the petitioner is an advocate, my lord. He went to the, on 12/7/26, went to the Tiptu Rural Police Station in connection with the complaint of his client, my lord. The sub-inspector, 5th respondent, my lord, he has manhandled him. In fact, he has pulled him out of the police station. So when I gave complaints to respondents 2 to 3, my lord. So far, they have not taken any action, my lord. I mean, they use a singular language, my lord, and the disrespectful manner he pulled out, my lord.
CCTV footage. Yes.
I'll secure the CCTV.
And AGA accepts notice for respond number
1 to 4.
1 to 5.
My 5 is in the capacity of made him police.
He is also a police inspector.
He is also a police inspector.
1 to 5. And AGA to secure instruction as regard the availability. The respondents are directed to preserve the CCTV footage of the Tiptu Rural Police Station recorded between 6 p.m. to 9 p.m. on 12/7/26 for a period of 2 years from now. The learned AGA is directed to secure instructions, secure the video footage for the said period and produce the same before this court by the next date of hearing. Relist on 18th August.
17.
17 is the same identical matter.
1 out 26 is allowed. Kodi.
Instead of Bhadravati here, it
The
is
dates
Shimoga
are
Taluk.
this.
Dates are also the same, my lords.
Dates are same. Tender number is different.
Highly grateful, my lords. Highly grateful.
18, Venkatesh P. Dalwai.
Is that why?
My lords, annexure B is impugned. Lord, the fine is imposed on the petitioner, my lords, without issuance of notice under the KPME Act, the Karnataka Private Medical Establishment Act. Lord, she is the owner of the premises. Here she has been let out to one Dr. Krishna. Lord, the provisions.
The owner of the premise.
Yes, it is not even applicable to me. Now, without notice to me, my lord, this 25,000 has been imposed on.
Not served with a copy, my lord.
Put it. Don't go.
GS served until the seal is.
I can give him one more copy.
And AGA accepts notice for the respondent. The claim of the petitioner is that the petitioner is the owner of the premises, which has been let out to one Dr. Krishna, and as such, no fine could have been levied by the respondent on the petitioner owner of the property for any default on part of the tenant. In that view of the matter, the operation of the order dated 25/6/26 passed by respondent in so and so at annexure B, he stayed till the next date of hearing. Counsel for the petition to furnish one more set of the petition along with annexures on the AGA, released on 19th August.
19, Murthy DL.
For the petitioner's matter, of mandamus, consider my representation as per annexure E series, my lord. The petitioner the allottees of the sites in respect of site survey number 94 of Gomala land, my lord, the Arkulgud Taluk, and the Tahsildar have issued a Kupatra.
Who are you?
Allottees, my lord. There are totally 6 petitioners here, my lord. Totally more than 30.
All of you are the allottees.
Yes, my lord. All are allottees, my lord.
And AGA accepts notice for respond number
kindly peruse the
1 to 4. Arkalgod Taluk Panchayat.
MS Devraju.
5 and 6. AGA for 7. Counsel for the petition to furnish 2 sets of the petition along with annexures on the said counsel.
Interim prayer is they have demolished my dwelling house more than 15 houses, my lord. It is disclosed at annexure D series, my lord, photographs without even issuing notice to the petitioners, my lord.
That is not what you challenged. You asked for only considering your representation department inquiry against the respondent.
Yes, my lord.
ಅದರಲ್ಲಿ ನೀವು ಇಂಥ interim relief ಹೆಂಗ್ ಕೇಳ್ತೀರಾ?
And they are trying to dispose of the petition from the
So you should have
possession.
asked for particular reliefs, not for department inquiry and then this relief. How is department inquiry concerned with this disposition?
Interim, in case of there is no interim stay, my lord, they have.
Your reliefs are not worded properly, Mr. Counsel. You're not challenging their action. We can't advise you. Application ಆಗ್ತೀರಾ amendment ಗೆ? ಯಾವಾಗ ಆಗ್ತೀರಾ?
3 days. Within 3 days.
Counsel for the petitioner
Next week, any date may be fixed.
a week's time to file necessary application.
Date may be
Released
fixed,
on
my lord.
4th August.
God bless.
Serial number 20, Vijeta Nayak.
Here for the petitioners, my lords.
Yes, madam.
My lords, impugned orders are order of the Assistant Commissioner invoking Section 23 of Senior Citizens Welfare and Maintenance Act, my lords. My lords, by way of invoking Section 23, the gift deed, the operative portion of the order may be seen. It is at page number 94 at Annexure F.
Page number?
94, Annexure F.
Yes.
My lords may kindly see, these are the details of the property. ಈ ದಾನಪತ್ರವನ್ನು last 4th line, ದಾನಪತ್ರವನ್ನು ರದ್ದುಪಡಿಸಲು ಹಿರಿಯ ಉಪನೋಂದಣಾಧಿಕಾರಿಗಳು ದಾವಣಗೆರೆ ಇವರಿಗೆ ಆದೇಶಿಸಿದೆ ಹಾಗೂ ಸದರಿ ವಿವಾದಿತ ಆಸ್ತಿ ಸದರಿ ದಾನಪತ್ರವನ್ನು ರದ್ದುಪಡಿಸಿದ ನಂತರ ಅರ್ಜಿದಾರರ ಪತಿಯಾದ ಲಿಯಾಜ್ ಅಹಮದ್ ಅಡ್ವಾನಿ ಬಿನ್ ಅಬ್ದುಲ್ ಇವರ ಎಲ್ಲ ನೈಜ ವಾರಸುದಾರರ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಲು ಆಯುಕ್ತರು ಮಹಾನಗರ ಪಾಲಿಕೆ ದಾವಣಗೆರೆಗೆ ಇವರಿಗೆ ಆದೇಶಿಸಿದೆ. My lords may kindly have the gift deed. It's at Annexure A. My lords, respondent 2 is the mother of the petitioner who has invoked the act claiming that the gift was fraudulently executed by her husband in favor of petitioner. It's my lords, respondent 2 is not the transferor of the property. It is the father of the petitioner who has in fact executed the gift deed in the year of 2017. She is nowhere a signatory. And also, my lords,
Accepts notice for respond number 1, issue notice to respond number 2, returnable by 8th September. Considering that respond number 2, who had approached respond number 1 under section 23 of the senior citizen so-and-so, was not the donor in the gift deed dated 18/5/2017, but the said gift deed was executed by the husband of respond number 2. The operation of the order dated 27/5/26 passed and so at annexure F, he stayed till the next date of hearing.
wait,
Process fee and copies to be furnished
my lords, the
by end of
direction is
29th July 26, failing which the interim order will stand automatically vacated.
there is a direction issued to the municipal corporation to.
Stated. No,
Please,
once it is stated,
wait.
everything is stated.
Wait.
21, Lata Paces.
This matter pertains to general parole.
Parole.
AGA for response 5th August.
22.
Pertaining to general parole.
AGA for response 5th August. See how many paroles are coming. That report has to come. We can't be having so many parole matters coming before this court.
One submission, my lord. This parole, my lord. Yeah, my lord. Kindly come to annexure D, my lord. My lord, there is. He has already filed a previous time the parole, my lord. In that, there is a direction has been given, my lord. To kindly come to page number 25, my lord.
Let him get instruction.
23.
AGA for response 5th
Premature
August.
release. Premature.
Premature release.
Please.
5th August.
24.
We've asked for them to submit a report. We'll see.
There are guidelines, my lord.
There are guidelines, but no guidelines are followed.
I'll
We
seek
asked you for the
instructions.
data also, how many applications received, how many were allowed, how many were rejected. It looks like everything is rejected.
I'll seek instructions in this particular.
It's 24.
Lata Shayan
For
Murthy.
petitioner, same.
AGA for response 5th August.
Much obliged.
25.
I appear for the petitioner, my lord, on 31/12/2023, page 21, a notice was issued to me as to why I should not be included in the Rowley list. It's page 21, my lord. Then I filed a writ petition and that was quashed by this honorable court. And that was crime number 87/23. And that was quashed by this honorable court. All further proceedings were also quashed. Then the charge sheet was filed and I have been acquitted. Not a single witness spoke against me.
That's the
No.
only complaint which is there. Only criminal proceedings. Only criminal proceedings was SC number.
My lord. Now again, on the same crime number in which I have been acquitted, notice is issued. It almost to contempt. This court
Annexure.
crashes, again they issued a notice.
Page number?
Page number 21 is the first notice, my lord. First notice, page number 21. 87/23, why I should not be included in this one, crime number. Then page 22 is the writ petition.
What has happened to 87?
87, so 307, etc. they are filed.
What has happened to 87?
I have been acquitted.
Acquitted.
I have been acquitted. Not a single witness has spoken to me. I have produced a judgment also, page 26.
Yes, madam.
Only one case is there.
No, that one I have been acquitted. Again, on the same crime number, I have been notice
The
is issued.
AGA accepts notice for respond number 1 to 3. Petitioner is before this court seeking for the following leaves. The petitioner is challenging the notice dated 16/7/26 at annexure D issued by respondent calling up the petitioner to show cause as to why the rowdy sheet shall not be, why a rowdy sheet shall not, why the name of the petitioner shall not be entered into rowdy sheet on account of the pendency of crime number 87 of 2021. The counsel for the petitioner submit that once earlier, when such a notice had been issued on 31/12/23, the petitioner had challenged the same before this court, and this court, while order dated 22nd July 2024, had quashed the said notice. His further submission is that crime number 87 of 2021 went to trial, and while the judgment dated 10 July 2025 in SC number 160 of 23, the petitioner has been acquitted in those proceedings. Thus, as on 16/7/26, there is no proceeding which is pending against the petitioner, and the police notice could not have been so issued. There can be no dispute as regard the submission made by learned counsel for the petitioner, inasmuch as once earlier, when such a notice had been issued, this court, a coordinate bench of this court, had quashed the said. Subsequently, the petitioner has been acquitted in the proceedings in 87 of 2021. There being no other criminal proceedings pending against the petitioner, there would be there's no question of opening or continuing a rowdy sheet in the name of the petitioner post the said acquittal in the sole criminal proceedings which were attributed to the petitioner. This is not a stray case which is coming up before this court several times. Proceedings which have been initiated. Proceedings on which basis the rowdy sheet is sought to be opened had already ended in an acquittal. It appears that the authority issuing the notice for opening or continuing a rowdy sheet is not aware of the status of the proceedings,
Yes.
resulting in unnecessary notices being issued. The Inspector General of Police, Police Computer Wing, is requested to look into the matter and make available the data
Dismissed.
of all the status of all the criminal proceedings
Yes.
arising out of any criminal crime registered against any particular person, including the proceedings before the magistrate and or the sessions court, appeal filed therefrom, proceedings under section 482 of the CRPC, now 529 of the BNSS,
Yes.
stay orders passed therein, etc. The Director General of Police is also directed to mandate that any officer issuing a notice for opening or continuing a rowdy sheet shall mandatorily state that he has verified the details of the pending proceedings from the said database, and only after being convinced that there are proceedings which are pending to issue such a notice.
Yes.
In the present matter, coming back to the present matter, the notice dated 16/7/26 at Annexure D has been issued without verification of the fact that crime number 87 of 2021 had ended in acquittal. This court passes the following order. Writ petition is allowed. A certiorari is issued. The notice dated 16/7/26 issued by third respondent at Annexure D is quashed. Though the above matter is exposed, released on 25th August at 2:30 p.m. for reporting compliance.
Interim.
We have quashed the matter.
Sorry.
Aವಾಗಿಂದ ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಿ?
Sorry. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರ್.
I have instructed R3 my lord to look into.
Yes.
Serial number 26, Dhananjay Kumar.
Yes.
My lords, for the petitioner, the case of custodial death, my lords. Petitioners are the mother and sister of the deceased, my lords, who has been murdered in the judicial custody at the Central Prison, Madikeri, being stabbed with a knife by one of the under trial prisoner, Rajesh LS.
He's been murdered?
Yes, my lords.
Has any case been registered, madam?
My lords, in the earlier...
Yes, my lord.
What is the status of investigation?
My lords, and in the earlier occasion, the same under trial prisoner had murdered one of the petitioner's family member in 2022. And the petitioner, they had given several representation with regard to that also, my lords. So they have not considered police departments.
Which is the crime number which has been registered?
There are several. My lords, in this regard, kindly peruse annexure F1, my lords. Crime number 98.
98. Find out what is the status of
My
investigation.
lord, against two jailers, my lord, suspension order is issued, my lord. My lords may kindly peruse this.
Sorry?
I beg your pardon.
What is the status of final report has been filed?
The concerned persons who were in the jail, my lord, departmental inquiry will be initiated. That is my instruction.
What about the final report in this matter, madam?
That, my lord, I'll place it, my lord.
That final report will say who is all responsible.
Please, my lord. Lord,
This has been registered.
DIG has personally looked into this matter. That is my instructions, my lord.
This has been registered on 1/6/26.
1/6.
DG,
Knife was supplied inside the prison, my lords. Knife was supplied by the prison authorities.
please, my lord.
Supplied by the prison authorities.
Yes, my lords. Colluding with the Rajesh, the murderer's family. They had some civil animosities, my lords.
Director General of Prisons has personally looked into this matter, my lord, and they have suspended two jailers. That apart, my lord, departmental inquiries will be initiated against the other persons who were in the prisons, my lord.
Once this final report is done, then you
Please,
know who are all responsible against whom. You have to initiate department inquiry. Now, we have observed that in other matter also.
Please, my lord.
Before the final report is done, you do a department inquiry, give him one increment less and one promotion less. And then they come and say that department inquiry is over, no criminal proceedings can be initiated.
Please, my lord.
So if you are serious about it, your criminal investigation has to be completed first and then the department inquiry.
I'll seek instructions in that regard.
My lords, we have an interim prayer for securing the CCTV footage, my lords.
We'll do that. And AG accepts notice for respond number 1 to 8. And AG is direct secure instruction. Make a submission as regards the status of investigation in crime number 98 of 26, registered by the Madikeri Rural Police Station on 1/6/2026. What is the date of the occurrence?
On 1/6/2026 itself, this incident happened, my lords.
The
1-3.
sixth respondent shall ensure that the CCTV footage of which jail is this?
Srimangala Police Station.
This is in the prison, you said.
This is in the prison, my lord.
Police station in it.
So the petitioners had filed an RTA also, my lords, with regards to the CCTV footage of police station. And even with the prison, if your lordship can permit. Petitioners along with the
Central Prison Madikeri from 25/5/26 to the incident occurred on 1 and then 6 and thereafter. So, to 5th June 2026. As also to keep a separate backup of the said recording
Please.
to be produced before this court if as and when ordered. This court or any other court as and when ordered. Now, AG is direct secure instructions and make a submission as regards the status of the investigation and when the investigation will be complete.
Lordship, One submission. CCTV footage of the police station is also required.
Police station,
because the petitioners along with the deceased were arrested together on this date, my lords. They went to file a complaint against the private accused, my lords, the family members of under trial prisoner. Instead of lodging a complaint, they arrested the petitioners and as well as the deceased, my lords, on 26th 5/2026, my lords.
On? When was that?
26/5/2026, my lords.
The sixth respondent is also directed to secure and preserve the CCTV footage of the Sri Mangala police station for 26/5/2026. So you went to give details as regards the imminent threat. You were already knowledgeable about this threat on 26/5.
Complaint discloses, my lords. They knew that there was a dispute, mutual enmity between the deceased and the murderer, my lords. Despite that, they left them in the mutual common area, my lords.
Released on 19th August.
27.
Please.
Here for the petition challenging the proceedings before the SCST commission, my lord. Lord, complaint at ink page number 21, my lord, annexure B. Repeated to read, my lord. 21, annexure B, my lord. ವಿಷಯ ಜಾಲ ಹೋಬಳಿ ಕಾಡಿಗಾನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 67ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 8 ಎಕರೆ 20 ಗುಂಟೆ ಸರ್ಕಾರಿ ಗೋಮಾಳ ಜಮೀನು ಆಗಿದ್ದು, ಇದನ್ನು ಕಬಳಿಸಲು ಪ್ರಯತ್ನಿಸುತ್ತಿರುವ ಮತ್ತು ಇದೇ ಸ್ವತ್ತಿನ ಸಂಖ್ಯೆ 240 ದಲಿತ ಕುಟುಂಬನಾದ ನನ್ನ ಸ್ವಯಾರ್ಜಿತ 3045 ಅಳತೆಯುಳ್ಳ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನ ಇರುತ್ತೇನೆ. ಈ ಸ್ವತ್ತಿಗೆ ತೊಂದರೆ ಕೊಡುತ್ತಿರುವ ಹುತ್ನಳ್ಳಿ ದೊಡ್ಡ ಬಸವರಾಜು ಮತ್ತು ಅವರ ಮಗ ಮಂಜುನಾಥ್ ರವರ ವಿರುದ್ಧ ದೂರು. ಲಾರ್ಡ್, ಇನ್ ಫ್ಯಾಕ್ಟ್ my lord, we filed suit for injunction. There is a status quo order. He filed suit for declaration. There is no interim order granted.
They also know they have suffered orders.
Notice for one.
AGI accepts notice for respond number 1. Where is Mr. AC Manjunath?
My lord, AC Manjunath has resigned.
He has resigned.
Is resigned.
So who is the standing counsel now?
I don't have. I'll personally.
Sri K. Chandramohan is directed to accept notice for respond number 2. Issue notice to respond number 3 returnable by 24th August. Considering that the complaint which had been filed by respond number 3 before respond number 2 is as regards a property dispute, respond number 2 did not have jurisdiction to either take cognizance of the complaint and or proceed to pass orders. Orders pass madilla.
Orders pass madilla. Proceedings is pending, my lord. They have sought reports from the Tahsildar, executive officer.
And thereafter seek for reports. The further proceedings in case number Jaminu/138/2026, depending on the file of the second respondent, is stayed till the next date of hearing. They also have this classification, Jaminu. Case number Jaminu. That itself indicates it's a civil dispute. The second respondent is also directed to place on record the nature and classification of cases registered by the respondent. Number 2. Furnished by end of day 29th July, failing which the interim order will stand automatically vacated.
Please. Chandramohan, I'll seek the details of the Chandramohan. Then
you serve it on him.
28.
My lord says AGA for respondent 5th August.
29.
Serial number 25, my lord.
29.
Party is different, my lord.
So
Only
same
party is
well, the
different.
facts will be different, Mr. Attiga.
No, same, my lord.
Same, under the same crime number.
Same crime number, everything same, my lord. There also a writ petition is there. Absolutely no difference. Only the party is different.
Writ petition number Writ petition number is 15445 of 24. SC number 160 of dates are all the same. Yes.
Everything same.
30. Yes, Balakrishnan.
Lordships, we are for the petitioners in this matter, Lordships, we are challenging the C summary report that was filed by the fourth respondent that your Lordships gets at Annexure C, your Lordships, the pages at 24 and 27, and your Lordships to transfer the investigation to any other investigating agency apart from respondent number 4 is our prayer sought, your Lordships. The crux of the crux of the matter is this, your Lordships. On 1/3/2017, your Lordships, when I was in the office, I was attacked by two assailants, your Lordships. And on the same day, I was admitted and 12 sutures were put on me, your Lordships. On the next day itself, I go and register a complaint before respondent number 4, your Lordships. And the FIR was also registered under crime number 30 of 2017, your Lordships. And the reason why the C summary report or the case was closed, your Lordships, gets it at page number 27, your Lordships. If I may read the last para, your Lordships. ಈ ಪ್ರಕರಣದ ತನಿಖೆ ಕಾಲದಲ್ಲಿ ನಾನು ಮತ್ತು ಸಿಬ್ಬಂದಿಯವರು ಹರಿನಾಥ್ ರೆಡ್ಡಿ ಮತ್ತು ಅದಿನಾರಾಯಣ ರವರುಗಳು ಸಹಚರರನ್ನು ಪತ್ತೆ ಮಾಡಲು ಎಲ್ಲಾ ರೀತಿಯ ಪ್ರಾಮಾಣಿಕ ಪ್ರಯತ್ನ ಮಾಡಿದ್ದು ಆರೋಪಿಗಳು ಪತ್ತೆಯಾಗುವ ಸಾಧ್ಯತೆ ತುಂಬಾ ಕಡಿಮೆ ಇರುತ್ತದೆ. This is the reason why the C report was closed, your Lordships. My further statement was recorded, CDR was collected, everything was done, your Lordships. And in the fag end, they filed C report, your Lordships. After our persistent follow-up also, your Lordships, they kept telling that the investigation is going on, they will file the charge sheet, your Lordships. If they file the assailant, your Lordships, we really feel that there is some kind of high influence made by the assailants with the police officers, your Lordships.
Yes, madam. And AG accepts notice for respond number 1 to 5.
2019, my lord.
Please, your Lordships.
Now they have.
When was this closed?
2019, your Lordships.
Why have you come now?
Your Lordships, every time when we were following it up, your Lordships, the only thing is that investigation is going
After the C report
on.
has been filed in 2019.
Your Lordships, they kept telling us that the investigation is charge sheet C report is not final, your Lordships. We were not aware until and unless we met an advocate that we had another remedy available under the law, your Lordships.
From 2017 for 9 years you have been keeping quiet.
2019 it was filed, your Lordships.
Your complaint was 2/3/2017.
Please, your Lordships. If you may observe the page number 8 also, your Lordships, the serious allegations on the assailants, your Lordships. I was assaulted. They even say that they have collected the weapons were seized, your Lordships. The spot measure was conducted, but no investigation is done at all, your Lordships. There is a delay, agreed, your Lordships, but it is a genuine delay on our part, your Lordships. I was really not aware that I had any other remedy available once a C report has been filed.
This was registered on 2/3/2017.
Please, your Lordships.
And now you are coming and saying that C report which has been filed.
Please, your Lordships, was really not aware, your Lordships. If your Lordships is not convinced,
they won't have the
What will you
backup
get
for
now
so
after
many
9?
days.
Lordships, if I may, I think I've failed to convince your Lordships. Kindly give me a short accommodation. your Lordships.
You are not failed in convincing us. You have made your best attempts. But after 9 years, what investigation can be done? CCTV won't be available. Nothing will be available.
But they have not made any attempt to collect the
Can you
CCTV footage.
do that after 9 years? Your client has slept over it without looking at it in a proper manner.
Please, your Lordships.
It's a mistake. Can't do this.
Pray for a short accommodation, your Lordships.
AG accepts notice for respond number 1 to 5. Counsel for the petitioner seeks for a short accommodation. But next time your senior will not come, you will come.
Please, your Lordships.
Don't get your senior.
Please, your Lordships.
We'll remember the facts. Relist on 19th August.
Grateful, Your Lordships.
31, Umesh DN.
Seeking for writ of mandamus direction to the respondent, my lords, to consider the representation for releasing the service benefits of the petitioners. Next year, email page 10.
LIC error.
Sir K. Rajshekar.
Sri K. Rajshekar is direct to accept notice for respondent. Counsel for the petition to serve 2 sets of the petition for on the said counsel. Relist on 19th August.
Please.
32, Surambad.
For petition, club case. Club case.
Yes. Yavat is the club case.
17-8.
17.
And AGA for respondent 17-8.
Well, till that interim order may be granted.
Interim order so and
Third
so.
order.
Third, yes.
33, Ritesh Vinayak.
Yes.
Petitioner is seeking transfer of authorization on compassionate ground. The impugned endorsement is at Annex of page 21, my lord. The petitioner application has been rejected on the ground that the license holder is aged at the age of 74 years.
And AGA for respondent number 1 to 3.
Annex H, your lordship.
Petitioner is before this court seeking for the following relief. The petitioner's father was given authorization to run a fair price depot at Sante Maidana Road, Kote, Kunigal Taluk, Tumkur district. Which has been renewed from time to time. The last of the renewal being on 1/1/2025, valid up to 31/12/2029. Unfortunately, the father of the petitioner expired on 6/6/26, leaving behind his wife and 4 children, including the petitioner. The mother and other children, other siblings of the petitioner have no objection for transfer of the authorization in favor of the petitioner. Hence, the petitioner made an application for transfer of the authorization on compassionate basis. The said application came to be rejected on the ground that the authorization holder was 74 years as on the date of his death, date of his expiry. And as such, the transfer could not be done on compassionate basis. It is challenging the same, the petitioner is before this court. This court in a catena of decisions has categorically held that it is the age of the transferee which is required to be considered and not the age of the authorization holder. In the present case, the transferee is 35 years as on the date of the application, well within the upper limit of 65 years. Hence, the respondents could not have rejected the application for transfer on the ground that the authorization holder was above 65 years of age. In that view of the matter, this court passes the following order. Writ petition is allowed. Tertiary is issued. The order bearing number so and so dated 17/7/26 at Annex F is quashed. A mandamus is issued directing the respondents to consider the application of the transfer of the authorization for the aforesaid fair price depot in terms of the directions, the observation made supra. Needless to say, the petitioner would have to comply with all other formalities, including submission of necessary no objection from the other family members. Within 60 days.
34, Arjan. 35, Ravishankar, yes.
Petition seeking mandamus. Annexure A is the order passed by Tahsildar granting allocation of venue for the performance of puja in. The Annexure A is the order passed by second respondent.
What does the order say?
Order says that the time was fixed on the first petition was fixed to 3 months from July 1 to September. And the second petition was
Respondent number 4 notice ಹೋಗ್ಬೇಕಲ್ಲಪ್ಪ.
ಅವ್ರಿಗೆ they have filed a KV. ಅವ್ರ tenure ಬರೋದು ಆಮೇಲೆ ಅವ್ರಿಗೆ subsequent to that.
And AG accepts notice for respondent number 1 to 3. The K. Murthy, who has filed KV, is directed to accept notice for respondent number 4. None appears for respondent number 4. Petitioner is before this court seeking for the following reliefs. The respondent number 3, having considered the claims of various persons, had designated the period in which each of them would offer puja as a archak at the Yao temple, Sri Basveshwara temple, Manikyapura village, Yalwala Obli, Mysore Taluk, Mysore district. The grievance of the petitioner is that the said order of the Tahsildar had not been implemented, and it is in that background that the petitioner had submitted a representation on 7/7/26, while Annexure B, which has also not been acted upon. Whenever any officer of the state were to pass an order, it is required for the corresponding officer to implement the same within a reasonable period of time. In the present matter, the order of the Tahsildar not having been implemented, the petitioner had submitted a representation on 7/7/26, which has also not been acted upon. Hence, this court passes the following order. Writ petition is allowed. A mandamus is issued directing third respondent to consider the representation dated 7/7.
Yes, enforce the order, yes, yeah, hand over the.
7/7/26 at Annexure B and enforce the order bearing number so and so dated 1/6/26 at Annexure A, unless there is any order of stay of the said order dated 1/6/2026 within a period of 1 week from date of receipt of copy. Grateful.
36, Akash VT.
Hearing on behalf of the petitioner, my lords. In this petition, I'm seeking a writ of mandamus as against the petitioner's name's inclusion in the central fraud registry, my lords. My lords, I had availed. The petitioner is a company which is involved in construction activities, my lords. I had availed a loan of rupees 2 crore 50 lakhs from respondent number 3 bank, my lords. My lords, during the period of COVID crisis, there was a little bit of default from the petitioner's end. However, after the crisis came to an end, I have made the complete payment on 31/3/2021, and the
Him has been there from that time.
bank has even issued a
Union of India Finance. Sri Shanti Bhushan DSGI is directed to accept notice for respondent number 1. Sri Pradeep Savkar is directed to accept notice for respondent number 2. Indian Overseas Bank.
MS Venugopal.
MS Venugopal for respondent number 3. Counsel for the petitioner to furnish 2 sets of the petition along with annexures and said counsels.
If I may make only one submission, my lords. My lords, this inclusion of my name into the fraud registry is directly in contravention with the RBI guidelines itself. And SBI versus.
Coming to this court after 4 years.
My lords, I've issued representations
You're
continuously.
Not willing to wait for 4 weeks?
My lords, I'm just making my submission.
Relist on 19th August.
I'm grateful.
37, Kumar Akeji.
In this case, my lords, mother wants to change the children name in her caste, my lords. Father caste is, my lords, Adi Karnataka. Lords, mother.
Where is the father?
Lords, they are living separately.
Living separately and divorce ಆಗಿದೆಯಾ? What has happened?
Divorce ಆಗಿಲ್ಲ, divorce ಹಾಕಿದ್ದಾರೆ, but
where the divorce decree?
Decree ಆಗಿಲ್ಲ, my lords, they have filed the divorce petition.
You have to make the father a party.
I'll make it.
And AG accepts notice for respondent number 1 and 2.
Gautam Devullal. Gautam Devullal. Caste certificate.
Caste certificate. Gautam Devullal, Jagdisha.
Brother. Any one of them.
Gautam is also on the panel. Sri Gautam Devullal is directed to accept notice for respondent number 1 and 2. Counsel for the petitioner seeks for and is granted a week's time to file necessary application to impede the father as a party respondent. Released on 6th August.
Yes.
Serial number 38, Arjun. 39, Nishant Devi.
39 is that gigs worker. We have for the petitioner. It's that gig workers rules which are under challenge. This has to be tagged along with the main matter.
Same order, Kodi. And AGA for respond number 1, 2, 3. Union of India is not a party.
No, ma'am.
The order copy.
E-quota, sir.
The list in the above matter is drawing the attention of this court, of a coordinate bench of this court in WP number 19746 of 26. The coordinate bench of this court had passed an interim order dated 3/7/26. The benefit of the said interim order would be equally applicable and available to the petitioner in the present matter. However, the date for compliance shall be calculated from the date of, from today, this order, I mean, from today, when this order has been passed. Connect the above matter with WP number 19746 of 2026.
May I make one request, minutes? The cause title, the name of the petitioner in the website as well as in the cause list is wrongly printed.
Registry is directed to correct the name of the petitioner in the cause list as also on the website.
Great.
As per the cause title filed.
I'm grateful.
40. Sukanya HD.
Ms. Sukanya? It's registration of
FIR, my lord.
cognizable offense ಏನು?
Cheating case, my lord, and cheating and blackmail ಅಂತ complaint ಹೇಳಿದ್ದಾರೆ. We'll look into it, my lord, because it's given to DJ IGP, my lord, not to the jurisdiction of police. I'll just check the status, my lord.
Record your submission.
Yes.
None appears for the petitioner. None appears for the petitioner. Sir, notice ಹೋಗಿಲ್ಲ. And AG accepts notice for respond number 1 to 5. Issue notice to respond number 6 to 8, returnable by 9th September.
41. Yes, Rajshekar.
Lord, in this case, my lord, that WP, my lord, 2983
ಯಾವುದು?
is not 41 serial number.
41.
My lord, it is connected with W2, WP 7294. Lord, there is no connection between both these matter.
There's nothing which has been connected here.
42, sir. 42.
42. 42 ಅದು ಇರ್ರಿ. Wait,
connected.
Wait. We are in 41 now.
41, my lord.
Yes.
Regarding defreezement of, my lord, sir.
Defreezing.
Matter, my lord, initially 5 FIRs, my lord, came to be registered. Subsequently, my lord,
All of them have been quashed.
all the criminal cases have been quashed, my lord.
There's one complaint I'm told which is still pending. Crime number 99 of 2025.
Not 99, my lord.
Cyber command they'll sort it out, or?
No, my lord. I'll have to find out what the disputed amount is.
And
Could you also
DGA
pass it over, my
accepts
lord?
notice for respondent.
Please.
Pass over.
Final hearing, serial number 42. Pradeep Nayak, unconnected matter.
I am for the petition in this matter. This connected matter 42.1 is nowhere connected to the 42 mailer. Therefore, I request your lordship, it may be.
It indicates about the impleading in that writ petition.
But that will see, first we have to get it disconnected with the
Matter.
WP 29.
If all of you speak, we won't understand. What is your submission, Mr. Gide?
My lord, there is an IA number 1/24.
Yes.
It is filed by me to implead in this writ petition number 7294.
What do you have to say about both of them being connected or not?
No connected.
They're saying it's not connected. So why did they?
Subject matter is different.
Why did they get connected?
It is wrongly connected.
Wrongly connected.
Put the order sheet.
2983 first matter belongs to the PTCL.
Idu connected aidu 7294 of 2024. This is nowhere connected to each. This is a PTCL.
PTCL.
This is PTCL. This is my lord, first matter is connected to PTCL Act, my lord.
7294.
Connected to PTCL, my lord. Transfer of property.
7294 is relating to the cooperative society.
How did they get connected?
7294 is late. I have challenged the rule for
ಅದು ಅವ್ರದ್ದು
of the
ಒಂದು ನಿಮಿಷ ಅವ್ರ
Along with connected.
My humble submission, my lord, both are independent writ petition.
They got connected. When did they get connected?
Long back by mistake, my lord. By oversight it is connected. I request to de-link the.
ಅದಿದೆ ಬಟ್ ಕನೆಕ್ಷನ್ ಯಾವಾಗಾಯ್ತು?
The office note, there is a general order cell.
ಇದೆ. First date. Along with 7294 of 24. On 8/11/24, somebody has made a submission to connect with 7294.
No, by mistake, my lord. There is maybe some other cases. It is not connected to the first matter.
2983 belongs to PTCL, my lord. First matter, 42.
ಅದರಲ್ಲೇ ಇದು ಕನೆಕ್ಟ್ ಮಾಡಿರೋದು. Both the council, all the councils.
All the council.
Submit that WP number 2983 of 2008 and WP number 7294 of 24 are not connected to each other. And the order dated 8/11/24 passed by a coordinate bench directing 7294 of 24 to be posted along with 2983 of 2008 is apparently a mistake. In that view of the matter, WP number 2983 of 2008 is disconnected from dealing from WP number 7294 of 2024.
And one submission, it has to go to the roster bench,
Roster
29.
Sorry.
Sorry.
Registrar Judicial is directed to accordingly do the needful, since there is a special order which had been passed.
Please.
Much obliged.
Date may be given.
We can't give a date for that bench. First ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ.
ಅಲ್ಲ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇವರು ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇಲ್ಲಿದೆ
72 relist WP 7294 of 24 on 19th 24 ನಮ್ದೇ ಅಲ್ವಾ? On 19th August.
9th or 18th or 20th, my lord.
20th August.
Serial number 43, MJ Alva.
Petitioner, please second respond.
Yes.
The-
Ready?
I may be permitted to file a statement of objection, my lord.
ಇವಾಗ you file.
Yes.
Have you served a copy on everybody?
Not yet. I'll serve.
And AGA has filed a statement of objection. The same is taken on record. Copy thereof is served on the counsel for the petitioner and the other respondents. Harishchandra, what about you? You have filed your.
Pardon, man?
You have filed your.
I already filed.
You have already filed.
Please.
Mr. Varaprasad,
Is well, I also filed that.
you have filed a impleading application.
Impleading application as well as I also filed application for that. He is the proposed Pujari, my lord. Next, he has been referred to the.
Any objection to the IA? So,
Aspiring to become the acceptor. I filed the detailed application.
so IA 2, we can take it along with the main. IA 2 of 25 shall be considered along with the main. When will you get ready?
Shorter completion.
We list on 19th August.
B group matters, serial number 44 adjourned, 45. Pratisha KB.
Number 6. For R2. Only 2 weeks, filed my objection. R6.
I appear for the fourth respondent.
Mr. Satisha. Mr. Chandramohan. ಇವ್ರದ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ತಗೊಳ್ಳಿ ಫೋನ್ ನಂಬರ್
ಕೊಟ್ಟಿದ್ದೀವಿ
ಕೊಟ್ಟಿದ್ದೀವಿ
ಮ್ಯಾಮ್.
So you will have to appear in several matters.
Okay.
We have issued several directions for you to file affidavits.
Yeah, madam.
Because
14
this
and
commission
12.
is taking cognizance of matters which it cannot
We will
and
file.
passing orders which it cannot. So file affidavits of the member secretary. This is also again the same thing. How can the commission direct removal of boundaries, carrying out advastu and affecting the kata? Satisha is not here. None appears to the petitioner. Released on 19th August, interim order earlier granted is extended till next date of hearing. Learned counsel for respond number 2 is direct to file the affidavit of the member secretary of respond number 2 indicating the provision under which jurisdiction has been excised by the second respondent in the present matter.
46, CH Virupakshaya.
PB Patil. इधर है पास हो
47, KG Sadashivaya.
Appear for respondent 3 and 4, Your Honor.
yes ready
Kindly,
hmm
kindly 2 weeks time may be granted, Your Honor. We have
2 weeks
informed
for
them.
what reason, madam? For what reason?
You have to approach the parties and you have to.
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಏನಕ್ಕೆ ಬೇಕು ಅರ್ಜೆಂಟ್
ಅವ್ರ ಪಾರ್ಟಿ ಜೊತೆ ಮಾತಾಡಿ ಏನು ಮಾತಾಡೋದಿದೆ ಅಂತಿದ್ರು ಸೀನಿಯರ್, ಅದಕ್ಕೆ 2 ವಾರ ಟೈಮ್ ತಗೊಳ್ಳಿ ಅಂತ. It's have to get the instruction from the parents.
counsel for respond number 3 and 4 seeks for and is granted 2 weeks time to get ready and address arguments. Relist on 19th August. If arguments are not advanced by respond number 3 on that 3 and 4 on that date, the matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner. Interim order earlier granted is extended till next date of hearing.
48,
Much obliged.
Pawan Chandra Shetty.
Forty-three, interim order earlier granted is extended till next date. 48.
I appear for the R6
Yes.
in this matter.
Last date of order, your lordship may kindly peruse me.
Proposal has been received from the state government.
Yes,
Will be
now
considered given 2
proposal
weeks time.
received by the central government to state, my lord.
Now, they have served with the draft proposal, my lord, where they are telling to you few documents from our side to the central government for final approval of the management plan. That has to be given, my lord.
So when will you give?
My lord, it is only received recently, my lord.
What recently andre yavaga? We have recorded on 8/7/26.
Within 2 weeks, within 3 weeks, my lord, there are so many documents, my lord, which has to be given.
Counsel for respond number 5 submit that all the necessary documents would be furnished to the concerned authority within 3 weeks.
3 weeks, my
From now.
lord. They have given 45 days, my lord, time.
45 days ಕೊಟ್ಟಿದ್ದಾರೆ.
45 days ಕೊಟ್ಟಿದ್ದಾರೆ.
45 days ಯಾವಾಗ ಎಕ್ಸ್ಪೈರ್ ಆಗುತ್ತೆ?
My lord, ಇನ್ನು ರೀಸೆಂಟ್ ಅಂದ್ರೆ 14/7/2026 ಇದೆ. ಅವರು ಇದಾಗಿರೋದು ರೀಚ್ ಆಗಿರೋದು ಯಾವತ್ತು ಅಂತ ಐಡಿಯಾ.
8/7 we have recorded it, Prashant.
My lord, ಅದಾದ್ಮೇಲೆ then it has come, my lord, to our this.
ಇಲ್ಲಿ 45 days ಯಾವಾಗಪ್ಪ? 12th ಇಂದ
14th ಇಂದ
14/7 ಇಂದ. So by end of August,
please,
will be furnished within the time frame prescribed in the demand made by respond number 6, that is by 31st August. Relist on 21st September.
Please,
Your lordship, on submission, we have filed a memo to the same effect, showing that the approval has been given by the central government.
Approval has been
Given by the central government subject to the.
You are not given the
Draft
approval.
approval.
You
My
have
lord,
asked for some documents.
ಅದೇ draft approval, that is the one they are talking about.
I disconnect ago.
Lord, approval has been done by the, my lord, honorable central government. Now, my lord, only, my lord, MSL has to take the decision with respect to the same.
Provisional subject to the document.
Document.
These documents will have to be considered and final approval to be given.
Last week,
ಅವ್ರಿಗೂ ಒಂದು 2 weeks time ಬೇಕಲ್ಲ ಅದಾದ್ಮೇಲೆ.
August last week.
August last week they will furnish. September last week we are having it. 21st September.
Please.
49, Vinod Kumar.
Vinod?
My lord, I am for the petitioner, my lord. My lord, short accommodation, my lord. Need to secure few documents.
For respondent number 4, my lords, I have
Readings
filed
are
my
complete?
Lords,
Readings are complete?
yes, my lords, I have filed objections.
Readings are complete. Counsel for the petition seeks for a short accommodation. Released on 24th August. Interim order earlier granted is extended till next date of hearing.
Date may be given, my lords, because, my lords, what the annexure K, they have challenged, my lords. That annexure K itself is not there, my lords. I have taken the document through the RTA, my lords, wherein, my lords, the date itself is wrong. And, my lords, the contents of the document is also, my lords, not forthcoming in my document, which I, my lords, have brought under the RTA.
He has not given you the documents? Or?
No, they have given, my lords. I have taken the, my lords, through the RTA, that the same very document. My lords, the date of the document is different, which they have challenged.
Yeah, the documents we can direct. Yeah, adjourning the matter because he
Yes,
wants
yes,
time.
that's why, my lords, my date may be fixed, my lords.
24th August.
Yes, yes.
Much obliged.
Serial number 50. Kalyana.
Lord, the
State
petitioner is,
Tourism Development Corporation.
Lord, it is wrongly mentioned cooperation. It should have been corporation. The cost title.
Corporation.
Corporation.
What do you?
Lord, writ of mandamus.
What,
My lord,
have you, what is the petition is proper? ನೀವು ಕೋಆಪರೇಷನ್ ಅಂತಾನೆ ಹಾಕಿದೀರಾ
ಅಲ್ಲ ನಾನು ಹಾಕಿರೋದು ನಂದೇ ತಪ್ಪಿದೆ ಅಂತ
ಸೊ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಬೇಕಲ್ಲ
I'll do it. I'm permitted.
For the petitioner seeks for a week's time to file necessary application to him to amend the names of the respondents. Sidraju M. You appear for Tourism Development Corporation. Shri Sidraju M, who has appeared for respondent number 2, accepts notice for respondent number 1 also. And what is the matter?
My lord, this is a matter where, my lord, the tender was awarded to the petitioner. He had carried out, my lord, outstanding bills.
First carry out this change. Released on 19th August.
Please. Much.
51.
51, my lords. For the CL number 51, I appear for the petitioner, my lords. Seems to be a talk of a settlement, my lords. We have responded settlement.
ಮಾತಾಡ್ತಾ ಇದ್ದೀರಾ? All the councils submit that the parties are discussing settlement and given. How much time do you want?
2 weeks time, my lords.
2 weeks time, they will endeavor to report settlement. Released on 19th.
The CL number 51, there's an interim order which has to be
Interim order where granted is extended till next date.
grateful.
52. Anand Ramachandra Das.
In this case, my lord, I'm submitting bank statement along with a memo. It's a senior citizenship act, my lords. In this case, 10,000 has been ordered for the maintenance. Lords, I have paid up to date. My lord, I'm not violating the interim order, my lords.
You will
Moreover,
vacate the interim order right now.
my lord,
You are trying to hoodwink this court?
my lords, one small submission. In this case, the respondent number 4, even he is not ready to take the amount, my lords. He's residing in the same house. In fact,
You were asked to transfer
may
it.
kindly see the
We'll
cost
vacate
title
the
also, my
interim-
lords.
Mr. Counsel, you were put on notice last time.
Please, my lords.
They specifically said that you were not paid the money to the senior citizen. You said it's been paid. That's why we asked you to keep it on record as for completeness of record.
No, my lords.
And now you transfer this money just a day before the matter is listed.
No, my lords, I have paid 1,10,000 before itself, my lords.
That is after defaulting for 11 months.
My lords, on every occasion,
Memo has been filed.
my lords, one small
We
submission.
are
my lords.
vacating it, Mr. Counsel.
My lords, one small submission. My lords. In this case, they are both residing in the same house. My lords, may
We will
kindly see
consider that on
may
merits
kindly
later.
see the cost title of the.
If you violate the order, you'll bear the.
My lords, they are refusing to take the maintenance, my lords, and they are moreover asking for the possession over the property, and we
Last
are ready to
time-
give the possession also.
last
Let
time
him
you
come and
had-
stay in the same property.
Don't make these false submissions for us to make observations. Don't make these false submissions.
My lords,
Last time the transfer was made account to account.
please, my lords.
You were told to transfer account to account, not to hand over in person.
Please, my
And don't come up with these stories because your client is coming up with this and violating an order of the court. If you are going to support a litigant who violates the orders, then there won't be value for the orders of this court. Tomorrow you will be on the other side. Then if there's no value for the order of the court, what will you do?
My apologies.
On 9/7/26, there is a specific submission made by the counsel for the respondent that the petitioner has violated the orders of this court and not made payments of the maintenance amounts. The same was, however, denied by the counsel for the petitioner, stating that the payments have been made from time to time and the records would be placed. Records and details of payment would be placed. Today, a memo has been filed enclosing a transfer detail of 30,000 made on 27/7/26, that is yesterday. Earlier on 9/7/26, a submission had been made. Thus, the submission made on 9/7/26 by the counsel for the petitioner on instruction was apparently is ex facie false, inasmuch as no payment has been made prior to 9/7/26. Even from 9/7/26, no payment was made until yesterday evening. Apparently, it is after the above matter is listed that the aforesaid payment has been made.
My lords, it was date given, my lords, and moreover, he had some medical issues. That's the reason he had made delay, my lords.
You made a submission that it has been paid, which
My
is
lords,
wrong.
I have not made with that regard, my lords. I have stated that up to 1,10,000.
That view of the matter. The conditional order which had been passed by this court, subject to payment of the maintenance amount to a senior citizen on time, having been violated, the interim order stands vacated. Released on 14th August.
My lords.
Serial number 53, R.P. Somshekaraya.
Next to the marginal land, my lord, small plot was allotted.
ಯಾರಿದ್ದಾರೆ ಒಂದು ನಿಮಿಷ ಇತ್ತು.
ಅಲ್ಲ ಅವರು ಇಂಟ್ರಿ ಮಾಡೋದು ತಗೊಂಡು
On behalf of Chandrasekhar P. Patel, my lord, his morning is mentioned to taking time, my lord, is next week, my lord.
It was rejected. And if he is not here, it is his, he cannot ask for time and then come. We are not going to pass.
That is pass over, my lord.
Pass over.
Please.
54. Srinivasa NC.
Mr. Srinivasa. What is this matter, madam? Forest matter?
They have challenged notification, my lord. Section 17
Appearing
is
for
also-
petitioner in this case, Your Lordship.
Yes.
Your Lordship, respondent had filed a statement of objections. Copy has not been served to us, Your Lordship. We are requesting for a copy, Your Lordship.
Copy not, sir.
certain, my lord, but no locus, my
But
lord.
counsel for the petitioner submit that he has not received the statement of objection filed by the AG. The AG is directed to serve, furnish a set of the petitioner, a set of the said objection statement filed.
Short date may be given, my lord. They have
Released
no
on
locus.
19th August.
Please.
Interim order earlier granted is extended till next date.
5. Yashwant HN.
Your lordship, the respondent bank, they have removed the lien mark, your lordship.
File a memo.
It is an active status. So kindly observing the same, dispose of the petition.
File a memo.
Sure.
Petitioner is before this court seeking for the following leave. Counsel for the petitioner has filed a memo which reads as under. His submission is that the lien has been removed, rendering the above petition infructuous. Accepting his submission, petition is dismissed as infructuous.
56. Sampath Kumar.
So Sampath Kumar.
My lord, last date the court had directed me, honorable court had directed me to produce the notification, my lord, showing the survey number has been notified as forest.
Order dated 16/6.
I've put a posted, my lord. The entire survey number 21, my lord. The entire land has been notified as forest under the 1918 notification.
And AGA has filed a memo enclosing the notification bearing GO number R 11821-4 -FT 134-17-6 dated 6 June 1918, indicating that the entire land in survey number 21 of Kuruburalli village, Chelu Robli, Gubbi Taluk, has been entire survey number 21 measuring 155 acres, 24 guntas, has been notified as a forest land. Copy thereof has been furnished to the counsel for the petitioner, who seeks for and is granted a week's time to go through the same and make a submission. Released on 19th August.
So may be permitted to submit on circular manner with respect to the forest land is concerned. Then the second page, may read that C. ಅರಣ್ಯ ಸಂರಕ್ಷಣಾ ಕಾಯ್ದೆ 1980 ಜಾರಿಗೆ ಬರುವ ಪೂರ್ವದಲ್ಲಿ ರಾಜ್ಯ ಸರ್ಕಾರದ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಗಳು ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಭೂ ಮಂಜೂರಾತಿ ಕಾಯ್ದೆ ಮತ್ತು ನಿಯಮಗಳು ಹಾಗೂ ಇತರೆ ಕಾನೂನಾತ್ಮಕ ನಿಯಮಗಳಡಿಯಲ್ಲಿ ಅನೇಕ ಪ್ರಕರಣಗಳಲ್ಲಿ ಅರಣ್ಯ ಭೂಮಿಯನ್ನು ಮಂಜೂರು ಮಾಡಿರುತ್ತವೆ. ಆದರೆ ಆ ವೇಳೆಯಲ್ಲಿ ಕರ್ನಾಟಕದಲ್ಲಿ ಚಾಲ್ತಿಯಲ್ಲಿದ್ದಂತಹ ಅರಣ್ಯ ಕಾಯ್ದೆಗಳನ್ವಯ ಇಂತಹ ಮಂಜೂರಾದ ಅರಣ್ಯ ಭೂಮಿಯನ್ನು ಡಿನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿರುವುದಿಲ್ಲ. ಇದರ ಪರಿಣಾಮವಾಗಿ ಇಂತಹ ಮಂಜೂರಾತಿಗಳು ಕರ್ನಾಟಕ ಅರಣ್ಯ ಇಲಾಖೆಯ ದಾಖಲೆಗಳಲ್ಲಿ ಅರಣ್ಯ ಎಂಬುದಾಗಿ ಮುಂದುವರಿಸಿಕೊಂಡು ಬರಲಾಗುತ್ತಿದೆ. ಇಂತಹ ಎಲ್ಲ ಅರ್ಹ ಅರಣ್ಯ ಭೂ ಮಂಜೂರಾತಿ ಪ್ರಕರಣಗಳನ್ನು ಅರಣ್ಯ ಸಂರಕ್ಷಣಾ ಕಾಯ್ದೆ 1982 ಅಡಿಯಲ್ಲಿ ಭಾರತ ಸರ್ಕಾರದ ಅರಣ್ಯ ಪರಿಸರ ಮತ್ತು ಹವಾಮಾನ ಬದಲಾವಣಾ ಇಲಾಖೆ ನವದೆಹಲಿ ಇವರಿಗೆ ಅನುಮತಿಗಾಗಿ ಕಳುಹಿಸಿಕೊಡಲಾಗುವುದು.
ಅನುಮತಿಗೆ
ಪ್ಲೀಸ್ ಮಿನಟ್ಸ್.
ಅನುಮತಿಗೆ ಹೋಗಿ ಆಗಿದೆಯಾ ನಿಮ್ದು?
ಅಲ್ಲ, ದಟ್ ಇಸ್ ನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಮಿನಟ್ಸ್. ಹೋಗಿದೆ, ಮತ್ತೆ ಬಂದಿಲ್ಲ ಅದು. ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿಸ್ ಸರ್ಕ್ಯುಲರ್ ಮೆಲಡ್,
ಗೋದಾವರ್ಮನ್ ಜಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಏನು ಬರಲಿಲ್ಲಪ್ಪ. ನಥಿಂಗ್ ಕ್ಯಾನ್ ಕಮ್.
ಅಲ್ಲ, ದಟ್ ಇಸ್ ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್ ಫಾರ್ ಡಿನೋಟಿಫಿಕೇಶನ್.
ನಿರ್ವಾಣೇಗೌಡ ಜಜ್ಮೆಂಟ್ ಇದೆ. Circular you can't rely on. Only thing that you submitted is that it's not a forest land.
Please.
They have produced the notification, it is forest land.
Please, I will make my submission.
There is nothing more that can be done. All forests have to be preserved.
I will go through that, sir. Deeply.
19.
57. HR Ananta Krishnamurthy.
Mr. Mutharna, what is this matter?
My lord, this is a mandamus seeking to defreeze a gold loan account, my lord, with the respondent bank. My lord, the brief facts of this case are the petitioner had a savings bank account with the respondent, and she was running some kind of a chit fund business which faced some losses, and she pledged some of ornaments of her sister-in-law, one Miss Gautami. With
the order has been passed by the 31st Additional Chief Metropolitan Magistrate.
Yes, my lord. The 352 subclause 5 application was filed by the sister-in-law of the petitioner. That came to be rejected, my lord, because the IO filed a report stating that no gold articles were frozen in the said complaint, which is pending before the said CC, which is pending before the particular ACMM, my lord. Now it so happened that
this is a gold loan, Andre?
Yes, my lord. It's a gold loan. It is interlinked with the savings bank account, my lord. My lord, if I may take your lordship's, the gold loan slip is at Annexure B, page number 13, my lord.
Idhar number? Paso?
58. Raghava P.
For the petitioner matter, my lords. The matter pertaining to the compassionate appointment. The petitioner is the widower of one late Sushma. She was working as a chowkidar in the institute at Jawahar Navodaya Vidyalaya at Gajanur since April 2014. Now, uh, on one of these days, that is on February 3, 2022, while they were heading, there was a car accident that takes place. And while he was trying to avoid the snake that was passing by, the car falls into a canal. And because of that, the death of Sushma takes place. Now, there is on the very next day, the sister of Sushma files a complaint saying that this is a kind of a murder or culpable homicide. Now, accordingly, the charges that were framed were under Section 279 and Section 304A. Now, the entire trial takes place, which can be found at Annexure C, Malats. Trial takes place based on merits. He gets page 38, Malats, the judgment. The final order can be found at page number 52, Malats. Now, as per this, the petitioner gets acquitted as there is no offense that has been made out.
Yes.
The basic offense that was alleged against him was rash and negligent driving, and in addition to that, deaths due to negligence. Now, all the essential ingredients were not fulfilled by the prosecution. Accordingly, he was convicted. Now, immediately after the death, within the period of 6 months, he has made an application to the Jawahar Navodaya Vidyalaya asking for compassionate appointment. However, there was delay in terms of finalizing, and I just got a document from the respondent saying that he was already recommended as on 25th of April 2025. However, there has been no decision that has been passed yet in this regard. There is no appointment order that has been.
My lords, there is a statutory remedy which is available to the petitioner to approach the CAT, my lords. Even otherwise, my lords, a compassionate appointment is not a right, it is an entitlement. We just try to support them, my lords.
It's been
Now, my lords,
recommended is what you say.
so
Consider
there
it,
is
pass some,
if I may be.
either accept or reject it.
My lords,
Don't
we've
sit on it.
made a recommendation where we've considered, it is pending, my lords, as per the prayer is for consideration of the
The final
recommendation.
order, this is pending from when? 22.
Even before the petition was filed, he is recommended. My lords, may kindly have page 3.
Now, who is the authority to take a decision?
Respondent number 1, my lords. That is the society.
So you appear
Prayer is for recommendation by the respondent number 234, which is considered already, which is done.
you appear for respond number 1 also.
All, my lords, but it is pending. We might need some time to consider because of the
4
act.
years you have taken.
My lords, because of the criminal proceeding which was pending, my lords may kindly have it after 8 weeks, my lords. We will pass necessary orders.
We'll direct you to pass orders within 8 weeks and dispose the matter. There's no need to keep it pending. After 8 weeks, you'll come and say another 6 weeks.
Either way, there was recommendation which was done. even
Petitioner is
the
before this court seeking for the following reliefs. An application for compassionate appointment has been made. That counsel for respondent submits that respondent number 2, 3 and 4 had recommended the said appointment of the petitioner. And now the same is pending consideration before the first respondent. The recommendation has been made on 25/4/2025. The same is still pending with the first respondent. In that view of the matter, this court passes the following order. Writ petition is partly allowed. Respondent number 1 is directed to consider the recommendation made by respondent number 2 and pass necessary orders within 8 weeks from the date of receipt of a copy of this order.
Great.
Grateful.
59. Angat Kamath, party in person.
Yes.
Is already serving on behalf of the respondent.
Yes.
But I just want to clarify. This is not adversarial at all. I may in fact withdraw it. But I just want to.
If you want to withdraw, withdraw.
But I just
If
want
you
to
want to
share
argue,
one thing.
argue.
In institutional interest, because not at the end of the day, if archives have to be maintained, not and that's going to be a cost. I don't want to be the reason for that cost. I just want to show the impugned order, because the impugned order does not serve the burden of having to maintain the archives. The impugned order only says, I don't have jurisdiction. You go before the court which has
Yes,
heard
sir.
the matter.
Of course, my
Just
lord.
1 minute, sir.
Of course.
Let me just finish.
Before that, my lord.
I'm saying.
My lord, may I make one?
Let him complete.
Yes.
So, not the
He
impugned order.
wants to withdraw is what he says.
That's what.
No,
But he wants to say something.
No, I'm saying.
Yes.
It's not adversarial one. Second, not at the end of the day, the archives will still have to be maintained because the impugned order does not say on merits you're not entitled to it. The impugned order only says you have to go before the court which heard the matter because you're asking for use. But I never asked for use. I'm only asking for access. The distinction between access and use is what I tried to make out from a reading of the rules. If your lordship see the heading on in
Now,
rule
now
8,
that you're getting into repetition mode, you first decide whether you want to withdraw or you want to argue. If you want to argue, then you are entitled to argue. After everything you want to withdraw, don't waste time. That's all.
I just want to, since your lordship are even on the administrative committee, your lordship will look into it. Not, I'll withdraw it. I don't want to be the cause for burdening the High Court in that sense.
We are not saying anything. It's for you to decide.
I'll withdraw it. I don't want to.
File the memo.
Yeah, it's memos here.
Petitioner is before this court seeking for the following.
Your lordship will only
Memo-
take into account, not one of the prayers, your lordship may keep the question of law open. Because your lordship got to see.
Memo has been filed, seeking permission to withdraw the above petition. Accepting said memo, petition is dismissed as withdrawn. The question of law is however kept open.
My lord, one
Insofar
submission
as
on
rule
behalf
8,
of the
there are no
institution.
guidelines.
My lord, tomorrow all advocates will come and ask for the my lord video of the clips of the honorable
Then I'll
court.
ask.
It is a my lord complete peer review of the order of the my lord learned judge of the particular court. It is nobody's hand, my lord. It is rule 8.1 is very clear with respect to this.
But then I'll argue.
That's all.
I'll just show your
Please,
lordship
sorry.
what his objections are. I'll show your lordship what the objections are. Your lordship want to see rule 8 specifically says. I'm grateful.
Oblige me.
Serial number 60. Jairaj 80.
Jairaj,
Yes, I am for the petitioner, my lord. Kindly pass over.
TM Vijay Kumar, pass over.
No, sir.
61. PB Raju.
Mr. Raju, ಬನ್ನಿ ಮುಂದೆ ಬನ್ನಿ ಈ ಕಡೆ ಬನ್ನಿ ಏನ್ ನಿಮ್ಮ ಹೆಸರು ಏನು ನೋಡಿ ವಸಂತ್ ಕುಮಾರ್ ಏನ್ ಮಾಡ್ತೀರಾ ಇವಾಗ ಯಾವಾಗ ಮಾಡ್ತೀರಾ ಯಾವಾಗ
My lord, my responsible submission, even after this also, their liability will not be clear. Even after these proceedings, we will initiate proceedings under section 31 of the remove the guarantee of the guarantors. And my responsible submission, in this red petition number 2 and 3, they are not necessary parties. This is initiation of action only on primary assets of the.
Mr. Somshekhar, there's a council who has retired. They are going to appoint a new council. He's asking for a week's time. Should we not give them a week's time? The matter has been pending. You are arguing when a party is there.
I am prepared for the synopsis, sir.
Please file your synopsis, give him a copy. Shri K.M. Vasant Kumar is personally present before the petition number 2 is personally present before this court. He submits that the earlier council has handed over a no objection wakalatnama along with all the papers. He seeks for and is granted a week's time to appoint a new advocate to conduct the proceedings. Registry is directed to delete the name of Sri Bhuvanendra Raju P and PB Raju and PB Raju. Eradu ಒಂದೇ ಅಲ್ವಾ?
Copy of the synopsis circular.
As that appearing to the petitioner and print the name of the petitioners in the cause list. Sri PB Raju is discharged from the matter. Learned counsel for respondent has filed a synopsis of arguments. Copy thereof has been served on the petition number 2. Released on 19th August, it is made clear that no further adjournment would be granted. Released on 19th August, It's made clear that no further adjournment would be granted. If no representation is made on behalf of the petitioner on that date, petition would be liable to be dismissed for non-prosecution.
Serial number 62, Naveen Casey, party in person.
My lord, I am appearing for petitioner.
You filed your wakalatnama, madam?
Yes, yes, ma'am.
Why is your name not coming in the cause list? Ms. So-and-so submit that she has filed wakalatnama for the petitioner. Registry to verify and print her name as that appearing for the petitioner. You have not carried out the amendment on 9/7.
I'll carry out. I'll carry out.
Counsel for the petitioner seeks for and is granted a week's time to carry out necessary amendment as directed on 9/7/26. Yes, Mr. Krishna, they want to register an association.
That now my instruction, my lord, now the state government has passed the separate bill, my lord, the Karnataka Apartment Owners and Management Bill 2026.
Act aita adu.
Bill
It will take two more years.
It is only a bill stage.
bill stage ಅಲ್ಲಿ.
Bill alli it's inviting for objections. In fact, you should give all your suggestion on the basis of the litigation coming.
They have already given no objection, my lord, for formation of association, BDA.
Put your copy. Put. Yes. So you comply with the applicable law, get everybody to sign and submit a deed of declaration.
But respondent number 4 is rejecting our application, my lord, stating that he has no jurisdiction. Annexure D.
Annexure B.
D.
D.
62, page number 62.
62.
Second point, property details anta ide. The content of the deed does not fall under jurisdiction of sub-registrar office anta ಹೇಳ್ತಾರೆ.
Which sub-registrar did you present this?
KR Puram.
Where is the property located?
In jurisdiction of that sub-registrar only. Property is located at Konadasapura, which comes under jurisdiction of KR Puram.
Yes, Shaman.
Also, Jafar.
Serial number 63, Raja Subramanyapur.
Sixty-three. Mr. Butt. Yenappa.
Paso, Jafar again.
Paso.
65, NS Jain Babu.
64 withdrawn. 65. So Vijayant Babu. Paso.
66,
Petition has become infructuous.
But
Petition has
so
become
far as-
infructuous. The first prayer, what has been sought, the auction did not take place. Meaning they did not proceed with the auction, though they notified, they did not progress on the auction proceedings. That was dropped. So,
prayer
challenge
gave
what
him
was there for
subsistence.
the, not to undertake the auction, my lord, doesn't survive.
Consider his representation and pass orders.
Is not
Consider his representation. Second prayer.
pursuant to that representation, the auction was taken up. But precisely, there is no any. I am not aware where any order has been passed on that particular representation.
Listen.
We look at once again.
Petitioner is before this court seeking for the following release. The HN Vasif and counsel for respond number 2 submit that the e-auction as scheduled in terms of the notification dated 15/5/26 was not carried out, rendering the first prayer infructuous. Insofar as the second prayer is concerned, his submission is that the representation have been considered. On inquiry as to whether a formal order has been passed, he submits that he is not aware if such a formal order has been passed. In that view of the matter, if no formal order has been passed on the representations, directing the respondents to pass such a formal order within 4 weeks from the date of receipt of a copy of this order, petition stands disposed.
67, Concurrence order.
On the previous occasion.
Some documents you have to produce.
Yes, I'm producing.
You're giving them a copy?
Yes.
Howlinda ಕೂತಿದ್ರೆ ಕೊಟ್ಟಿದ್ರೆ ಹಾಕಿ
Sir.
ಒಳ್ಳೆ ಸುಮ್ಮನೆ ಅದಕ್ಕೆ ಅಜ್ಜನ್ ಆಗತ್ತೆ.
Kindly pass over.
Passo.
Please.
68, Keshav Bhatt.
Keshav Bhatt. Defreezing. Outside state. Outside state. Refer to Cyber Command. Petitioner is on 30th August, relist on 13th August, 30th July, relist on 13th August.
69, Nitin Ramesh.
He has undergone some surgery or some submission. Yes, Nitin,
My lord,
you're back.
my lord, am I audible, my lord?
Yes, you are.
My lord, my apologies, I'm appearing online today, my lord.
No need to apologize for that at all. Some submission was made that you have undergone some surgery. How are you?
My lords, there was some treatment that I underwent, my lords. I'm okay, my lords. For last two, I've started to come, but last 2 weeks I was a little unwell.
You are ready to address arguments in this?
I am ready to address, my lords.
Gautam, ready?
Actually, I don't have a copy, my lord.
Copy ilva. Nitin, copy has not been given to Mr. Gautam.
My lords, everything was served on the last date, my lords. In fact, I come on NOC in this 2 days back.
Just
In
serve
case the
him
copy
one
is not available, I'll serve a short date.
Shri Nitin Ramesh has entered appearance for the petitioner. Delete the name of Shri R. Kumar as that appearing for the petitioner. Shri Gautam Desi Ullal has entered appearance for respondent number 127. Delete the name of Shri M.N. Kumar as that appearing for respondent number 127. Shri Ullal submit that he is yet to receive copy of the petition. The counsel for the petitioner is directed to furnish 2 sets of the petition along with annexures by end of day 3rd August. Relist on 24th August.
Serial number 70, urgent, 71. Dinesh,
Kindly pass over.
Pass over.
72, Prashant BR, connected matter.
Hearing for R1 minutes.
Mr. Prashant.
Haven't served as a copy also, my lord.
Is not served.
Not served.
Pass over. Let him come.
73, urgent, 74. Sudhakar Pai.
I appear for the respond number 1. Pray for a short accommodation to file a statement of objection.
That counsel for none appears for the petitioner or respond number 3 and 4. Counsel for respond number 1 seeks for and is granted 2 weeks time to file the statement of objection.
3 and 4,
Mohammed Niaz, you are appearing for him. None appears for the petitioner. You want to file any objections? Next date. Counsel for respond number 1 and respond number 3 and 4 seek for and are granted 2 weeks time to file their respective statement of objections. Objections, if any, by 20th August, failing which it will be taken as not filed and matter proceeded with. Relist on 27th August.
75, Rahul S. Reddy.
My lords, I appear for the petitioners in this matter.
So and so submit that you will be filing wakalat number for respond number 3 and 4. Registry is directed to print his name as such. Copy bandidya?
Copy bandidya.
Ready na?
Copy on get. Yesterday only I received the files.
Counsel for respondent 3 and 4 seeks fund is granted 2 weeks time. Relist on 25th August. Interim order earlier granted is extended till next date of hearing.
Please, ma'am.
76.
I was unable to appear last week, Lords. Served the copy, Lords, to the other side.
Yes, Mr.
Lords, freezing of my account, Lords, by the respondent bank. Lord, the disputed amount is not only 3,50,000.
Outside state.
Yeah, not, he is residing in Lords in Tamil Nadu, but bank is in Lords in Bangalore.
Inspector is in Gujarat.
Lords.
Inspector is in Gujarat. Go to Cyber Command on Thursday.
I agree, Lords. I know Lordship has passed a detailed order. Lords, kindly, Lords, let them freeze, Lords, the disputed amount.
You go there, let us get in details. The order is to defreeze the entire account. They'll speak to them and see what is to be done. Some 100 matters have been settled is what Mr. Jaffer was telling us. Cyber Command 30th, relist on 13th.
Lords, in between, shall I approach before the authority, Lords?
30th.
30th, Oblate Lords.
Every Thursday it will be held.
Oblate Lords.
Alva?
13th of April.
Now 30th is Thursday.
Yes, my lord. That
So
is
they can go on 30th.
13th as well, another Thursday. 6th and one more Thursday. Even on that day we have.
Now they can go 2 days from now.
30th.
As early as possible.
Yes.
Oblate.
77.
Please, my lord, appear for the petitioner, my lords. I'm being led by counsel in Delhi, my lords. He has suffered a back injury. So he has
Suffered
been
a back injury.
We've informed the other side as well, my lord. So request for a short accommodation.
So when is he going to be back?
At least 3 weeks of bed rest is advised, so maybe in the week.
It's submitted that the counsel for the petitioner has suffered an injury requiring 3 weeks of recuperation. Relist on 25th August.
Please, my lords.
Ms. Annapurna Bordalai has appeared for respondent. Delete the name of Unni Krishnan as that appearing for the respondent. 77.1 Annapurna Bordalai has appeared. Delete Madhukar MD as that appearing for the respondent. Readings are complete.
Objections to the 77 they have filed.
77.1.
My lords, that's a 482 matter that was pending before that court. The counsels, the representing the ED.
GM Res, it is saying.
The first one is GM Res, my lords. The second one is 482 petition, challenging the summons.
Readings if not completed to be completed by next date of hearing. Interim order earlier granted is extended till next date.
Please, my lords.
78. Puneet Singh.
In this matter, there was a direction to conduct the survey on 6/7, my lord. Because of some non-availability of revenue documents, they are seeking 1 month time, my lord.
1 month?
Yes, it may be fixed in September first week or second week, my lord. Date for survey.
Date of survey in September.
Yes, my lord.
And AG submit that due to non-availability of certain records, the survey could not be carried out. He submits that if a date is fixed in the first week of September, necessary survey would be carried out and report furnished. In that view of the matter, the respondents are directed to carry out the survey commencing from 10:30 a.m. on 5th September 2026. Interim order earlier grant and submit the report by 21st September. Interim order earlier granted is extended till next date of hearing.
Next matter also same. 79.
79, same order.
Serial number 80. CN Mahadeshwaram.
For the petitioner in this case, case of tender where the respondent number 4, who is the beneficiary of the tender.
You are appealing for 2 and 3, Sumant.
3, my lord. 3, I have not sought any relief against number 3, my lord. My only thing is, my lord, the tender has been invited by respondent number 2, and it has been awarded to respondent number 4. My lord, the importance of the tender is that, my lord, it is for the cleaning purpose of the water purification, and there is a proceedings that has been initiated by pollution board also, my lord. So for that reason, this particular tender was called for only for the cleaning of the water purpose.
Your release you are asking for against respondent number 2 and 3.
My lord,
Three, my lord, three is only KMF, only respondent number 2 is the important, respondent 2 is.
Then delete your prayer.
I'll do that, my lord, I'll do that.
If you delete it, then you will be in trouble.
No, I'll do it, my lord.
Make
Because
submissions.
respondent 3, my lord, only, and respondent number 4 is a beneficiary.
Ready?
Weeks time to file my statement of objections.
Weeks time.
Because I have not sought any relief against them, my lord. I will.
For
stay in my
respondent
prayer
2 also
my
I'm
lord.
appearing.
Two is the only main, they are the one who invited the.
Mr. Counsel, did you hear who is appearing for?
Yes, my lord.
For whom?
Well, he is for respondent number 3, my lord.
That is where the problem is. You say he is appearing for 2 and 3.
Sorry, my lord.
See
I'm
the
sorry.
cause list.
I'm sorry, my lord.
Where counsel for respondent number 2 and 3 seeks for and is granted a week's time to obtain instruction and make a submission. Released on 14th August.
Please.
81.
Appearing for petitioner in this case, my lord.
Mr. H.M. Madhusudana. इधर है ऑनलाइन इधर है You're ready?
Yes, my lord.
Password?
82. Yes, Rashekar.
Next year, my lords, imposition of penalty, my lords, has been challenged.
Mr. Nagrale?
Deposited, my lords, 25% of the fine amount, my lords. Deposited the 25%.
Where is Mr. Santosh Nagrale?
They have to file objections.
He has to file wakalat also. Call him. Paso.
Please.
83. Girish Kumar.
In either no either. Respond number 5 deferred. Account freezing.
Yes, out of.
Cyber command on 30th, released on 13th.
84 Arjan. 85. Janardana Ji.
So Janardana,
Madam, based on the earlier order, Lordship passed the order annexure JML. Madam, in the case of acquiring Someshwara temple, they have also acquired my temple, which is not of the notified R for acquisition.
annexure J, page number?
That page 31, madam. 11th portion at paragraph 4, page 33.
Yes.
My lord, I'll seek instruction, my lord, on the previous order.
That is what was given on 3/7.
My apologies, my lord.
Madhyananda told you, we don't want to be listing like this.
Yes, ma'am.
Paso.
86. Zubair Ahmad. Khan.
Zubair Ahmed. Paso.
87 Arjan. Hearing on IA, serial number 88 Arjan. 89. Narendra Babu.
The respondents in this case, my lord.
In this, I may be.
What is this
But
impleading
is
application was?
File counter to the impleading application, my lord.
Your file counter.
My lord, apart from that, my lord, I have one submission. One of the petition, my lord, what is challenged is the order of the CCF under 64A
And I am
A3, my lord. A3, my lord. I just need to point out the survey sketch and survey report, which is not under challenge by the petitioner. That survey sketch and report clearly goes to show that his land is within the.
We'll come to the merits.
That's all.
later.
I'll just.
As per as
my
Just
one
one.
submission. One
There's
submission.
an impleading application pending.
That
Who
is
has
in the-
filed this
I
impleading?
am filing objection.
Who is to be impleaded?
It is my
Lord, clear an application filed by the impleading applicant in pursuance of, my lord, the proceedings are culminated, that was rejected by the Honorable Court. Again, my lord is trying to.
Where is Mr. Narendra Babu?
Senior is online, my lord.
Mr. Narendra Babu?
Jagdish sir is online.
Jagdish or appear?
Yes, my lord.
Allah, objection for minute.
Kodi, objections in. They want to implead the additional deputy commissioner. What's the objection that you have?
Allah, our
That is in
party, my lord.
34211, my lord.
Just I
One more
request your lordship to
impleading
kindly
application
peruse, my
filed
lord.
in 1111.
The proceedings were culminated in pursuance of an order passed by the Honorable Court in WP 6613 of
Mr.
2020.
Vishwanath, right now we are considering the impleading application. In the
That's what, my lord. Impleading application filed in the same proceedings, my lord, was rejected by a reasoned order, my lord.
Where is
There,
that? For the
just I
objections,
request- that is at page 275, my lord, order 3 of
you have
2020.
filed this objection 11992. What about 34112, Mr. Narendra Babu? ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು.
ಇಲ್ಲ ಅದರಲ್ಲಿ I am not on record, my lord.
You have no objection for allowing this application.
I have not served a copy to me, ma'am.
Yes, Mr. Jagdish.
Lord, what happened in this, as my lords are aware, we have filed an IFR impleading in 34112 of 2025. My colleague is there.
You want to implead the additional deputy commissioner?
Please, my lord.
You filed it. Yes, any objection?
No, my lord, we have no objection.
IA 1 of 26, 2 of 26 has been filed to implead the additional deputy commissioner. There being no objection on part of the respondent council, IA 2 of 26 is allowed. The additional deputy commissioner is brought on record as respondent number 4. And AGA accepts notice for respondent number 4. Counsel for the petitioner to carry out necessary amendment and file amended cost title. Next code 11992.
ಅದರಲ್ಲಿ I have my objections for
In this also, we have filed an IFR. In this matter also, my lord, we have filed an IFR impleading. My colleague has filed.
Who is to implead? Who is to be impleaded?
My lord is 89.1, my lord, now dealing with 89.1.
Yes.
My lord, I have submission in this regard.
We'll first finish the impleading application.
ಅದರಲ್ಲಿ as far as the objections are concerned, my lord, I have filed. And as far as
I want to
the
implead one Ananta Kirti.
Objection copy ಕೊಟ್ಟಿಲ್ಲ sir.
Yes, my lord. Please, my lord.
Copy not served on me.
He is a my lord. He is a resident of Kolar.
My lord, it may not be necessary, my lord.
My lord, we'll go through the objection and
Aye.
we'll.
They may say so.
I just.
Yes. Yes,
In
Mr.
Godavaram case, what the Supreme Court has said, my lord, as my lords are aware, I need not have to trouble my lord. Every citizen has also got a right to protect the forest rights.
Who is this? Who is this Ananta Kirti? You want to come on record?
My only.
Yes, my lord.
Submission is, my lord.
Yes.
State is anyway protecting the forest, my lord. An order has been passed by the CCR under 64(3)(a), my lord. There's a survey, 4 joint surveys have taken place. The last is in month of January 2025. There is no challenge by the petitioner with regard to this survey sketch and survey report. Now, this survey sketch and report shows petitioner has encroached nearly about 60 acres of land within the boundaries of the notified reserve forest. As my lords are aware, it's a summary proceedings. If the survey sketch and report is not challenged, my lord, all that I need to show to my lords is that his lands are within the boundaries. And insofar as 6 acres of land is concerned, he claims to have purchased lands in survey number 2. Survey number 1, he is found to be in possession of 6 acres. The petitioner, my lord, under
Survey
3
number 1 is
safeguards,
forest land.
Forest.
2 and 1 are, 1 is entirely forest, 2 is part forest and part revenue, my lord. The survey sketch discloses that he is encroached about 54 in survey number 2, 6 acres in survey number 1. None of his sale deeds anyway have reference to survey number 1, my lord. His contention is only with regard to survey number 2. Now, what they are saying is, my lord, that he has requested the state government to invoke powers under 19(2) of the Karnataka Forest Act. For if there is any defect or if the boundaries are not clear, then 19(2) can be invoked.
Sorry, my lord, already the
I'll
government
just make my
has.
submission,
Let him
sir.
make
I'll
a
just.
submission, then you
So,
can.
all that I'm saying is, my lord, today at least if my lords can consider, because Srinivasapura, we have evicted nearly 2,000 encroachments in last 2-3 years, my lord. It's been the recovery has been highest in the state. All that I'm saying is, my lord, if my lord sees the survey sketch and survey report, my lord, it's a short point, my lord. It can also be decided apart from 89, my lord. 89 is pertaining to powers under 19(2). My lords may uphold, either reject the CCF order or uphold the CCF order, my lord. which can always be subject to 89, my lord.
So
That's all, my lord.
you are ready for your argument.
I am ready, my lord.
But as far as um, it's called the rejoinder to, my lord, already they have initiated the
Rejoinder to what?
19.2. That is, your lordship may kindly peruse page 286.
What are you filing now?
My lord, that notification issued by the official memorandum issued by the government, they have not placed it before this honorable court.
Learned
Just I request.
89.1. Learned counsel for the petitioner has filed a rejoinder to the statement of objection filed by the fifth respondent. The same is taken on record. IA 1 of 26 has been filed by a proposed respondent claiming that the proposed by a resident of Srinivaspura claiming that he wants to come on record to protect the forest land. He cannot be brought on record as a proposed respondent. He is allowed to assist this court as an intervener. IA 1 of 26 stands disposed. Yes, we'll come back in the afternoon to address your arguments. First housekeeping of all these applications which are ಆಮೇಲೆ ಅಲ್ಲಿ ಡಿಕ್ಟೇಷನ್ ಕೊಡಕ್ ನೋಡಿದ್ರೆ ಒಂದು 4 ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇರುತ್ತೆ.
There's one matter, my lords, which pertains to Archaka rights of Tripura Sundari temple. Your lordship directed the registry to, my lords, list the matter today. Inadvertently, my lords, what has been recorded is 28/6. That's the reason it's not listed today, my lords. Urgency is in a calendar year. I am allotted 15th to 31st July.
We'll take it tomorrow.
3 days remains. 15 ರಿಂದ 31 ಅಷ್ಟೇ ಇರುತ್ತೆ.
We'll take it tomorrow.
Please.
ಅವ್ರಿಗೆ ಕೊಡ್ತೀನಿ ನಾಳೆಗಂತೆ
28/6 ಬರ್ಬೋದು. ಅದೇ 28/7 ಹೇಳಿದ್ ಸಾಹೇಬ್ರು, ನೀವು 28/6 ಬರ್ಬೋದು. ಇವತ್ತಿನ ಡೇಟ್ ಹಾಕಿದ್ದೀನಲ್ಲ ನಾನು, ಅದನ್ನೇ ಓದಿ ನಾನು ಕನ್ಫ್ಯೂಸ್ ಆಗ್ತೀನಿ ಸರ್. ಇದು ನೋಡಿ
ಮಾಡ್ತಾರೆ ಅಲ್ಲ, ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ?
7 ಅಂತಿದೆ, ಬಟ್ ಆರ್ಡರ್
ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿದ್ದು ಬ್ರಾಂಚ್ ಕಳಿಸಿದೀವಿ.
ಅಲ್ಲೋಗ್ ಕೊಡ್ಲಾ?
ಯಾವತ್ತಿಗೆ ಹೇಳಿದ್ರು ಬರುತ್ತೆ, ಕಳಿಸಿ.
71 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಕಳಿಸಿದೀವಿ, ಅಲ್ಲಿ ಬುಕ್ ಇದೆ, ತಗೊಂಡು ಚೆಕ್ ಮಾಡಿ. ಎಲ್ಲ ಕಳಿಸ್ತೀವಿ ನಾವು, ಅಲ್ಲಿ ಕೇಳಿ ಯಾಕೆ ಅವರು ಲಿಸ್ಟ್ ಮಾಡಲ್ಲ ಅಂತ. ಇಲ್ಲಿ ಫೋಟೋ ತಗೊಂಡೋಗಿ ನಾವು ಕಳಿಸಿ ಅವ್ರು ಸಿಗ್ನೇಚರ್ ಮಾಡಿರ್ತಾರೆ ತಗೊಂಡಿರೋದಕ್ಕೆ. ಮೊಬೈಲ್ ತಗೊಂಡು ಇಟ್ಕೊಂಡು ತಗೊಂಡೋಗಿ ತೋರಿಸಿ, ಅವ್ರು ಹಂಗೆ ಹೇಳೋದು ಬಂದಿಲ್ಲ ಅಂತ. ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್? ಫಸ್ಟು ಸೆಕೆಂಡ್ ಲಿಸ್ಟು ಪಾಸ್ಟ್ ಓವರ್ಸ್, ನಿಮ್ದು ಪಾಸ್ಟ್ ಓವರ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಅದಾದ್ಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ರೀಚ್ ಆಗುತ್ತೆ ಸರ್. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇನ್ನೂ ಇಲ್ಲ ಸರ್, ಇಲ್ಲ ಈಗಷ್ಟೇ. ಸುಧಾರಿಸ್ಕೊಳ್ಳಿ, ನಿಧಾನ ಸುಧಾರಿಸ್ಕೊಳ್ಳಿ. ಇವ್ರನ್ನೆಲ್ಲ ಕಳಿಸ್ತೀನಿ. 71 ಕೇಸ್ ಕರೆದಾಗಿರ್ಲಿಲ್ವಾ ನೀವು? 71 ಪಾಸ್ ಅವರು ಎಲ್ಲ ಸೇರಿ. 88 ನಾಟ್ ಬಿಫೋರ್ ಅಡ್ಜನ್. ಅದು ಡೇಟ್ ಕೊಡಲ್ಲ, ಇವ್ರ ಮುಂದೆ ಬರಲ್ಲ. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಕಂಟಿನ್ಯೂ. ಆಯ್ತು ಆಯ್ತು. 47 98 ಅಷ್ಟೇ. ಇವಾಗ ಹೇಳದ್ನಲ್ಲ, ಸೇವ್ ಅದು. ಪಾಸ್ಟ್ 92 ಇದೆ. 92 ಇದೆ. ರೀಚ್ ಆಗತ್ತೆ, ಇವತ್ತಾಗುತ್ತೆ. The second list of past hours. Hmm. 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 ಅಲ್ಲ ಯಾರನ್ನಾದ್ರೂ ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತ ಪಾರ್ಟಿನ? ಅಯ್ಯೇ. ರೀಕಾಲ್ ಆಗ್ಬೇಕಾ ಆರ್ಡ್ರು ಅಂತ. ಅದು ಹಾಕ್ತಿದ್ದೆ ಅಷ್ಟೇ. ಡಿಲೇ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ ರೀಕಾಲಿಂಗ್ ಅಲ್ಲಿ ಡಿಲೇ ಹೇಳ್ತಾ ಇದೀನಲ್ವಾ? ಅಲ್ಲ ರೀಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದ್ರಲ್ಲಿ ಡಿಲೇ ಇದೆಯಾ? ಗೊತ್ತಿಲ್ಲ, ನಂಗೂ ಗೊತ್ತಿಲ್ಲ. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ಟ್ ಅವರ್ಸ್ ಕಂಟಿನ್ಯೂ. He will advise, that's all. Okay, okay, no. Mention. Okay.
before the registrar and get it done. Yes, next. Sure. List 2. Serial number 11. You are appointed as a court. Huh? When the matter is called out, you make your submission, give them copies. You serve it on them.
List number 2, serial number 1, Vijay Kumar T.
For the petitioner, yes. The matter pertains to Darga festival.
1st of August. And everybody can participate.
There is no bar for participation.
Including the petitioners.
It will be conducted by the officer. Earlier, what has happened is that the responsibility to conduct the program was given to the petitioner. Because of some problems there, may create a law and order situation or something like that. The sub-inspector has written a letter. Following that letter, officer.
But you are now doing it on the 1st.
Yes, we will conduct it. Everybody can participate.
Can you permit the petitioner also participate in the Ganda?
You participate. You won't conduct.
Participate.
Participate.
Can.
Petitioner is before this court seeking for the following reliefs. The writ petition has initially been filed for the purpose of consideration of the representation of the petitioner and permitting the petitioner to conduct the festival of Ganda Pragram of Hazrat Syed Kalandar Shah Hussaini Dargah, Banawara. On notice having been issued, Sri P. Usman, learned counsel appearing for the Waqf board, submit that since there was a law and order issue, the festival is now proposed to be conducted by district Waqf officer. Hence, he was called upon to obtain instruction, make a submission as to when the festival would be celebrated. Today, he submits that the festival would be submitted on the 1st August 2026 by the district Waqf officer. Everyone, including the petitioner, could participate in the said celebrations, which will be conducted solely by the district Waqf officer, who has already issued a public notice about the same. The said submission of Sri P. Usman, learned counsel for respondent number 1, answers the grievance of the petitioner, placing his submission on record, permitting the petitioner only to participate in the said festival celebrations. The petition stands disposed.
Operative portion handle.
ಏನು operative portion of first ಅಷ್ಟೊಳಗೆ upload ಆಗಿದೆ.
It's just a participant.
Full order ಸಿಗತ್ತೆ.
Yes, anybody can participate.
Serial number 2, G. Suresh.
For the petitioner, my lord.
Enforcement Directorate.
My lord, the petitioner challenged the order of taking cognizance by the trial court, my lord, and the
ಎಲ್ಲ ಪೇಜ್ ನಂಬರಿಂಗ್ ಎಲ್ಲ ಸರಿ ಹೋಯ್ತಾ ಇವಾಗ?
ಎಲ್ಲ ಸರಿಯಾಗಿದೆ ಸರ್.
ಎಲ್ಲ ಸರಿಯಾಗಿದೆಯಾ?
ಸರಿಯಾಗಿದೆ ಸರ್. My lord, there are 4 accused, my lord. Accused number 2 is the firm, and accused number 1 is the director of the accused number 2 firm. And also this petitioner, the ED claims that he is also one of the director in the accused number 2 firm. My lord, the accused number 1 lured the investors on various schemes and cheated about 30 crores, my lord. And the allegation by the ED, my lord, the respondent, that this petitioner and accused number 4 aided the accused number 1 in cheating the publics. That is the allegation. My lord, the accused number 2, my lord, firm by name Shri Sai Net Enterprises Bangalore Private Limited, my lord, as per 36 page ink page, my lord, as per the complaint filed by the ED.
So charge sheet has been laid.
Charge sheet been.
Yes.
My lord, in page ink page 36, my lord, kindly peruse. The accused number 2, Shri Sai Net Enterprises Bangalore Private Limited, represented by its director Srimati R.P. Uma, that is A1, formerly known as Messrs. SS Enterprises, a proprietary ship firm. But initially, the accused number 1 formed a company by name SS Enterprises, a proprietary ship firm, and started the business, my lord. There, this petitioner, accused number 3, was working as a car driver. But in the year 2010, the accused number 2 firm was created as partnership firm. Company. Yes.
Yes.
She Sai Set Net Enterprise. Kindly peruse the predicate offense, my lord, was registered in 2011. That is February 2011. In CC number 34737 of 2011. Initially, crime was registered in crime number 194 of 2011, dated 26/2011.
194 of 2011 on?
On 26/2011. One crime number, sir.
When was the company formed?
Company formed in the 8th month, that is August.
August 2011.
2010.
10. So prior to that.
Within 4 months, the case has been registered against the company's firm, my lord, wherein the petitioner was accused number, petitioner was one of the director as claimed by the respondent. My lord, as per their complaint itself, my lord, none of the witnesses whom they have stated before the ED respondent that they have deposited the amount to the account of Shri Sai Net Private Limited. Only SS Enterprises ಗೆ ಇದು ಮಾಡಿರೋದು, ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದು. Within 4 months after the formation, within 4 to 6 months, my lord, the case has been registered against the petitioner, along with accused number 1. Merely, he has been inducted as director by accused number 1, my lord, without his permission, without his knowledge.
Yes.
And no crime proceeds have been recovered from the accused number 1 as well as accused number 2, my lord. Petitioner ಹತ್ರಂತೂ ಏನು ಇಲ್ವೇ ಇಲ್ಲ.
The firm was converted into a private limited company?
Privately.
Company?
Yes, my lord.
Firm was converted?
Yes, my lord. Upon conversion, my lord, the petitioner was inducted, who was working as car driver.
Unfortunately, you got inducted.
But there is no allegation from any of the witnesses whom they are relied upon that they have deposited the amount to this firm.
That's a defense. You are in a 482, 529.
Yes, my lord, because the trial court has taken the cognizance that there is a sufficient material against the petitioner to proceed with. Hence, the cognizance was taken. But there is no material have been produced by the respondent to show that there is any crime proceeds out of the crime committed by accused number 2 company. ಅವ್ರ ಅಲಿಗೇಷನ್ ಏನಂತಂದ್ರೆ ಗೋಲ್ಡ್ ನ ಪ್ಲೆಡ್ಜ್ ಮಾಡಿದ್ರು ಇನ್ವೆಸ್ಟರ್ಸ್ಗೆ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಹ್ಯಾಸ್ ಗಿವನ್ ಅವರ್ ಗೋಲ್ಡ್ ಟು ಅಕ್ಯೂಸ್ ನಂಬರ್ ದಟ್ ಈಸ್ ದಿಸ್ ಪಿಟಿಷನರ್ to pledge this gold before the pawn shop and secure some amount to return the money to investors. And in fact, the petitioner also joined the accused number one's proprietorship firm as investors. He invested 13 lakhs.
Who invested?
The petitioner himself invested.
To be a
That is
driver.
their case also, not my case. It is the case of.
Claim yourself to be a driver who has invested 13 lakhs.
ಅದು ನಮ್ಮ ಇದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮಾರಾಟ ಮಾಡಿದ್ದೆಲ್ಲನೂ
ಹ್ಮ್.
ಅವರ ತಂದೆ ಮಾರಾಟ ಮಾಡಿ ಅವ್ರಿಗೆ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದು
ಇದೆಲ್ಲ ಡಿಫೆನ್ಸಸ್.
ಅಲ್ಲ ಅದು ಕೇಸ್ ಇಡಿ ಅವ್ರ ಕೇಸೇ ಅದು ಕ್ರೈಮ್ ಪ್ರೊಸೀಡ್ಸೇ ಇಲ್ಲ ಸ್ವಾಮಿ ನಮ್ದು. ನಮ್ಮನ್ ಬಿಟ್ಬಿಡಿ A1 ಹತ್ರನೂ ಇಲ್ಲ A2 ಹತ್ರನೂ ಇಲ್ಲ.
ಸಿಗ್ತಾ ಇಲ್ಲ ಅದು ಬೇರೆ.
ಅಲ್ಲ ಇನ್ಫ್ಯಾಕ್ಟ್
ಏನು
ಇಟ್ ಈಸ್ ದೇರ್ ಕೇಸ್ ಓನ್ಲಿ. ಐ ವಿಲ್ ಟೇಕ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ ಅಟೆನ್ಷನ್ ಟು ಪೇಜ್ ಸಮಿಟ್. ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಒನ್ ಆಫ್ ದಿ ಪರ್ಸನ್ ಹೂ ಹ್ಯಾಸ್ no more, who is no more, that person is the kingpin of the fraud.
Yes.
Page 74, 75 ಅಲ್ಲಿ ಪ್ರೊಸೀಡ್ಸ್ ಸಿಕ್ಕಿಲ್ಲ. ಅವರೇ ಹೇಳ್ತಾರೆ ಅವರು. Though this complaint was filed after 7 years, still they don't have any material.
Yes.
Hence, the trial court has committed a serious error, my lord, in taking cognizance against the petitioner, though there is no material against him.
Yes. Yes, Ms. Madhu.
Lordship, may I, Lordship?
Yes, please.
Lordship, two predicate offences were registered. First predicate offence is 558 of 2011, dated 23/2/2011. My lords may, that is at page number.
First is
58 of 2011.
58 of
dated 23/2/2011. 23/2/2011 in Kengeri Police Station. Para 7 of their own petition.
The other one is 194 on 26.
Please, my lords, please.
Para
7, Lordship, their own petition.
Ink page 7, 6.
Page 7.
6.
No. It's 5. Para 7, page 5.
Yes.
Lords, may I read that para? It stated that here that prior to the initiation of the criminal proceedings against the accused under PMLA Act, some aggrieved persons lodged the first information report in 58 of 2011, dated 23/2/2011 of Kengeri Police Station, punishable under 406/420. Now, therefore, Lordship, after that, Lordship, there's one more offence which got registered in the same, if my lords may come next page. Similarly, another FIR in 194 of 2011, 26/2/2011 of Maikolevat Police Station. Now, both got charge sheeted, Lordship, and the CC number is 28139 of 2011. That was given to CCB. And also the other CC number 34737, that was also given to CCB on 14/10/2011. So based on this, my lords, we registered an ECIR. My lords may, in this same page 5, they have mentioned it. Page 5, para 6, second para in that. ECIR number 7 of 2012, dated 24/4/2012. This was the ECIR which got registered. My lordship, there are four accused which we did in our ECIR. That is Uma Devi A1, A2 that is the firm/company, A3 that is the petitioner driver, that is Mohan Kumar, and lordship A4 is Venkateshwar. These are the four accused which we registered. Yes. Lordship, now, Lordship, with regard to the and this, my lords, the cognizance was taken on this special C, that is the our PMLA offence. Cognizance was taken on 10/1/2020. My lords, may kindly come to page number 74.
Yes.
Para 7. May I, lordship? This is the brief summary of the result of the investigation. If I just may read for the benefit of the court, it's only 2-3 paras. Investigation under PMLA revealed that amount of 30.65 crores was the proceeds of crime generated by the committing and related to the scheduled offences by accused number 1 in the name of the company, accused number 2, that is company, and also with the help of accused number 3 and 4. The investigation further revealed that albeit A2 generated proceeds of crime of the scheduled offences, A2 did not reveal the whereabouts of such proceeds of crime. However, further investigation to ascertain where such proceeds amounted to around 30.65 crores possessed by A1 or A2, A3, A4 by other persons, also whether such proceeds of crime already used, concealed or not laundering purposes. As soon as the whereabouts of such persons proceeds of crime or the equal are known, the complaint department is liable to provisionally attach. That has happened, Lordship. And my lords, the modus operandi, Lordship, if my lords may come to page number 7 of their own petition.
Yes.
Page number 7, Lordship. May I read it? Second para in the start agatado. The complainant charge sheet further discloses that the accused number 1 opened bank accounts and deposited money collected from the public who invested the money in the above scheme. Thus, A1 collected about 30.65 crores by cheating more than 490 members and utilized the said illegal collected money by leading to luxurious life. In the process of inducing the public and collecting the money, accused number 3, petitioner and 4 have colluded with accused number 1. In addition, accused number 1 cheated more than 490 public who invested in her company. Thus, all the accused criminally conspired together and cheated the public for illegal acts. Accordingly, accused number 1 and 2, with the help of 3 and 4, cheated 490 plus 14 investors to the extent of 30.65 crores. This is the sum and effect of the modus operandi with regard to conspiracy and also.
But what is the role of accused number 3?
Accused number 3, Lordship, that is at page number.
All these monies were collected before the company.
Page number 9, Lordship.
Page?
Page 9 of their own petition.
Yes.
During the para 11, during the intervening period between date of appointment and date of resignation, the petitioner was asked to sign some papers as they was needed for the registration of EPF and ECIS. The petitioner was misled. That's what they say, my lords. Then I'll come to the PC.
Your allegation.
Since the signatures were obtained.
That is my contention.
Pertaining to the consent. That's because.
Let him complete. You completed your arguments.
Please, man.
Since those papers on which the signatures were obtained pertaining to his consent to become one of the directors of the company, a private limited company established during the month of 2010.
November 2010.
November 2010. He received correspondence from the Ministry of Finance during the month of.
Net Enterprises came about in November 2010.
Please.
By that time, the complaint was filed in February 2011. Yes.
Please. Now, my lords, 1 minute, I'll check. Page number 39.
39. Yes.
Lords, para 2. And para 4.
Yes. Is 2. Nothing about A3. Nothing about A3 in either of these two paras.
Now, let's. I'll come to page number 47.
47.
Para 12, Roman small 12. That the amount of 13.6 lakh towards purchase of Innova car bearing so and so was given to Mohan Kumar on the bank account of Essential Prices in which he was signatory. Mohan Kumar had purchased the IDs worth 18 lakhs approximately, in lieu of which the amount was given to him as per the instructions of late Umesh Sridhar. Then 14, sorry, apologies. That 177 grams of gold was given to her father at the time of marriage, also at the part of 1770 grams gold received by her from husband. The gold was pledged by Mohan Kumar. That was the modus operandi which they operated in order to get the proceeds of, so free the process of crime. Manapuram Gold. The loan amount was paid to the investors through click-through, and she does not have the details of the investors to whom the amount was returned. Subsequently, due to her and Mohan Kumar's arrest, she said the gold was auctioned. Then thereafter, they told us. And my lords, if my lords were to come to page number 57,
This gold received from her husband has been pledged.
my lord, what they do is, my lords, cash is given, then that is again routed back again to the investors at 18 lakhs. So what they do, my lords, cash is received and that is again invested. So therefore, my lords, in his 650 statement, section 50 statement 57, page number. As my lords are aware, section 50 is in statement admissible in evidence. See, my lords, summons were given. My lords, in this summons, my lords, if my lords were to mark this para C, my lords, the modus operandi of how he himself did the proceeds of, he layered the proceeds of crime is mentioned in CI, the entire thing, lordship. That is about the, lordship, the entire page number 57, 58, 59. Entire thing, he's accepted it. And now, lordship, that is also correspondingly told by A1 also under 50 statement. And thereafter there have been recoveries also. On the precise aspect of role of A3 minutes, page number 79. That give the entire modus operandi.
79.
Page number 79, lordship. That was the statement, lordship. This is the role what we have extracted and put, lordship. Page 79. We have summarized each and every one's role with regard to that, lordship. 79 and 80, the first paragraph, that, lordship. And my lords,
83.
Please. If my lords were to also come to page 107, this is the statement of him again. Page 107, 108, 109. It's precisely on 109. Because there was some purchase of certain car from that proceeds of crime. Now, my lords, in page number 109, my lords, the para number, question number 7, adikina munche salpa, that para. If I may read that para, essence of it. Another issue with regard to the car. On 24/3/2010, I along with Uma Sridhar and Uma Devi proceeds to Ravindra Toyota ISKCON Temple to purchase the car in cash. However, the showroom executive asked me to pay the amount in check. As I was not having the requisite amount in the bank account, later Uma Sridhar took the cash of 11 lakhs from me and asked Uma Devi to issue check of 13.6 lakhs for the fully loaded version of the Innova. Due to end of the financial year 2010-11, the dealer offered discount of 1.35 lakhs, which got refunded to the account of Uma Devi. Therefore, Toyota car was purchased in my name in the year 2010. However, the payment was made by Uma Devi through her personal account maintained in the Indian Bank Kengeri branch. The balance amount of 1.25 handed over to me by grandfather in cash, which was returned to Uma Devi. So there has been link with regard to taking out cash, giving it to him, he purchasing it and layering it. Similarly also happened with regard to gold also.
Yes.
Page number 110. Question number 8. Question number 8. How did you acquire 1770 grams of gold? What is the present status? The gold ornaments belong to Uma Devi since she was in dire need of the money. On a request my mother so and so, and I pledged the said arguments and Manapuram so and so Kengeri in our names and handed over the said cash to so and so. Now, my lords, there are evidences to prove on record after the section 50 statement has been taken, corroborating it. Now, my only submission before this honorable court is section 50 statement admissible. Settled law, my lords, is admissible in evidence. Uma Devi has also given statement which is admissible in evidence. Admittedly, they have not contradicted the statement till now. They have not controverted it. They have not retracted it. As of now, section 50 statement stands. Having that section 50 stands as of now, they having not controverted it, it becomes a matter of evidence. Therefore, my lords, even on that point, even if it not going further, that becomes a point which needs to be cross-examined in the matter of trial. In fact, my lords, in one of the judgments of the
whichever judgment you give us, we look one of Allah.
I'll give it.
So you give us only.
My lords, my only submission, my lords, is, my lords, if my lords come to on certain point principles of law, lordship, section 50 statement, my lords are aware, admissible in evidence, settled law. My lords may kindly see section 24, burden of proof.
Reverse burden.
Reverse burden, lordship. My lords, they have the section 24, lordship.
Evidence.
24. PMLA. Section 24, lordship.
Yes.
In any proceedings relating to proceeds of crime under this act, in case of a person charged with offense of money laundering under section 3, that has happened now, the authority or the court shall, unless contrary is proved, presume that the proceeds of crime are involved in money laundering. Therefore, my lord, there is a presumption now that this money is tainted money. Now, my lords, section 50 is admissible in evidence. And my lords, even section 22. Section 22. Presumption as to records or property in certain cases, where any records or property or is found in possession or control of any person in the course of any survey or search, any record or property produced by any person or assumed or seized from the custody or of the person has been frozen under the time being, it shall be presumed that.
So whatever you seized from accused number 3?
The car.
Only the car.
No, my lord.
The gold.
Gold is gone.
Action
My lord, no, auction, that's it. The point is, when there is a presumption which is inbuilt, it becomes, the onus turns on them to prove before a trial court to counter their own statement.
Yes, otherwise he's saying the gold is belonging to
No,
accused number
that my lords is again a disputed. If my lords, if I want to go into that,
accused number 1 also claims it is hers.
No, my lords, that accused number 1, my lords, I must say that my lords, she is absconding now, my lords.
So you want
but only accused number 3.
My only submission, lordship, is.
But was he actually the?
Yeah, it is. I go as per the complaint, lordship. I only can go as per the complaint. Lords, my only submission is there's an appreciation of evidence now. Now, my lords are aware, I don't want to give so many judgments. Appreciation of evidence, my lords, let them go before the court, and after they are at liberty to file a discharge application before the trial court. I'm only seeking for that.
Taking cognizance.
So cognizance is only on the aspect of prima facie whether the offense exists or not.
Entities are all different. SS Enterprises was a proprietary concern. The proprietary concern.
No, but he was the director.
SS Enterprises.
The proprietor.
SS.net. Sri Sai Net Enterprises is a private limited company. All the payments were received through SS Enterprises, a proprietary concern. There is no money which you have said is received by Sri Sai Net Enterprises.
So, he was made a director in that. If
is there any amount? So far, what we have seen, all the monies have gone to SS Enterprises.
So, my lords, this is a way of camouflaging that.
Show us any money going into Sri Sai Net Enterprises.
That was one of the reasons why they converted into a private limited company.
Show us any money going there.
Because that I need to show the records.
Easy for you to say.
Then I'll have to show. As of now, my lords, if I may say,
your entire statement here at page, where is that? Page 50.
Page number?
49 onwards is about the payments coming in.
Yes.
All of it by cash and or RTGS have gone into SS Enterprises. There's no amount of money in this 6 pages which indicates any money to SS Sri Sai Net Enterprises.
May I for a moment? Page number 117.
17.
Admittedly, page 117.
Yes.
Admittedly, he is a director of that company. Now, why was there a director of company? Because all the assets and liabilities of the firm gets transferred to the company.
Is it a Chapter 9 company? Is it
No,
a
normal private limited company.
So where
It's
is
a
the transfer?
regular private limited company which has been formed.
Where is the transfer? Show us any transfer and
Then I have to bring the
you
entire
have to show.
records. Lordship. I will show it.
because as of now, there's nothing.
No, because only the charge sheet has been filed.
He was a driver. If he's been given one car
And he has
to make him happy. If there's a fund which has gone into the account when he was a director, you place it on record that he has got any benefit out of it. And if funds have gone to him, what are those funds? As regards A1 and A4, the allegations which are made. Why is he a A3 without much?
That's
is the question.
my statement of objections, page 13.
Page.
Page 13, para 30. May I read that, Lordship? That was what they were telling, that no metal was shown. The enforcement complaint contains specific documentary and statement-based material establishing that A3 knowingly assisted A1 in laundering the proceeds of crime. The directorate records that A3 was appointed director of so-and-so in 2010 and actively managed its business along with A1, at point of time. A3 received 13.6 lakhs from A1's firm for purchase of an Innova car. That my lord said. A3 and his family pledged the gold ornaments with Manapuram and handed over the loan. That is also there. That evidence is there. A3 purchased more than 110 IDs in A1's click-through network scheme by surrendering his own and his father's insurance policies with so-and-so.
He is the investor.
No, but then the point is, my lords, once it is a proceeds of crime which gets layered.
This 13.8 lakhs, actually he has lost money.
No, lords, that is the cash which was given, lordship. To that extent, the cash was given. What happens, lordship, in these cases, they will withdraw the cash. And my lords, in order to camouflage the transaction, my lords, they make up online payment.
Otherwise, you may be right. In this case, he has surrendered the insurance policy, got 13.8 lakhs. And because A1 was running this pyramid Ponzi scheme, he also was dragged into it and he has invested 13.8.
I have a different opinion on that, lordship. The reason is, lordship, they would have got, they get cash, lordship.
Albarang, why should he sell his?
Because to
show us what money has gone into. Simple two questions. Sai net. What is the money which has gone in from SS Enterprises? Number one. Number two, what is the money that have gone into the petition? These two, if you show us any money, then we'll dismiss it. But if there's no money, then
my only submission, dehorse that, lordship. Dehorse that. My only submission is
to be proceeds.
No, my lords, dehorse that, lordship.
Yes.
As of today, lordship, my only submission. Section 50 statement is admissible, lordship.
There's nothing in that
also. No, my lords, they have not contradicted their own statement. They are bound by that statement.
There's nothing in that statement also. He's only saying that that car was purchased. He did not have the money. The money was given. And he pledged the gold. That's all. Nothing more.
No, my lords, that evidence is.
It is not related to the predicate offense.
No, my lords, the layering that is what he has done, because his role is layering the transactions.
After arguing for some time, Learned Counsel for respondent seeks fund is granted a week's time.
Please.
To make a submission as regard the transfer of monies from SS Enterprises to
Sri Sai Net.
Sri Sai Net Enterprises, Bangalore Private Limited, and or any transfer of the proceeds of crime to the account or otherwise of accused number 3.
That's all.
Relist on
next week.
5th, 6th?
5th one.
5th, I have some.
Yavatedi.
Otherwise, after next week, coming Monday also.
11th, 12th.
Please.
11th.
Please.
That's all.
Serial number 3, M.R. Vijay Kumar.
This was for furthering, it has not come up only. We have heard you.
Basement.
There is nothing more to be heard. Heard, reserved.
I have
filed wakalat in this matter, my lords.
For whom?
My name,
Actually,
respondent number 1.
Vipin Hegde he left the case of my lordship.
We have heard him now. You want to make any submissions?
My lords, not today, my lords, because his name was shown instead of my name, my lords. My name may be shown.
Then we'll have to hear you. If we
Next
change
week,
the name, because what we have recorded is all his hearing, arguments.
Submission, my lords. It was not, my name itself is not shown in the cause list.
I thought I will show your name now.
Yes, my lords.
But
Next week.
do you want to make any submissions?
My lords, next week, my lords.
So want to submit that you would be appearing for respond number 1. But the earlier submission will attribute to Mr. Vipin Hegde. Later submission will attribute to you. Don't argue everything. In the registry that delete the name of Sri Vipin Hegde and print the name of Sri so and so as that appearing for respond number 1. Relist on, when will you get ready?
My lords, next week, any day, my lords.
19th August.
Serial number 4,
Grateful manage.
E.A. Hanumantraya.
My name may be
party
deleted.
person.
Grateful.
Is discharge and right?
Yeah, please.
Yes. Jafar, who is appearing in this? 4.
E.A. Hanumantraya.
ಏನಾಯ್ತು? He's coming for this matter only from Chikbadapur.
Document was supposed to be given by the government advocate, my lords. It was a direction.
You are appearing for whom?
R1, my lords, for commissions.
For the commission. No, he has to make some. Pass over.
Serial number 5, I.S. Devaya.
This matter, Lord had asked me a question to say whether those particular treatments relate to chemotherapy. So I had sought for information from them. The TPA has given me, I'm sorry, I have to furnish it in this. Communication by the TPA, that is Medi-Assist. Unfortunately, they're not represented in the matter. They say that these two are hormone therapies related to treat conditions like this. They're not chemotherapies. They are certain hormone therapies.
Ask you both the question. Is it for prostate cancer?
Correct.
And is it, or for chemotherapy?
Correct. It is not
They
for,
say it is for prostate cancer.
it seems to be for prostate cancer when it affects the bones and other parts. It is used for that. The only reason when I again asked the insurance company, my lord, as to whether this, why was the cover not provided? Their contention is, my lord, these are based largely upon, if I just place this, my lord, I will not fight on this matter.
So your stand doesn't change.
No, I'll just explain, my lord, and I will leave it to my lords. The reason being, another point that my learned friend had raised was that subsequent claims have been admitted.
Prior claims.
My lord,
Prior claims were admitted after transfer to you. You are
prior
not
claims were admitted. As a matter of fact, my learned friend, though he's not there, he had said, and I concede that subsequent claims also admitted. The reason for that being that the policy, the terms had changed. I have placed, my lord, before, my lord, the clause 3.2. This is as per the present as per the policy which covered the respondent. Subsequently, what happened, my lord, was certain targeted therapies were added. This is the subsequent policy. That is the reason why I'm bringing this, my lord, is because chemotherapy and certain subsequent targeted therapies were treated differently. So how this works is, my lord, if I may just give us,
Where is that?
my
item
lord, point number 20. My lord will see point number 20 in the document of 23-24. Those were approved targeted therapies for treatment of cancer in daycare and on standalone basis. So what happened was, when the respondent was covered in the year 2021, the IBA, these are, my lord, retiree policies for IBAs, large group mediclaim policies by the Indian Bank Association. They floated a tender. We were based on their requirements, and therefore we provided the services for a certain agreed premium for covering certain requirements which the IBA had provided to us. Thereafter, in 23-24, a fresh tender was floated where the IBA had requested even covering of point number 20, that is approved therapies. So there we have paid him out for even for these hormone therapies. But unfortunately, in 21-22, that cover was not availed. Premium was not paid for that cover. That is the reason why 21-22 we could not pay it. All subsequent payments have been made. And as a matter of fact,
Introduction is only immunotherapy.
that immunotherapy and the other therapies, that is approved targeted therapies.
for treatment of on a
Cancer-related,
standalone basis. Third bracket, immunotherapy, monoclonal
antibody cancer
on a
treatments.
standalone basis.
And which we have paid him off also. He's, as my learned,
Here it is different. It is
this was
hormone treatment for
hormone treatments. These are hormone treatments. As a matter of fact,
long-acting hormone therapy used to treat hormone-sensitive conditions like prostate cancer.
So when-
Zexava is for targeting and neutralizing specific protein that activate osteoclasts.
So when the cancer cells affect the bones, these two treatments ensure that they don't affect the tissue and the bones. That is the basics.
Zexava is because of chemotherapy affects the bones.
My lord, yes.
So for that,
The cancer, I will say that it relates to prostate cancer. I will not fight on that aspect, my lord. The only reason I would place before my lord is it was not
distinction you are
covered.
drawing is between these two policies.
Those two policies, it was not covered under the earlier policy. They requested for it later in 23-24 it was covered. So all his claims subsequent to that have been paid out. Unfortunately, it was not available under the earlier 21-22 cover, which is why the insurance.
What do you want now? You want to invite an order from us, or what do you want to do?
Lord, I've requested them for if they can be consider it. But the problem is, Lord, they have 25 lakh insureds. Now, if one has if they have to cover one, there'll be multiple. It'll open a floodgates for them.
Once we pass an order, it may open a floodgate for
That is the reason, my
much
lord.
more.
The only my request is, my lord, let it be. If my lord may consider sending it to the local adalat, at least they can adjudicate on this point. Unfortunately, there has been no adjudication.
This is not required to send there. It is up to you to make this one. If you are willing to pay, we won't pass any order. Otherwise, we have expressed our opinion on this.
My lord, I'll
Even
make
this
another
is-
attempt, my lord, in that by explaining it to them. The only problem is they have this. I concede. I will not argue this.
Heard, reserved. If you have any change, next week you tell us.
Great.
Serial number 6, Manjunatha LS, connected matters.
Yes, ಏನಾಯ್ತು?
Nothing.
ಏನಾಯ್ತಮ್ಮ?
ಏನು ಆಗಲಿಲ್ಲ.
ಏನು ಆಗಿಲ್ಲ, ಅವರು ಯಾವುದು ಕರೆದೂ ಇಲ್ಲ.
ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮುಗಿಸಿ.
My prayer with respect to it's an interim stay granted by the registrar, district registrar, not to function for the status movement, not to make any new membership with the association.
Saying that you are going to settle. If you settle well and good, we are always open for that. If nothing has happened, then you argue the matter so that we can finish it.
It may
And keep it pending.
ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ಸ್ ಮಾಡಿ ಅಷ್ಟೇ ಸಾಕು.
Who appears for the respondents?
I am respondent in.
ಏನೆಲ್ಲ ಬರೋರೆಲ್ಲ ಯಾರು ಇಲ್ಲ.
I am the petition. I am for the petition in 27952.
Yes.
My prayer is with respect to the impugned order passed by the district registrar.
Paso, ನೋಡೋಣ ಬರ್ತಾರೆ. We'll fix a date for all of you to get ready and argue.
Short accommodation.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಅಂತಲ್ಲ, get ready and address arguments.
Short accommodation.
Short accommodation, but after that, no accommodation.
I'll come.
Well, last 4 adjournments have been on settlement. Can't be dragging the matter like that. Settlement ಏನಿಲ್ಲ, will record that, alva?
Next week I'll kindly one short accommodation.
ಇಲ್ಲ ಸೆಟ್ಲ್ಮೆಂಟ್ಗೆ ತಾವು ಹೇಳಿದಾಗೆ ಸೆಟ್ಲ್ಮೆಂಟ್ ನೋ ಸೆಟ್ಲ್ಮೆಂಟ್ ಡೈರೆಕ್ಟ್ ವಿ ಆರ್ ರೆಡಿ ಟು ಆರ್ಗ್ಯೂ ದಿ ಮ್ಯಾಟರ್ ದಟ್ಸ್ ಆನ್ ದ ಫೈನಲ್ ಡೇಟ್.
All the councils submit that there is no settlement which has been arrived at between the parties. If that be so, it is for the respective councils to get ready and address their arguments. Relist on 11th August at 2:30 p.m. It's made clear that no further adjournment would be granted.
Much obliged.
The respective councils to file their respective synopsis of dates and events, list of authorities, as well as synopsis of arguments after exchanging same with each other before that date.
Much obliged.
Much.
Serial number 7, Parvez Ahmad.
Lord, I have filed this petition seeking a direction from this court to fertilize the eggs and sperms which are there in the seventh respondent's IVF clinic. That is the prayer which I have sought. Lord, before I get into the prayer.
Just one. The husband is respondent number 6.
Yes, ma'am.
I'm for respondent number.
You are for respondent number 6. This you are for union.
Union minutes.
2 to 5 AG.
Only one. Only respondent 1.
6 is there. And 7 is a formal party. Yes.
But what has happened is both me and the seventh respondent have been previously married. 6th respondent have been previously married. And the 6th respondent from the previously
married to someone else.
To somebody else and divorced and remarried. So
Yes.
it is the second marriage for both of us.
Yes.
Now what has happened here is the 6th respondent already has a child from the previous marriage. And I am childless. But after marriage, we tried to have a child, it didn't happen. Then we sought artificial
IVF.
assistance, IVF. Many IVF have gone. In between, a lot of IVF, close to about 7 to 8 and plus more undergoing. In between, a dispute has started between me and husband. We became estranged. Now the problem here is, my lord, we also sought adoption in the interim. Our application, annexure E, my lord, we have sought for adoption as another measure to welcome a child. But the problem here is, even after that, the 7th respondent has created circumstances, 6th respondent has created circumstances where we got separated. He tried to throw me out, and there are a lot of cases which are there.
Don't get into allegations right now.
No, my lord, I withdraw.
You get into allegations.
No, I am just giving a little
not
bit
be
of.
able to get you together.
No, I am getting a little bit. Now, why I am before the court is, my eggs and the sperm are with the 6th respondent. 7th respondent. Now, what has happened here is, I am impaired by the fact that without his consent, I cannot get them fertilized and move ahead. What was the initial?
You will have no claim for any property or any other right.
My lord?
You will not have any claim against respondent number 6 for any property or any
Yes.
right, maintenance or otherwise.
My lord, yes.
You won't have any claim whatsoever.
For the child will not have a claim.
For yourself?
Myself, we are married. Our marriage is not dissolved. The divorce has been filed, which is pending, my lord.
Why didn't you try and resolve both the issues?
We tried, my lord, we tried.
Where is
Now,
it?
we tried a lot of mediation.
Mediation has happened?
Mediation, we tried in the family court. It has not hurt. The main problem what we are facing here is, you give me a divorce, I will give you NOC.
So where are you stuck?
We are stuck because the biological clock is ticking.
That is different.
Yes,
where are you
ma'am.
stuck in the divorce?
No, it is just the first stage. We have to. I mean, they filed for divorce after all the other cases have been filed and litigated. They filed for divorce, and the matter is right now for objections.
So are you willing for a divorce?
No, my lord. Right now, the question before the court and me here is, I want, by the time the divorce proceedings goes on, I might lose my last chance.
Consider before you start argument.
Yes, my lord.
Because once you start argument and once we hear, then the question of reproachment and all those things in these matters don't happen. So you want to try closure as this also being part of it, or this you want to consider to be standalone and argue this matter. That's your choice.
My lord, right now, my mind is so, this one perplexed with all the problems that I'm having with being childless, is that right now I'm not thinking of anything but to have the child. At least let the embryo be fertilized and even frozen till the divorce. That also is an option open to me.
Then the time is not essence.
Time is the essence, my lord.
Not
That
the
is
essence.
the reason, because we have been held at knife point to say that either you give me divorce or NOC. I am impaired. I cannot have a donor. I cannot use the sperm because of the consent as per the law.
That's why we are telling you.
The consent is a valid point.
That is why we are.
Yes, that's why I have
We
come
don't
before
want to
the court,
express
my lord,
anything
because
right
it
now.
is against, he already has a child. I don't have.
Can this court force a person to give any consent?
No, man.
Yeah.
Because I am here asking whether this particular case should be a precedent wherein my right to have a child should be considered, my lord. My right to have a child, he already has a child. I cannot have. To have a child, do I have to give a divorce?
He is not objecting to your having a child. He is objecting to having a child with him. There's
Yes, my
a
lord.
distinction there.
Then let him give me a NOC. I will take another donor and have a child in the interim. At least let the child be, because even his sperm quality is very less.
On that you can argue.
Yes, my lord.
Yes, argue.
Yes, my lord.
Yes.
The Assisted Reproductive Technology Regulation Act, there were certain objectives why it was made.
No, just Act 11. Anybody has an extra copy?
The Act copy, I have it online. Yeah, my lord.
You have extra copy?
I have it on. First. Objectives. Objective. Look, the objective is very clear, my lord. Act for the regulation and supervision of assisted reproductive technology clinics. The main objective of this act is for welfare of women and children, to protect them and to see what the intent of the legislation
Which item
is.
are you reading? Which paragraph are you reading?
The first objective, my lord.
Which objective are you reading? Regulate to need to regulate
Index.
ART proposed legislation. What is D? 5D is what you're
5D, my lord. Don't do this. I don't have it online.
D. You can take back your go.
Yes, my lord. I take back.
Idralli.
I have noted it. I'm sorry.
This doesn't.
The Art Act, statement of objective and reasons.
Yes.
Assisted reproductive technology has grown leaps and bounds in the last few years. India has the largest growth in art centers and number of art cycles performed. Assisted reproductive technology, including, has also a plethora, a hope to multitude of persons suffering from infertility. But it has also introduced a plethora of legal, ethical, and social issues. This act has, after enactment, introduced a lot of legal and social issues. And this case before your lordship is a legal and social issue
Yes.
together. So the intent of the legislation was to ensure that this act would try and resolve all legal issues. But as every act, this act is also dynamic. Different issues come before the court with respect to interpretation of this act and also the practicality of this act. My lord, where there is no consent in a case like this, wherein both the husband and wife are
Take
estranged.
us to the provisions.
Yes, my lord.
Please. Which provision do you want to refer to?
22, my lord.
20.
Section 22.
Yes.
The clinic shall not perform any treatment or procedure without the written informed consent of all parties seeking assisted reproductive technology. My lord, there are two ways to this, my lord. By giving the sperm, it is an implied consent to go through IVF. Initially, when the sperm was given in the bank. Thereafter, they became an estranged couple.
Yes.
The implied consent for to have a child was there. Now this consent has been withdrawn.
Yes.
Thus, this consent which was implied and given before, withdrawn, and is stopping me from having a child, which is totally against my right of motherhood, my lord. If he is unwilling to give his consent, I may be allowed to take another donor.
And what provision are you?
My lord, there is no provision, my lord, here. With respect to this case, that's why I said it is a legal and a social issue, my lord.
What do you have to say about 2S? That is for surrogacy.
Yes, my lord. My lord, I am capable of still having a child, my lord. I would not seek surrogacy. I have also sought adoption also, my lord.
So you are willing for a
Six
donor.
IVFs we have
You are
undergone.
willing
my
for
lord.
a donor.
Donor, my lord.
Anyone else also is fine.
Anyone else also, my lord. We have explored even adoption, my lord.
So in that case, do you need consent?
I don't need consent, my lord, if a donor is there. If he is unwilling to give a consent, let me be allowed to take a donor.
What's the provision for it?
My lord, there is no
Because if you argue
provision.
like
There is
this,
no
we
provision
can't-
stopping me also, my lord.
You have to interpret something.
My
There are
lord,
various
I
provisions.
have gone through this, my lord. That's why I said it's a social and a legal issue.
Yes.
Reserved for interpretation, my lord.
Your lordship, sleep, please.
Yes.
Lords, Section 22 subclause 4 is very clear, please. It says that any commissioning couple may withdraw with or without
Section?
with his or her consent. under
Which section
1.
are you? Which section are you referring to?
Please. Section 22 subclause 4, please.
22.
Subclause 4.
Yes.
Any commissioning couple may withdraw his or her consent under subsection 1 anytime before the human embryos or gametes are transferred to the concerned woman's uterus. So it's very clear I can withdraw it at any time before it is withdrawn. Now please not, if your lordships were to look at the writ petition itself, what they are challenging is this particular section. They have nowhere made a mention that they want a NOC from you. It is not within the grounds, or neither they have urged anywhere in the writ petition.
That they can always file amendment application. Now the simple question from what Mr. Parvez says is your divorce can go on, you may be fighting wherever, for however long you want to fight. Now that you want a divorce, not that she wants a divorce, you want a divorce. How do you stop her from having a child from a donor, from a third party?
Millards, the only concern is if there is now there is a wedlock. If a child is born out of the wedlock, the maintenance of that child also please.
That's why we ask them. No maintenance, nothing. They're not going to ask you for anything.
Not asking for that, my lord. For the child, we don't want
Anything from you.
If they are ready to give undertaking, please not. Then
Yes, my lord.
I'll just concur with my client, please not. And that can be done.
Even with your sperm, they're not going to ask you anything. Somebody else's sperm also, they're not going to ask anything.
Please not. Let me concur with my client, please not. I may be allowed either given a date, please not, or he's here only. A few moments may be given. I'll concur with him and I'll come back.
Would you have any problem with that?
Millards, now the only category of people who are eligible under art is one commissioning couple, Millards, and I think one single woman. Only two category of people. Now commissioning couple means, my lords may see 2E, my lords, definition 2E.
Yes.
Let's got it. Commissioning couple means an infertile married couple who approach an assisted reproductive technology clinic or assisted reproductive technology bank for obtaining the services authorized of the said clinic or bank. Now they have already approached as a commissioning couple. Now I leave it to your lordship that if their marriage is still subsisting, divorce has not come through, then she does not become eligible is my submission, my lords. Again, I leave it to my lords.
See, this are, as Mr. Parvez said, these are not purely legal. We can't look at it technically.
My lords,
We'll have to look
they'll
at
be
it
traveling outside the scope of the act, my lords.
socially also. Now, if a woman above the age of 21 years approaches the ART or Assisted Reproductive Technology Bank for obtaining authorized services, a woman who is not married can also approach.
That is under Surrogacy Act, a single woman is defined.
Correct.
Single woman means one who's divorced, widow, or no, not unmarried. Unmarried is not included at all in a
So
single
now,
woman.
divorced woman
Divorce or widow, my lords.
or widow is included. Now, here is a situation where the divorce petition has been filed by the husband.
Yes, my lords.
She is fighting not to give the divorce.
My lords, I agree.
Wants a divorce.
My lords, I agree. I will agree to it that they're still husband and wife in the eyes of law. But I'm not sure if the embryo can be freezed without the husband's. My lords.
That is why we have two options here.
My lords, third
We
party.
we need to solve the situations. These are problems which come up. How do we solve
Not
those
operate
problems?
as a precedent and.
will-
Well, it's because it is made with a certain object, my lords.
The object is what? For the citizens.
Well, it's for
And
the
if-
welfare of the child also.
If the mother can take that assessment would have to be made in terms of income, etc. We'll have to see that. All those aspects will come about. Not that they won't come about. The first issue is if the husband now consents, you can't have any problem, irrespective of anything. Now, if he doesn't consent, then it would have to be a third party donor.
Milad, she's asking for both. She wants the marriage also and a donor, Milad. That is not contemplated, Milad.
Yes,
Now,
but
there must be a power under which it
our
can be
system, how
granted.
long a divorce matter takes.
Milad, I understand.
Can she wait for that long a period?
Milad, I totally understand that there is a very urgent requirement, Milad. But it's just that it should be backed by some provision of the statute, Milad.
Or interpretation
Because
of law.
because the baby which is born, Millards, it has to be, Millards, there must be a magistrate order saying that so and so is a parent and all. And the magistrate will not have power if at all they don't go strictly by the act. So all that issues will arise. I'm just putting forth.
You sit between them and sort out their marital problems.
Millards, can ASG answer this, Millards, please?
Please, we'd prefer that also. There, these are these are newer technologies which keep coming in. There are newer issues. Some of the things would not have been considered. New issues keep on coming up. How do we solve that as you on a policy level or as an interpretative level? Either of these things we'll have to try and solve the problem and give them some recourse where they are not at fault. She is not at fault. There's a dispute which has arisen.
Millards, obviously we
And
cannot
after having
enact
gone through
laws.
6
based on-
IVF treatments,
That's sufficient response. Then please give whatever proposal they have for undertaking. Just concur with my client and I will come back. A short date may be given.
basic thing, you are not going to seek for any maintenance
For the child.
for the child. And we'll make it an order that
And the property rights also.
property rights won't be available
Yes,
as
my lord. I
succession
may be
rights.
allowed to take a donor, my lord.
As succession rights.
Yes,
They are considering even the first one.
yes, my lord. No, in the absence of that,
If they consider the first option, then Ms. Desai will not have any issue.
no, my lord, let there be this one option. I mean, if either this or that, my lord.
The second option, ASG will address arguments. So that's the next stage.
So this is a social and legal issue, as I told this court.
But as submitted by Ms. Desai, we need to see that it is as per the applicable law and how it will fit in.
Yes.
It can't be completely.
I'm not asking anything away from my rights, my lord.
Where is that right which is not
It
there
is
in this
not
book?
enumerated here, but this is a
There-
dynamic act, my lord. The act needs to be dynamic.
This dynamic act does not say that they have the
Many boards
discretion or we
and
have.
committees constituted for this.
Don't put it at that.
Yes, my lord.
Look at it.
We'll work something out, my lord.
Put it in a proper way.
Yes, my lord.
See how any provision can come to your rescue.
Yes, my lord.
Whether it's the Surrogacy Act and 222,
Yes.
or this, which will come to your rescue, you need to look at.
Yes, my lord. We
Maybe
will.
the ART will not come to your rescue without their consent.
Yes, my lord.
If they consent, well and good. If they don't consent, which act will you go under?
Yes, my lord. A date may be given.
So let them share the proposal, please.
Discuss, have coffee
We'll
between
sit, have
yourself
coffee and discuss, Mr. Chairman.
Hello, both of you discuss.
A date may be fixed.
When will you?
18th, my lord.
Anytime next week.
18th, next week
Not
also.
next week.
Next week also.
Sometime second week of next month, August, my lords.
18th, so
11th August?
11th, please.
11th.
11th
Yes.
August. At 2:30 p.m.
Grateful.
Serial number 8, yes, Rajshekar.
It's a case where, my lords, migration
How
of
many cards did you have? Or do
Lords,
you
sir.
have?
last time order may kindly be seen.
Yes. Interim order
required to
granted.
produce the-
AGF for entire
To
file.
get the entire file, Madam. I request for a week's accommodation. Or Russia may kindly have it on
He's
Monday.
finished his exams and come here to argue.
My lord, I would like
Morning
to
he went and
submit,
wrote his exams.
my lord, I would like to submit list of events, my lord. It is,
Without that file, we can't look at it.
my lord, it is everything in my pleading application, my lord.
That
We
itself
need to
speaks
see the
volumes, my
original
lords.
file. We need to see the original file.
So I had requested, my lord, they have to come from Mangalore. Apparently the officer is on one of this. Everybody says
When
yes.
will
sir.
you get the file?
The latest is Friday, my lord. Friday. Your lordship will have it on Friday.
Relist on Friday.
Friday,
Any
Friday.
exams that day?
This Friday, my lord.
Huh.
Yes, I have my exam.
Afternoon you can come or we'll have it on another day?
After August, first week, anytime. August first, second, any-
First week.
Yeah, when
Then
will
your
your
lordship
exams
may
get
kindly
over?
have it on
Sorry, my
13th.
lord.
When will your exams get over?
31st.
31st.
31st
Then,
of July.
have it on 6th.
So the lordship may kindly have it.
ಏನಪ್ಪ?
Some inconvenience.
When, no, you know the facts, so when will you be there?
13th, my lord.
13th.
13th.
My lord, I would like to make two important submissions.
We'll hear you together, not in piecemeal. You give
Like to
that
submit
memo.
list of events.
The respondent,
Topic.
number 5 party in person has filed a memo with synopsis of date. The same is taken on record. And AGA seeks for and is granted 10 days time to comply with the order dated 27/26 and keep the original file present. Relist on 13th.
13th.
13th at 2:30 p.m.
Interim order.
Interim order earlier granted is extended till next date of hearing.
Please.
Serial number 9,
Okay.
Vinay M.
9, my lords, yesterday's matter, my lords.
Clerks Association.
Clerks Association matter.
Hmm?
Clerks Association matter.
ಏನಾಯ್ತು?
Lords, yesterday, my lords, the committee of members, lords, associations, my lords, committee members have held a meeting yesterday. They have decided to, my lords, hold AGM on, my lords, 28th of this month itself, August 28th, because 21 days notice is, my lords, mandate. They have to, my lords, finalize. There are, my lords, about more than 50% of, my lords, members are defaulters. And they have to collect that and, my lords, finalize the
First, you have to make every clerk in the state of Karnataka a member.
We have decided to convene the meeting on 28th of August.
Not, can I make a request? Not let an administrator be appointed and let not the administrator conduct elections through the registrar. Not, we have no faith in them. For 13 long years, they've just continued not with this. Now, not to say, not even the meetings that they hold, not a lot of people not are not enrolled as members. And not person who has become a lawyer, his name is shown in the list, and as though he has signed. Not he has given a letter
But,
also
sir,
saying that you have forged my signature in the document. Therefore, not we have no
But it is-
faith
it
in
is
them.
not in this
I'm
case,
not.
my
It is
lords,
not as one. It's not as though not they have no funds to conduct elections. I'm told not even not multi number of times.
We are giving them a lot of funds.
Yes, ma'am. Not the courts have given. I would request not let an administrator be appointed, because not the order that was passed directing them to hold election, not was passed long ago, not now. Lords see not the order that was passed, not annexure E, if my lords would see, it is 13/6/2025. It's been 1 year after that. And not, they have not, because not I raised this issue, not I've been suspended. If not, I would request not,
See to that it will get done, don't worry.
let it be conducted not by the,
Lords, this order came to be passed on 13/6/2020.
Why do you need a AGM for it?
My lords, now to hold elections, my lords, and to even regularize the, my lords, members.
You have to invite applications.
Yes.
Let them be members, that's all.
My lords,
Why do you need a
membership
AGM
process,
for it?
membership process we have commenced, my lords. I have the list also. Applications we have, my lords, and also we have this.
Where is the publication that you have made?
My lords, publication, now application we have, my lords, from through the process of High Court, my
Where is
lords.
the publication that you have made across the state? Have you sent it to all the advocates associations?
No, my lords.
Have you sent it?
Across the state, we have not issued, my lords, across the state. Not yet.
Then where is your bona fides?
Lords, now. Lords, now may I request my lords to kindly see.
AGM is not required, Mr. Achikar. If you are reasonable and you establish your bona fides, we are not going to appoint administrator.
Lords,
But as indicated, you have not held elections is a good enough reason for 27A 1A to apply.
my lords, may I submit this, my lords. Now the order at annexure E came to be passed on 13/6/2020. But subsequently, my lords, we have convened the AGM, my lords, and we have decided, my lords, I have read it over, my lords, yesterday. Till, my lords, that was on 2/8/2025. This particular resolution, my lords, is still, as on today, my lords, nobody has challenged this resolution. Passed on 2/8/2025. The contention.
Keep passing any resolution. There's
Lords,
already an order. That order is final.
Now, that order is passed by, my lords, the district registrar, my lords, directing us to hold the election.
Certain finality.
My lords, that no doubt, my lords. Thereafter, my lords, we have convened the meeting also, my lords. So with regard to one of the agenda was to hold elections. And there, my lords, the measure, of course, my lords, the number of the members who were present, my lords, they have decided, my lords,
To extend it by 5 years.
now, my lords, till that welfare fund issue is, my lords,
Yes. Heard reserved.
pending, my lords.
We'll appoint an administrator.
Lords, now may I
Yeah.
request this, my lords. Now my instructions are, my lords, they have decided to may pass on this one particular, my lords, letter what we have received from the High Court, my lords, registry.
Copy ಕೊಡಿ.
With regard to, my lords, issuance of ID card, the process is also on, my lords.
To whom? To only you people?
To the members, my lords, present members.
whom?
There are about 411 members, my lords, as on today, out of which, my lords, 15 are no more.
For the institution.
Yes, my lords, yes. No doubt, my lords, I am also.
Everybody should get the benefit of
Yes,
it.
yes.
Each and every clerk, with whatever we are doing, we are training the clerks for e-filing, we are training them for so many things. And if they are going to be excluded because of a few people sitting there,
No, my
it
lords, now
doesn't work.
may I submit this? My lords, though, my lords, during COVID-19, my lords, a decision was taken to, my lords, extend the financial, my lords, help to the members. Though, my lords, some of the members who have not paid the, my lords, membership fee, we have extended the benefit also to them as well, my lords. There is no
Because
dispute.
the funds given by whom?
My lords, from the government as well as, my lords, the cost
Not
imposed
from your pocket. So
Now, my
please
lords,
don't try to make it as if you have done something.
no, I'm not.
What
Now-
your existing committee is doing is not correct.
Lords, that is the reason why, my lords, in fact, we have decided to convene the AGM also, my lords, on
Not
20
necessary. We'll
my lords,
convene
on
what is
28th of
reserved.
one more issue.
Give you an option to
Yes,
be
my lords.
fair, reasonable and come forward. to
That
the-
is why, my lords, from yesterday itself, we have convened the meeting also, my lords.
Not reasonable.
Emergent meeting also we have held yesterday itself, my lords.
Not reasonable. What we'll direct is appointment of a
Now, my lords, the
administrator.
appointment of
You
administrator.
will invite applications for
Yes,
clerks from
across
all over
across the
the state,
state, my lord.
make them members and then conduct.
There is a parameter as per their bylaws saying anybody who gets a certificate from advocate who has been practicing for past 10 years, serving him as a clerk, that person is eligible to be a member of the clerk association. Subsequently, they will follow all the bylaws. Let the administrator go ahead with
So the bylaws you follow.
Yes, As far
Don't
the
have time to dictate, otherwise
Yes,
you would have dictated it now.
very well, very
My
well.
lord, I have a
But
small
the-
request, my lord, to implead HPCL as a party in this, my lord. Because petitioner relies on the unified guidelines.
Some other matter. You want HPCL to come and clutch. You file an application.
Sorry, man.
You
Lords,
file
it
an
is my
application if you
petition, my
file.
lords, he wants to implement somebody
Not
else.
in
my
your.
lord. No, in serial number 8, my lords, I am the petitioner.
He is the petitioner.
Serial number-
Mukambika Gas Agency.
File an application.
In my petition, he wants to implement somebody else, my lords.
You
Petitioner
shifted
relies
from
on
there to here.
circulars, my lord.
You file an application if you want to implement anybody.
Can I
Yes.
seek for extension of the interim order, my lord?
Interim order earlier granted is extended.
Please.
My objection may also be considered, my lords.
Everything will be considered.
Yes.
But unfortunately, if we consider it, it reflects bad on you. That is the reason why we
That
said
is why,
it should
my lords,
not be like.
no, that is why, that is the reason why, my lords, I advise them to, my lords, to go ahead with, my lords. So,
They're not listening.
no, that is the reason why they have decided to hold meeting also, my lords, on
My,
28.
my removal from membership,
Not good enough. Next.
please. But there's a
Serial number
second
10.
prayer also with regard to my removal, Lord, that also not considered.
That will be considered by the administrator. Everything will be considered.
Without notice to me, Lord, they have passed the order. I
Will no longer be there.
Serial number 10.
But on the last occasion, your lordship said directed, Lord, the 24/7/24 inquiry report.
Mr. Reddy, that by High Court Bar Association matter 6, there's no settlement on that. We fixed a date, get ready and address.
One round of discussion we conducted, Lord. We conducted one round of discussion. They didn't seem to be.
Argue the matter and let's close it. Yes, please.
Idರಲ್ಲಿ
I understand last time.
The inquiry whether it's been
There's
accepted
already
or
a report and it is accepted, etc. That is not a report. Page 247, your lordship may kindly.
Yes, Jafar.
Yes, sir.
Who is appearing?
No, no, no. I'll appear in this matter, my lord.
Report has been accepted.
No, my lord, it has not been accepted, my lord. That was the only verification that we were supposed to.
So 24/7/24,
It
which
is
has
not
been
a
submitted,
report.
has not been accepted.
It's not been accepted, my lord. Then it was,
what they are giving is, they gave us some documents now. These documents pertain to the second report of 23/9/25.
You're filing some documents.
They filed these documents, they gave us these documents.
It's a ploy to drag on the case.
Are you
Kindly
filing
see
any document? You're not filing anything.
They have served us
Page
some documents.
247, according to them, is a report
Page
which is
247.
supposed to have been accepted.
247.
247,
Yes. Annexure R.
Annexure R. This is, your lordship may kindly see the heading. Sahakara Sanghagala Janti Nibandhakaru. He has nothing to do with the district registrar of societies. He addresses it to registrar of cooperative societies, who have nothing to do with this. How this arose is, in the last general body, there was a departmental observer sent. He submits a report to the district registrar, which is being forwarded one after another. This has nothing to do with section 25 inquiry. This is not a report of section 25 inquiry. They, just for the purpose of avoiding that how this secondary petition was filed without disclosing the earlier order, all these things are being raised before your lordship. As far as government is concerned, it has made clear that except Sundar Rajan report, there is no other report under section 25, and that report is not accepted, which your lordships have already held so in the earlier annexure R23.
Yes.
They, without any remorse, they file another petition against the same notice and get away with it. They are entering an interim order in this petition.
Kindly see 24/7/24 inquiry report.
Yes.
Annexure R. Yes. Page 247. ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ The same petitioner hereunder, I'm sorry, the respondent, private respondent, whom Learned Senior Council represents, he has submitted a complaint. Cosmopolitan Club Jayanagara, subject one. ಬೆಂಗಳೂರು ಈ ಕ್ಲಬ್ನ ವಾರ್ಷಿಕ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ನಡೆದಿರುವ ಕಾರ್ಯಕಲಾಪಗಳ ಕುರಿತು ದೂರು ಅರ್ಜಿಯ ಪರಿಶೀಲನಾ ವರದಿ ಸಲ್ಲಿಸುತ್ತಿರುವ ಕುರಿತು. That is the same issue. ತಮ್ಮ ಪತ್ರ ಸಂಖ್ಯೆ ಈ ಕಚೇರಿಯ ಸಮಪತ್ರ. ಮೇಲಿನ ವಿಷಯ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖವನ್ನು ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಬೆಂಗಳೂರು ಇವರ ಪತ್ರದಲ್ಲಿ ಕಾಸ್ಮೋಪಾಲಿಟನ್ ಕ್ಲಬ್ ಜಯನಗರ ಬೆಂಗಳೂರು ಈ ಕ್ಲಬ್ನ ವಾರ್ಷಿಕ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ನಡೆದಿರುವ ಕಾರ್ಯಕಲಾಪಗಳ ಕುರಿತು ANK ರಾಜು ಮತ್ತು ಇತರರು ಸಲ್ಲಿಸಿರುವ ದೂರು ಅರ್ಜಿಯ ಪ್ರತಿಯನ್ನು ಲಗತ್ತಿಸಿ ಸದರಿ ದೂರು ಅರ್ಜಿಯಲ್ಲಿನ ಅಂಶಗಳ ಬಗ್ಗೆ ವಿಚಾರಣೆ ನಡೆಸಿ ಎನ್ಕ್ವೈರಿ ವಸ್ತುನಿಷ್ಠ ವರದಿಯನ್ನು ಜರೂರಾಗಿ ಸಲ್ಲಿಸಲು ನಿರ್ದೇಶಿಸುತ್ತದೆ. ಸೊ he acts on that. ದೂರು ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ದಿನಾಂಕ 5/5/24 ಅಂದು ವಾರ್ಷಿಕ ಸಾಮಾನ್ಯ ಸಭೆ ಪ್ರಾರಂಭವಾಗಿರುವುದರಿಂದ ಮುಕ್ತಾಯವಾಗಿರುವವರೆಗೂ ಸದಸ್ಯರುಗಳು ಹಾಗೂ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಯ ನಡುವೆ ಜರುಗಿರುವ ವಿದ್ಯಮಾನಗಳ ಕುರಿತು 10 ಅಂಶಗಳ ವಿವರವಾದ ದೂರನ್ನು ನೀಡಿರುತ್ತಾರೆ. ದೂರು ಅರ್ಜಿಯ ಅಂಶಗಳು ಕೆಳಕಂಡಂತಿರುತ್ತದೆ. So detailed records.
Duru arji is a complaint. It's not an inquiry. Who had asked him to inquire under section 25?
ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ? 25 1 they say ಅರ್ಜಿಯಲ್ಲಿನ ಅಂಶಗಳಿಗೆ ವಿಚಾರಣೆ ನಡೆಸಿ.
The section 25 ಅಲ್ಲಿ the registrar may on his own motion or appoint an inquiry
or on the 1/3 members.
So if now the joint registrar has done the inquiry according to you.
Yes.
That means there must be an order from the registrar appointing the joint registrar as the inquiry officer.
Yes, ಅದನ್ನು ಇದೆ ಇಲ್ಲಿ.
Where is that?
That is ಉಲ್ಲೇಖ. ತಮ್ಮ ಪತ್ರ ಸಂಖ್ಯೆ ದಿನಾಂಕ 17/5/24 ಈ ಕಚೇರಿಯ ಸಮಪತ್ರ ಸಂಖ್ಯೆ 3624.
Cooperative societies.
Cooperative
not the
society.
He
district registrar.
only has directed.
He has no authority under the society.
Then kindly see my
Is he
249.
been constituted as an inquiry officer? And say, you will have to show us that order.
The
Otherwise it's
reference
not
orders.
there.
We'll get the reference
The
orders.
state is saying it's not.
Unless what state says is it has not been accepted anta. That is their stand. But today they are giving us 2 documents. State has given us 2 documents pertaining to 2025 Gopal Krishna inquiry. Sundaraju's inquiry.
Yes.
This is what the state is giving us.
That was not accepted.
That was not the issue point on which, of course, that is not accepted, and your lordship's query was not on that point. Our issue is that this is in pursuance of a section 25 direction.
This has also not been accepted, even if it were to be.
Allah, but they have not answered that in these documents.
That
They
is
have
what-
given a different answer.
I will only point out, Malad,
Mr. Patil, it is not for you to answer, it is for the state
State
to
to
answer.
unless
You, both of you can be fighting, no issue.
state ಈಗಲ್ಲ ನಾನು ಹೇಳೋದು.
Lord, let them pointedly file an affidavit on this issue.
Section 25 inquiry can be ordered by the district registrar.
That is why we are asking Mr. Jaffer, who is the competent person to answer on this. Was a inquiry insisted
yes,
under
my lord.
section 25?
Yes, my lord.
If so,
Your
was
lordship
it
will
accepted?
Yes.
I
I apologize, my lord. We have not filed a memo. My colleague just collected it and carried it.
Annexure R, but
Now, these documents that were given to us
Annexure
does not
R, my
answer
lord.
this point. These were subsequent Gopal Krishna inquiry.
My lord, this
25.
document that I produced, my lord, 23/9/2025. In that,
This
if
is
your lordship will-
subsequent.
Subsequent.
We are asking you about Annexure R, page 246.
Yes, my lord.
24/7/24.
Yes, my lord.
This has not been accepted, yes, it is clear.
My lord, this is
They will have to verify this issue.
We had requested you to secure instruction, make your submission as to whether the inquiry report dated 24/7/24 at Annexure R
Yes.
has been accepted by registrar and actioned upon in terms of.
Pointedly on R.
my lord, they have provided me with this report now, my lord. I'll secure that, my lord. I'll secure.
What we want to
24/7.
know is whether Annexure R
Section 24/7/2024, my lord.
is a report under section 25.
Yes.
It is not, my lord.
And if it's been accepted or not.
It is not, my lord. How can, that is,
You have to make your
yes,
department
yes.
submission, we'll record it.
yes, my lord. Your lordship may kindly have it tomorrow, my lord.
Tomorrow.
On this, I'll get the.
Release tomorrow.
Please.
For learned AGA to secure instruction on the direction issued on 23/7/26.
Serial number 11, 9.
Request is one interim order to be extended.
Interim order earlier granted is extended till.
Obliged.
Yes, madam. Your third copy?
Yes. Yes.
All of you have received copies?
Yes.
So when will you get ready?
Any day next week itself.
My lord, I haven't received a copy, my lord. The BBMP has.
You like to file objections. So that means it is going this side. We haven't seen it. You are for? This one number? 4.
The contesting respondent.
Yes. You are the owner. Mr. Reddy, what do you want? You want a copy?
Yes, my lord.
Mr. Krishna.
I can share.
You'll have to
one
give
copy,
it to
my lord.
Mr. Reddy and Mr. Krishna also.
Lordship, I was only served maps by the area level officer, 5 copies.
5 copies.
Yeah, one I've served to the petitioner and 3 I've served.
One you have given us. 1 to the petitioner.
3, that's it. 3 to the.
No, I have received one copy.
AGS 2. AGS received 1. 3. Respond number 4, you are given 1.
The developer and the
4
builder,
and
both of
5
them
you are
have
given.
4, 5.
We'll share, my lord. The authorities, you will share, my lord. Authorities we will share.
Extra, which I told you to.
The learned commissioner appointed by this court has filed a report. Copy thereof has been served on the counsel for the petitioner, learned AGA, counsel for respond number 4 and respond number 5. Learned AGA is directed to furnish one set of the said report to the counsel for respond number 3 and respond number 6. You want to file any objections?
I don't think so, my lord.
Counsel for the petitioner submits that is acceptable to the report and it doesn't wish to file any objections. Counsel for respond number 4 and 5 seek for and are granted a week's time to file their statement of objections to the report. Objections, if any, to be filed on or before 7th August after serving a copy thereof on the all the other counsels. Relist on 13th August.
My lord, as far as the BBMP is
But can it
original
be on-
report, my lord, I get it on the next date also, my lord.
Keep the files.
Please.
Can it be on 12th, not instead of 13th, subject to?
12th.
12th?
Not interim order may be extended.
Interim order earlier granted is
And I request not be treated as part heard, not.
ಯಾಕಪ್ಪ 12th lane change ಆಗುತ್ತೆ.
ಅಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಬೇಡ ಆಯ್ತು.
Started ಮಾಡಿ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅಲ್ಲ because not spent a lot of time on this. That is why I'm only saying.
For further hearing.
Please. Objections ಏನಿಲ್ಲ ಅಲ್ಲ. Great.
Lords, I am not even aware, so why will I get into all that?
You never know, so we have to, if we have any doubt, we place it for you.
But your lordships raised a doubt, my lords, not even us.
For us to raise.
Because your lordships had some sort of a thing. I did not even.
Whoever has the knowledge has to raise it. Otherwise, what's the problem? This court tried on the earlier occasion, directed the counsel for respond number 6 and 7 to verify if there was any conflict. Today, the counsel for respond number 6 and 7 submit that objections. The appearance made by me was for another party in a proceedings filed by respond number 6. And there's no conflict as such. in view of the said submission and due to the consent of
Yes.
all the councils, the matter is taken up. Yes.
Proposed respondent 6.
The IA 1 of 26. 1 of 26. Yes. This is where we had stopped last. Why do you want to be a party? Why do you want to be a party?
Because this is a case wherein, under the joint development agreement in 1994,
Notes and
between respondents numbers 1 to 5, with me, it went for arbitration. There was a majority award which came to be passed. That award was set aside under section 34. Plus, after that, at page number 5 of my application document 1,
Who approached the arbitral tribunal seeking for what, and what is the award passed? What was set aside?
the landowners, that is respondents 1 to 5, they had invoked the arbitration clause under the joint development agreement in 1994
Seeking for what relief?
for the relief of damages and mandatory injunction directing me to hand over property.
So the JDA had been terminated.
Had been terminated by them. They had not sought for a declaration. On the contrary, they had sought for damages because I had delayed. That was the case. Damages of 61 crores they had sought for, along with the mandatory injunction directing me to hand over back the property to them. Plus, the majority award was challenged by the proposed respondents numbers 6 and 7 before the commercial court. The commercial court in 2024 passed an order allowing the section 34 petition and setting aside the majority award. Both Mr. Ajesh's client as well as the senior counsel have filed to commercial appeal pending in respect of the section 34 order. Because thereafter, at page number 5 of my application, there was a public notice issued, wherein three of the landowners wanted to sell off their particular share. And some was willing to buy it.
Yes.
We had accordingly, Lords, given our objections at page number 7. Thereafter, we filed an application under section 9. Before, we had filed it before the commercial court. The commercial court, after hearing, was pleased to pass an order in our favor. The order is at page number 10.
What is the order passed?
Page number 10.
Yes.
Document.
Yes.
Can I just read it out?
What relevant portion of the order you released, not the facts?
In order to protect the property in dispute, that is 8 lines from the bottom. From being wasted or alienated, it is hereby directed both the parties to maintain status quo with regard to the nature, possession, and title until further orders.
Untitled.
Since the respondent numbers 1 to 3 have voluntarily appeared
On retail.
through their advocate, there is no need to issue notice. So they were aware of this particular order. They voluntarily appeared.
Yes.
Matter was posted thereafter to the next day. Then they filed an writ petition before this court. That is at document number 3 at page number 11. And in the writ petition, my lords, they had obtained orders. Only one of them had 5 orders on page number 30, document number 4. The grievance was that they were not able to, they obtained this order at page number 30, document number 4. Issue notice to the respondent, stay of the order dated so and so, in Com AA, liberty is reserved to the respondents. Because only one of the three appeared approach this court, not all the three.
Yet the entire order has been stayed.
The entire order has been stayed, but so far as the other two are concerned, they had not approached. It is only this person that approached.
Yes.
I filed an application immediately for vacating that order has been set. This order has been, the writ petition has been disposed of. Parties are relegated back to the trial.
So the interim order is back in force. Where is that order?
Because I have that order. The order was uploaded only last week.
Yes. So you have an order of injunction in your favor as regards title.
And I've also issued a consent notice in respect to the other two who tried to go and execute the sale deed and get it registered. Because they had not approached this court. Although the order was stayed, it was on the basis of one of them. And all three had knowledge of it. All three had knowledge of it. I'm not getting into that. I have also filed a writ petition for a prohibition. It's also tagged along with this.
Yes.
That's today. They are trying to get an order from this court, directing the registrar. I'm not going on the merits. I'm only saying my interest has to be protected.
So you are to be heard in the matter.
Yes, that's all.
Yes. What about?
Yes, madam. My lord, the petitioner number 4 is my sister, and I am a co-owner of the property. My sister, along with respondent number 4 and 5, who are also my sisters, have purportedly executed a sale deed in favor of the petitioner 1, 2, and 3 before the Honorable Court. And they are seeking for a writ of mandamus to register the sale deed. That's the first prayer. And to take action to carry out necessary corrections in the online software portal. And therefore, I am before my lord saying that I am a co-owner, and it will cause prejudice to me because we have a partition agreement amongst ourselves where we have agreed to act together.
Meets and bounds, or?
No, my lord, it's undivided share. We have agreed to act together.
Not separately.
Not separately.
Any decision will have to be by all of you.
Yes, my lord.
Where
I
is that
produced the partition deed, which is at, along with my application, document number 1 at page 7A.
IA number?
My lord,
You are in IA number?
IA number 3 and 4, my lord.
3 and 4.
Yes, my lord. The first document is a partition deed dated 2/2/2005. Where there are two interveners, my lord. One is the uncle, that is the first person, Mirza Abdul Karim Namazi. Then petitioner number 4 is Zibande Khalili. Sabah Khalili is respondent number 4. Then Rehane is respondent number 5. And the second impleading applicant is Ismat Khalili.
Who are the impleading applicants? Ismat and?
Ismat and Mirza Abdul Karim Namaz.
Yes.
Yes, ma'am. My lord, in this document, at page 26, clause number 1, the parties, my lord, please, parties here agree to jointly share and hold and develop the Schedule D property with each of the parties holding specified shares as set out in clause so and so above.
Yes.
Each of the parties herein are co-owners in joint ownership, so and so. Bifurcation and division is neither practical nor possible inasmuch as it would diminish the value thereof, resulting in detriment to the interests of the parties herein. Development thereof as a whole and compact block alone would be beneficial and conclusive to the interests of the parties. Therefore, my lord, even though I definitely agree that section 44 is there under the Transfer of Property Act, but when we have agreed that we will act together as one single unit, this should be given effect to. Otherwise, my lord, the purchaser would subsequently have a right to file a suit for partition and seek for possession. That is one aspect. Second aspect, my lord, is that we have filed an appeal as against under section 37, as against the order passed by the Learned Commercial Court under section 34. That matter is pending before the Honorable Division Bench, and our appeal, my lord, is at page 148. I think page 148. And we have also, my lord, anticipating based on this public notice, etc., we have given a petition to the respondent registrar, which is at ink page 287, requesting that not to affect any registration. And so also, my lord, to the respondent Greater Bangalore Authority at page 294, not to bifurcate, change the khata. My respectful submission for my lord's kind consideration is that once this honorable court is pleased to grant a mandamus, automatically once the sale deed gets registered, thereafter, my lord, under section 149, I think, of the Greater Bangalore Authority Act, they would be entitled to get the khata, their name included in the khata.
That is merits will come.
Yes.
Whether you have an
Yes.
interest in the property or not.
And there are also other disputes, my lord, pending other this commercial appeal. A third party filed a suit for declaration on the basis that my mother has gifted the property to him. And behind my back, my lord, he obtained a declaration, which I challenged before this honorable court, which is a writ petition which is pending before this honorable court. And I produced the writ petition, which is at ink page 60
Of your
WP
application.
7137 of 23.
Of your application.
Yes, ma'am, of my application. And there is an order.
This is Ismat Khalili.
Yes, ma'am. And this honorable court was pleased to grant me an interim order at ink page 1. Sorry, where's the writ petition order? Oh, there's the commercial. I'll just place it, ma'am. The interim order is at ink page 84, sorry. And at ink page 85 is the operative part. Because the third party claims that he goes with a stranger on my property and settles the matter before the Lok Adalat. And based on the order of the Lok Adalat, a decree seems to be drawn up. And my name is included, even though I did not participate in any of the proceedings before the trial court. So I have impugned those proceedings before this honorable court. And to bring all this on the record of this honorable court, I seek intervention before the honorable court.
Yes, Mr. Panindra.
And sorry, my lord, last but not least, I am opposing even the petition filed by Mr. Joshua's client.
Right now, we are considering
Yes.
locus to come on record.
Please,
After that, you can make
Yes.
if you succeed on that, subject to what.
That your lordships may have to record that because there are certain things happening here that will also have bearing. Who is opposing whom? Let's now please see the prayers in my writ petition first.
Yes.
Lords, your lordships should get, my lords, the prayer at running page 32. The first one is an endorsement issued by the sub-registrar. Please see, my lords. Lords, in this, the petitioners number 1 to 3 are, of course, the purchasers. The fourth one is the sister, petitioner.
Yes.
Page 36, my lords, what does the sub-registrar say?
Yes.
ಪ್ರಸ್ತಾವಿತ ವಿಷಯಕ್ಕೆ your lordships have that. ಪ್ರಸ್ತಾಪಿತ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನೀವು ಸಲ್ಲಿಸಿದ ಭೌತಿಕ ದಾಖಲೆಯ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಕಾವೇರಿ 2.0 ವೆಬ್ ಪೋರ್ಟಲ್ ಸಿಟಿಸನ್ಸ್ ಪೋರ್ಟಲ್ ನಲ್ಲಿ ಬಹುಮಾಲೀಕರ ಒಡೆತನದ ಆಸ್ತಿಯಲ್ಲಿ ಮಾಲೀಕರ ಭಾಗಶಃ ಮಾಲೀಕತ್ವದ ಅವಿಭಾಜಿತ ಪಾಲನ್ನು ಯುಡಿಎಸ್ ಮಾರಾಟ ಮಾಡಲು ಅವಕಾಶ ಮತ್ತು ಅನುಮತಿ ಇರುವುದಿಲ್ಲ. ಕಾವೇರಿ 2.0 ತಂತ್ರಶಾಸ್ತ್ರದ ನೋಂದಣಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಸಂಪೂರ್ಣ ಆನ್ಲೈನ್ ಮುಖಾಂತರ ನಿರ್ವಹಿಸಲಾಗಿರುವುದರಿಂದ ನೋಂದಣಿಗಾಗಿ ಯಾವುದೇ ಭೌತಿಕ ದಾಖಲೆಯನ್ನು ಫಿಸಿಕಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತೆಗೆದುಕೊಳ್ಳಲು ಉಪನೋಂದಣಿ ಅಧಿಕಾರಿಯವರಿಗೆ ಯಾವುದೂ ಆಯ್ಕೆ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ನಿಮ್ಮ ಮನವಿಯಂತೆ ಪ್ರಕ್ರಿಯೆಗೊಳಿಸಲಾಗುವುದಿಲ್ಲ ಎಂಬುದನ್ನು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ ಹಾಗೂ ನಿಮ್ಮ ಭೌತಿಕ ಮನವಿಯೊಂದಿಗೆ ನೀಡಿರುವ ದಾಖಲೆಗಳನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ಹಿಂದಿರುಗಿಸಲಾಗಿದೆ. Issue is this. What I have raised is,
We will consider that on merits. Now, these two sets of people, 6 and 7 in IA 1 of 26.
Yes, Manoj.
And 2
I have filed my
in IA 3 and 4. They are contending that they have an interest in this property.
I'll tell you.
So any order passed will affect.
Lords, what I have said is, so far as my lords, the JDA is,
we can consider later. First, we will have to see.
Lords,
Especially they have a right in the property.
Lords, according to me, the JDA, my lords, that is Mr. Samuel, Hudson Samuel's client is concerned. Lords, the JDA was 1/11/1994, unregistered, unstamped. Lords, thereafter, a legal notice was issued on.
And adjudicate the merits on a one road.
I am saying they are not even necessary. My lords, my prayer is allow me to present. Suppose my lords have violated. I am not even sick. If your lordships, that's why I showed the prayers. That has to go. If I am allowed to present the document, and the sub-registrar has the right either to keep it pending or not to register. But that is also not being permitted because of the software problem. For that, none of them can have a interest in so far as that is concerned. My issue is only this: for presentation, let's suppose somebody wants to sell. I have violated. If JDA has a right in the property, what ultimately his right is 60/40 or 40/60 in the built-up area. I will be bound as a purchaser to obey if he succeeds ultimately, because he had sought a counterclaim in the arbitration, my lords, for specific performance. That was rejected. He has not filed a 37. Anyway, I will not get into that aspect. There is a termination of his JDA. I don't think Mr. Ajesh will oppose on that issue because
it is in his favor.
But strangely, if your lordship takes, my lords, the order of 17th July 2026,
17 July,
which my learned friend passed on, just the Honorable Justice Lalita Kanagatti's order.
Yes.
One sister came to the court, my lord, seeking a relief against a JDA holder. My lords, all of us are fighting against the JDA holder, but please come to para 6 in that order.
Yes.
As against the JDA holder, my lords, all of us have a grievance. Because commercial appeal is pending, we all went into the arbitration. But when it came to the rate, the uncle and sister, my lord, strangely said, writ is not maintainable. So that is why, my lord, I'm saying nothing comes out in writing. Today, my lords, seems like the uncle and sister are pairing or joining with the JDA holder insofar as this battle is concerned. Because there, if your lordship sees, this is
should be better that we refer to mediation and you sort out all your issues.
Lords, I'm only saying this for a presentation. Nobody will have a right to come so far as that issue is concerned. That's what I filed my objection.
You won't get a single kata.
Lords, I don't, Lords, presently I'm not, I will solve my problems after the arbitration. But presentation, nobody can prevent a presentation of a document.
Partition deed where you say that it
That
cannot
also,
be
my lords,
sold,
with great respect.
has to be jointly.
Lords,
All
please.
that we'll have to consider.
Lords, the partition deed does not say so. Please see the partition deed. It's not a partnership deed. My learned friend first said it's a partnership deed. Partition deed. My lord, please see the partition deed. All that it says. Please come to, my lords, page 26, I think, subject to correction in their impleading application.
Page 26.
Yes.
All that it says is parties herein agree to jointly share and develop the Schedule D property with each of the properties parties herein holding specified undivided shares as set out in clause 23 above.
Yes.
Now the clause 23 is there itself, how much each one is holding.
8/5/24. Yes, sir.
That's all. And clause 2 simply says we are in joint ownership. That's all. It does not bar anyone from selling the other man's share. And that the Supreme Court has categorically held now, that you can't even prevent somebody from selling their co-owner's share. It's an undivided share.
Give me that.
As a purchaser, I cannot come. Lords, I'm saying as a purchaser, I cannot come and seek possession. I can only seek a partition. The Supreme Court says you can't prevent a co-owner from selling his share of the property. Now, my lords, I want to.
Give us the decision.
My lords, I have the list of authorities ready. May I just pass on, my lords?
Yes.
Court.
Give them copies.
Yes, yes.
There's only on one rule 10.
Pardon me, my
There's
lords.
only on one rule 10, Alva.
My lords, on one rule 10, I have said, my lords, that serial number 8 to 10.
Yes.
Serial number 8 to 10.
Hmm.
Lords, is on the proper and necessary parties.
Hmm.
And my lords, if your lordship sees 9 and 10, I've set out the proposition and the para numbers. At serial, I'm referring to the index, sorry.
Take us to the para numbers of the.
Lords, on your lordships are straight away coming to the, lords, on co-owners, right, or your lordships want me to address?
Only on the impleading
Lords,
application.
impleading, please come, my lords. The first one is serial page number 100, running page 100. That is 2026-3 SCC 631. In that, paragraph number 31 to 34, my lords, which your lordships should get at running page, my lords, 107.
Yes.
It starts with the fundamental, your lordships have, my lords. The fundamental distinction between a necessary party and a proper party was succinctly explained in Ramesh Hirachand Kundalmal versus Municipal Corporation, Greater Bombay, wherein this court held a necessary party is one without whom no order can be made effectively. A proper party is one in whose absence an effective order can be made, but whose presence is necessary for a complete and final decision on the question involved in the proceedings. Then in Kasturi, then the my lords again they say, what are the twin tests in Kasturi's case? Then my lords 33 talks about my lords twin tests, my lords in para 32 sub-para they record, if your lordship sees the fourth line there in my lords in the court. Two tests are to be satisfied for determining the question who is a necessary party. Your lordships get it.
Yes.
The tests are, there must be a right to some relief against such party in respect of the controversies involved in the proceedings. No effective decree can be passed in the absence of such a party. The principle has been consistently reiterated in Mumbai International Airport versus Regency Convention Center and Hotels. This court reiterated a necessary party is a person who ought to have been joined as a party, and in whose absence, no effective decree can be passed at all by the court. If a necessary party is not impleaded, the suit itself is liable to be dismissed. A proper party is a party who, though not a necessary party, is a person whose presence would enable the court to completely, effectively, and adequately adjudicate upon all the matters in dispute in the suit, though he need not be a person in favor of or against whom a decree is to be made. If a person is not found to be a proper and necessary party, the court has no jurisdiction to implead him against the wishes of the plaintiff. The fact that a person is likely to secure a right interest in a suit property after the suit is decided against the plaintiff will not make such a person a necessary party or a proper party to the suit for a specific performance. Thereafter, in so and so, my lords, again they reiterate the same position. Now, my lords, para 37, your lordships can see. And para 35, if your lordship sees 35 also there in. There, of course, they said there is no relief that is sought against the appellants who are the impleading applicants therein. Then at 37, that apart, respondents 1 and 2 have instituted the suit or dominus litis, and it is for them to choose their adversaries. If they do not array the proper and necessary parties to the suit, they do it at their own risk. However, they cannot be compelled to add a party to defend a suit against their wishes. The decree, if any, passed in the suit would be binding only between the parties to the suit and would not infringe upon any right of a third party, much less of the appellant that is not a party to the suit. This conclusion, again, my lords, they say, referring to Kanakalata Das, about who can be a proper party and necessary party. The next one is, my lords, at page 110. That is, my lords, Mumbai International Airport, para 13, 15. The lordships would get para 13 at running page 115. 2010 7 SCC 417. Starts with the general rule in your lordships have para 13 minutes.
Yes.
They call out that, my lords. Then at para 15, if your lordship see, my lords, at page 116. A necessary party is a person who ought to have been joined as a party and in whose absence no effective decree could be passed at all by a court. If a necessary party is not impleaded, the suit itself is liable to be dismissed. A proper party is a party who, though not a necessary party, is a person whose presence would enable the court to completely, effectively, and adequately adjudicate upon all the matters in dispute in the suit, though he need not be a person in favor of or against whom the decree is to be made. If a person is not found to be a proper or a necessary party, the court has no jurisdiction to implead him against the wishes of the plaintiff. The fact that a person is likely to secure a right interest in a suit property after the suit is decided against the plaintiff will not make such a person a necessary party or a proper party to the suit for specific purpose. Normally, principles are this. And in the present suit, my lords, the other one is, my lord, of course, Ramesh Hirachand Kandalmal, there, my lords, that is reiterated. Para 6, my lords, it starts at page 122. But if your lordship kindly come to running page, my lords, would be 129, para 6 and 14. 14 is at running page 129.
This is 126.
It starts at 126. The judgment, my lords.
Hello.
122.
Para 6 is at 126.
Para 6 is at 126. I'm sorry. Para 6 is at 120. That is how, my lords, addition of parties is called out. Then, my lords, para 14. Please come to 14 at 129.
Yes.
It cannot be said that the main object of the rule is to prevent multiplicity of actions, though it may incidentally have that effect. But that appears to be a desirable consequence of the rule rather than its main objective. The person to be joined must be one whose presence is necessary as a party. What makes a person a necessary party is not merely that he has relevant evidence to give on some of the questions involved that would make him only a necessary witness. It is not merely that he has an interest in the correct solution of some question involved and has thought of relevant arguments to advance. The only reason which makes it necessary to make a person a party to an action is so that he should be bound by the result of the action and the question to be settled. Therefore, must be a question in the action which cannot be effectually and completely settled unless he is a party. The line has been drawn on a wider construction of the rule between direct interest or the legal interest and commercial interest. It is therefore necessary that the person must be directly or legally interested in the action in the answer. That is, he can say that the litigation may lead to a result which will affect him legally, that is by curtailing of his rights. It is difficult to say that the rule contemplates joining as a defendant a person whose only object is to prosecute his own cause of action. Then, my lords, they call out what it is.
Yes.
Now, my lord, so far as my writ is concerned, if your lordship sees the dispute amongst us, I am not concerned. My only concern is under the software, it is not allowing registration or presentation of a document of sale of an undivided right. Now, my lords, that is an issue vis-a-vis the state. In view of section 44, my lords, the Registration Act, there is no prohibition. 44 says a co-owner can sell his undivided share. So when I try to present it, it is not allowing me to present the document. Sale deed is executed by 3 sisters. Today there is 1 sister and 1 uncle who don't seem to be with the. Now that is why I have approached the court. Now what rights, my lords, they have, that is separately to be decided. My lords, vis-a-vis my sister and uncle whom Mr. Rajesh represents, that is a dispute where they have to sue something. In my writ, they cannot say there is a dispute. There is no dispute so far as we are concerned. There is no suit filed by them. The only dispute that is pending, my lord, so far as all the sisters and uncle with the JDA holder is where commercial appeals have been filed by the vendors as a family against the JDA holder, whose counterclaim was rejected by the majority award. Lords, there was a majority award by 3 arbitrators. Termination was upheld. He was directed to return. My lords, it's only a license under JDA. My lords, it's only as a license he is in possession. He was directed to give handover possession. 2 arbitrators held that so and so amount should be given as damages by the JDA holder to the landowners. 1 arbitrator on that, my lords, deferred and held that the landowners shall give 50% of the security deposit of about 1 crore what he had deposited back to the JDA holder. So far as termination, so far as other issues, there was consensus. Counter claim filed by the JDA holder seeking specific performance of the JDA by majority, it was rejected.
That has not been challenged.
He does not, 34 he filed, the JDA holder filed it. The entire award is set aside. So far as his counter claim, that also has gone. The owners have filed a commercial appeal challenging the 34 order. The JDA holder has left it at that. And he has neither initiated arbitration after that. He has not initiated except now filing a 9. So 37 is by the owners. So, my lord, so far as JDA holder, he has absolutely no right in. My lords, he is only a JDA holder. Ultimately, my lords, if I get possession, if there is a sale, if I get possession, he can enforce his rights so far as I am. I am only stepping into the shoes of the owners. I will be bound by if he succeeds, my lords, either in arbitration or in the commercial appeal or in the commercial suit. He will be entitled for his 60-40 right or whatever it is. That is of a JDA of the year 1994, if it succeeds. So, my lords, in this, my prayers, if your lordship kindly see, again, I would invite your lordships to the prayers.
Yes.
Now, my lords, prayer 1 is for quashing of that endorsement, which says we will not permit. The Kaveri portal does not permit. That can't be an answer at all. So nobody can have an issue. This, neither the JDO holder can have an issue, nor the sisters can have an issue because they does not concern them. Now, prayer 2 is, my lords, for a direction to respondents 1 to 3 to immediately register the sale deed in respect of scheduled property presented. Now, if your lordship do not, I will not even press for this. Please see prayer 3. Because I am unable to present the document. Now, my lords, there is no law which says I can't present a document. Today, I am unable to present the document. The sub-registrar, my lords, they say they have given letters asking the sub-registrar not to reject. That is for the sub-registrar to decide. That stage is not even come because the portal is not even allowing me to present the document.
moment it's presented, it will get registered.
My lords, that is for,
It's a natural consequence.
my lords, that today, my lords, the issue is only this. So far as our vis-a-vis rights are concerned,
Focus only on that, not on this right now.
yes, let's, so far as their rights are concerned, we are not, as of now, this court will not even be adjudicating on that.
Yes.
My only issue is state should enable the portal to be operative. Now, my lords, let's assume for a moment, my lords, for a moment, neither the JDA is here nor the other impleading applicant is here. There is unanimity amongst three brothers in an undivided family, my lords. Two brothers do not want to sell, but they don't have objection or whatever it is for the others to sell. If the presentation is prevented because of a software glitch, though this, my lords, in the same compilation I have given the judgments where the Honorable Supreme Court says, even the latest judgment, that the co-owner has a right to sell his extent of the right.
Page number?
Well, it's, in my compilation, the first judgment, if your lordship sees, 2024 SEC online SC 2456, Lords, para 21, it starts at page 1. 21 alwa. Para 20. Lords, that your lordships would get at running page 4.
Yes.
This was a case, my lords, I'll just tell the background facts. This was a case where one co-owner sold the entire share. Your lordships will see this, since the suit, lords, it starts with since the suit property. Your lordships have that parameter. Since the suit property has many co-owners, including the plaintiff, respondent Nandulal and Brijmohan, the defendant appellant Golam Lalchand could not have acquired right, title and interest in the whole of the suit property solely on the basis of sale deed dated 19/5/2006 executed by Brijmohan. The sale deed, if at all, in accordance with section 44 of the Transfer of Property Act 1882, may be a valid document to the extent of the share of Brijmohan in the property, and defendant appellant Golam Lalchand is free to take remedies to claim appropriate relief either by suit of partition or by suit of compensation and damages against so and so. So that it's a reiteration, my lords. Then the other one is at 2009-10 SEC 654. It starts at page 6. In that, my lords, kindly come to para 13. At running page 9, they again consider the same issue about sale of a
Para 25 of this judgment is different.
Pardon, my lords, your lordships are referring to the first judgment.
Yes.
Lords. There, my lords, para 25.
Yes.
My lords, please see the point for determination formulated in para 12 above is accordingly answered, and it is held Brijmohan alone was not competent to transfer the entire property without getting his share determined and demarcated so as to bind the other co-owners. Accordingly, defendant appellant Golam Lalchand has rightly been restrained by decree of injunction in acting in derogation of the proprietary rights of the co-owners until and unless the partition takes place. There he had sold, that's why I said he had sold the entire property. That's why in para 21, my lords, they say he could have sold his share, not the entire property. And that, my lords,
There's also, they say it may be a valid document.
My lords,
it's not a categorical.
My lords, that also again, my lords, if your lordship sees that's
maybe is what.
Please come to the next judgment also, my lords. I'm just taking because of the time constraints, my lord. It starts at running page 6.
Yes.
In that, my lords, please come to para 13. Because all this relates to section 44 of the Transfer of Property Act. Para 13 at running page 9.
Para 13 is a different judgment. That is Hardeo Rai.
My lords?
Hardeo Rai.
Running page 9, my lords.
9 or 13?
Running page 9, para 13.
Para 13, yes.
Lords, before that, in para 11, they say, my lords, that a purchaser of a co-parsoner's undivided share is not entitled for possession. But para 13, if your lordship kindly see, my lords, Thus, in view of the above, the law emerges to the effect that in a given case, an undivided share of a co-parciner can be a subject matter of a sale transfer, but possession cannot be handed over to the vendee unless the property is partitioned by metes and bounds, either by decree of a court in a partition.
There's a distinction here. In all these cases, the sale had already happened. In all these cases, the sale had already happened. And thereafter, it was questioned. Now is a situation where they are coming before the sale is happening.
So
on that aspect, we are not
I'm only
required to give a
saying
ruling.
this. No. Sale, my lords, whether they have, my lords, it's my petition. I have come here saying it is not being allowed to be present. Now, my lords, if the sale is.
Unfortunately, they also come.
No, my
So
lords,
we have to
I'm only
decide
saying
on
this.
whether they are proper and necessary party.
My lords, that's exactly.
Even before the sale.
My lords, sale has taken place. Today, the sale has taken place. It's not registered. Sale has taken place. Sale deed is executed.
Then be happy.
My lords,
Then be happy.
my lords, I'm only saying this. Today, my
It's not
lords.
so don't put it so.
Lords.
See, there is a objection which has been raised for the registration. On that aspect is what we are now
Lords,
deciding.
I'm only saying this. If 44 permits sale of a co-parcener's rights, now JDA will not even have any right insofar as this is concerned, my lords. Whether it gets presented, whether
JDA
it is
will not have.
JDA, my lords, that those judgments also have placed that an agreement of sale holder itself has no interest. A JDA holder having an interest does not even happen.
JDA has a better interest than agreement.
Lords, I would respectfully
percentage of share is there.
Lords, his right can always be, my lords, adjusted. He has a right of constructed.
Agreement of sale is specific performance. JDA
That's all.
is a different.
So far as the other one sister and one uncle. Oh, my lords, there is no, we do not have any dispute. They have not filed any suit against me. Injunction is not up.
Is there any judgment on they cannot object for a sale happening?
My lords,
these are all after sale.
My lords, sale happening is not worded. The other judgment is, my lords, 2008 7 SEC 46, where law is laid down. That starts from running page 10, my lords.
Yes.
In that, the court holds, my lords, a co-parcenary right can be transferred.
Page.
At para 25, which your lordship should get, my lords, running page 15, 1-5.
Yes.
It starts with in bottom only there.
You're not entitled to possession, Ashte.
I'm not entitled to, my lords, I'm not even asking. The sale deed also does not say.
For both of you, it is the same question.
26, your lordship may kindly see 26. Thus, even a co-parcener interest can be transferred subject to condition. Purchaser without the consent of his other co-parceners cannot get possession. Yes. Mine is not even that. He acquires a right to sue for possession. So here, my lords, I am not even seeking for possession. And the entire issue before my lords is actually none of this. The issue is against the state.
The issue is as regards registration of sale deed, which they are opposing. Before the sale deed happens, all these decisions, if it's not there, we'll have to apply our mind to it. That's not an issue.
No. I'm only saying, let's the position of law being this. Let's what I'm trying to make out is, if 44 permits sale of a co-parcenary property, undivided share. Now, one sister and one uncle coming here and saying, don't permit that sale. Let's, this is not the forum.
We are only considering the impleading application.
Yes, their entire case before my lords is, I have a right. I have filed objections to the sub-registrar. Don't allow such sale. Now, my lords, that is a separate cause. What I have come here before my lords is that the software is not permitting me.
Right. You have repeated so many times.
Lords, that is the only issue which needs to be adjudicated.
Anything else from this side?
Can I respond?
We are only passing orders on the impleading.
Yes, ma'am.
Impleading.
But on first principles, I want to submit all the judgments learned senior counsel placed reliance on was in a suit. In a matter of writ, my lord, most respectfully, there's a lot more leeway, and I place reliance on a judgment of division.
Whatever you want to place
Yes,
reliance on, please give it. Let one of you complete and then we'll complete. In between, but.
No, this is of the High Court of Jammu and Kashmir, para 14 and 15, in page 9, my lord.
14 and 15, yes?
Yes, my lord. That the writ court cannot keep itself confined merely to the litigants appearing before it or on the record available, nor will it keep itself confined only to the lists before it, but will also take into account the consequences or the effect which the decision will have or is likely to have on the interests of others who may not be wholly necessary for the decision of the issue at hand, but whose interests would be vitally affected in the consequence of the decision rendered in the writ petition. Viewed from this angle, the concept of necessary party in a purely civil suit and a writ petition cannot be the same. Far from this, the scope of necessary party in writ petition will be much wider than in the civil suits. The High Court invoking writ jurisdiction looks beyond the parties appearing before it and must ensure that not only the persons who are essential for the purpose of the disposal of the case, but also those who will be vitally affected by the order to be passed are made parties so that nothing is decided behind their back. Then para 15 is Prabodh Verma versus State of UP. The High Court ought not to decide a writ petition under Article 226 of the Constitution without the persons who would be vitally affected by its judgment being before it as respondents, or at least by some of them being before it as respondents in a representative capacity. This is one aspect, my lord. The second judgment, my lord, is Shivdeo Singh, page 15. The only aspect, my lord, is that I could file a review petition or even a writ petition, that's page para 10 at page 18, where the Honorable Supreme Court said that a writ against a writ is maintainable in the form of a review jurisdiction. And I'll tell my lord why these facts in this particular case may attract these two propositions. One aspect, my lord, if we look at the prayer is in the nature of a suit for mandatory injunction. The first three parties to the writ petition are proposed to be purchasers. My sister or my niece is the fourth petitioner. They now would like to have a mandamus as against the property to saying that this mandamus be granted. I submit, my lord, most respectfully, they produce the sale deed. Now, in the sale deed, my lord, what I noticed, I just looked through the copy. If my lord is pleased to see the sale deed along with the writ petition, yes. Page 69, my lord, I'm just looking at the page 69. It says that there is no case pending. The property is free from litigation. My lord, here is a case where I have no differences with my sister or with my niece, however we look at it. The first three persons have been talking to me at different levels. I have not been able to come to an agreement. Now they precipitate the matter, file a sale deed by making a statement saying that there is no litigation pending, whereas there are so many cases pending which I placed before my lords. Now, if they had placed all this, then my lords would be pleased to consider that this writ, if it was allowed, they would get the sale deed registered, they will get the khata issued in their name. And it will cause prejudice even to my appeal. My lord, I am opposed to the client being represented by Mr. Joshua, and so far as the joint development is concerned, because my submission is, unlike what Learned Senior Counsel Mr. Panindra said, the person who has filed the Section 34 is not the person who signed the joint development agreement. I entered into a joint development agreement with a partnership firm. A proprietary concern represented by one of the partners files a Section 34, but that's a contention before the Section 37 court. So my submission, my lord, is that this order, if any orders passed by this honorable court, will cause prejudice to me. In fact, my lord, in para 21 of their statement of objections, the petitioners to my
statement of objections to your
impleading application, they say that it is going to benefit me. So if something is going to benefit me, my lord, I also most respectfully say, let it not be gratis. Let me also be heard. This is what they say. It is further submitted that any relief that would be granted in the above writ petition would ultimately inure to the benefit of the impleading applicant. This is their own contention.
If they want to sell, my lords, let's assume. I'd oppose, he wants to sell it.
Then is there a means of forcing them to sell?
Oh, I am not forcing, it's his way of reading it.
It's like the British, my lord. They come in,
his
create
way
a
of reading
dispute,
it.
and then they sit outside
What,
and
lords,
laugh.
your lordship may kindly consider.
Let him complete.
Yes.
Then you
My lord,
can give your surrey joint.
please, my lord. My lord, here's a case where first, second, and third petitioners, complete strangers to the family, obtain a sale deed for my sisters, come before my lords, withholding this information, and therefore they try to project a dispute. There's no dispute between me and my sisters, and we are equally opposed to the developer. There's no difficulty. My lord, because we have agreed.
Then why don't you sit across and sort it out?
My lord, they have to come to us, my lord, but they cannot. What they are doing, my lord, they are creating a sale deed. Then they are forcing us to say, look here, you will buy this, sell this property to us at these terms, etc. Now, we have a situation, my lord, one is based in Singapore, one is based in London, and they are not resident in Bangalore. And we have said, okay, we will have a discussion, but that cannot be by them breaking down the family, my lord, most respectfully. That is where we have been.
If all of you are agreeable, you let us know when you can come. We can refer the matter to mediation, and you can try and sort it out. If all of you are agreeable, otherwise
I'll
we'll
find
pass
out,
our
my lord,
orders on
because
this.
my instructions were, if they directly talk, everything will be possible.
And talk
There's
directly.
something, that's why, my lords, I do not know, because my instructions are, they are in communication.
So if mediation happens, everybody will be there directly.
Yes.
But without the JDA, my
Yes,
lord.
I
JDA holder,
agree.
we do not want any mediation as of now. My instructions.
Finish this, then.
That I agree, my lord. I
Mr.
agree with.
George. First, you sort out your issues.
No, I
That's
agree
exactly.
with the learned senior counsel of the petitioner. Insofar as my clients are
Just
concerned.
because Mr. Ajay is standing that side doesn't mean that he's not with you.
No,
He's
no,
been-
lords.
From that time, he's with you.
My lords, there are so many other things which have happened. When the status quo order was granted, once somebody went and said no objection for granting status quo in the arbitration.
My lord, this is the issue.
Please see.
They want to obtain an
Exactly.
order. They want to obtain an order by suppressing facts.
Section
They
9.
want to push me to the corner.
Now, what do you want us to do? You want to refer to mediation or pass orders on this?
My lord, I can take, if my lord permits a day, I'll ask my client for instruction.
Very well.
Yeah, will finish your arguments. Anything else?
Only on
Only
that.
the last thing, the intervening applicants have been unfairly targeted by the purchasers, who are the writ petitioners 1 to 3.
Yes.
My lord, we are entitled to, and we should make a submission before my lord, when the writ petition is not maintainable. To make much of it is not fair. Second thing, my lord, they come before my lord, suppressing material facts. We bring it to the attention of this court. They feel that what we are doing is wrong. My lord, we have two aspects. One is the commercial appeal pending, because if everybody.
Repeat, Mr.
Yes,
Ajay.
my lord.
Lot of
That's
people
all.
are waiting.
That's great.
Yes, Mr. George.
Page
70?
74 of the writ petition. The statement is made that possession is with me, because in the arbitration they ask for a mandatory injunction. Page 74, clause number 9.
Sale deed and lien barthi. Yes.
The sellers at this date delivered and put the purchasers in actual physical joint vacant possession. I'm in possession. That is what the arbitration award says. And what they are trying to do is, they are trying to sell away my right. I have a 60% right, admitted right under the joint development.
And that right will be yours if you,
Yes,
whoever.
what I'm trying to say is, they are trying, kindly see page number 77.
Yes.
They've given the tabulation. How much of it is going to be sold? It is there 25% as per this particular sale deed includes my right of 60%.
Correct. Now, 60% of your this one, Indraprastha Excellence, 60% of 40% will be landmark, 60% or 19% would be Indraprastha Serenity.
No, this is with regard to the internal petitioners. In so far as 100% of the land,
Yes.
3 owners are selling away their rights.
They get substituted by these 3.
I'm just saying, my rights are being dealt with.
But how does it affect you?
Because how it affects me is, I already have an order of status quo in the commercial court. Number 2, I have an order passed under section 34, wherein I have the award has been set aside. I am going ahead with the process of arbitration against them.
You can go ahead with that.
Yes.
How does For them, yes, there is a possibility of them being affected. For you, at the most, the owner is changing, that's all.
No, but sir,
If
what
you
will
succeed,
happen is,
if you succeed in that arbitration, you'll have to file it against these owners.
because my only thing is, well, what the Supreme Court says. The Supreme Court says
Yes.
so far as
Redundancy. Yes.
Let's, I'll not take the time of the court. Let's directly come to paragraph number 7.
7. Yes.
The principles governing pleading
Hmm.
are well set in, though proceedings under 226 of the Constitution of India are not to be controlled by the technicalities of the pleadings as an ordinary civil suit. The principles underlying Order 1, Rule 10 of the Code of Civil Procedure 1908 continues to furnish sound guidance in Mumbai International so on. So this court explained the distinction between a necessary party and a proper party. A necessary party is one without whom no effective order can be passed. A proper party is one whose presence enables the court to completely, effectively, and adequately adjudicate upon the questions involved. In writ proceedings, where the court is called upon to interpret the scope and operation of an interim order already passed by it, the person who is shown to be directly or demonstrably affected by that order cannot be shut out merely because such person was not an original party to the principal challenge. Tested on the aforesaid principles, Malab Segon.
Hmm. Yes.
All I am trying to say is, Malab, today I have also filed a writ petition or a writ of prohibition. If for some reason I am not made a party here, my writ, which I have said that please do not direct the sub-registrar not to register, that there will be an issue. So I have to be in both the writ petitions. I made all of them as parties in another.
Yes.
No, it's only one. In his rate, please see the prayer. It's a prohibition not to register it. That, my lords, prohibition does not arise, my lords, against carrying out of statutory duties by the sub-registrar. Be that as it may, petitioners number 1 to 3, they have not made us as parties there. My learned friend went on saying, I have suppressed facts regarding litigation. No, I have brought it out at para 16. I have mentioned it. Commercial appeals are mentioned. Writ is mentioned.
You brought it out in the sale deed is what they're saying.
Sale deed also, my lords, the previous facts are brought out. What my learned friend says, there is one more case, one more suit by one Iqbal. Lords, that is by an imposter who got all of us deleted and got a decree. It is inuring to our benefit. How, in what manner will that help, my lord?
Will you get back on the
Tomorrow, your lords.
Tomorrow.
Only to report this aspect, my lords.
Third, Sri Ken Panindal, Senior Counsel for the petitioner. In WP 15824 of 2026, Sri Joshua Arjun Samuel, Learned Counsel for the impleading applicant in IA 1 of 26. Sri Ajesh Kumar, Learned Counsel appearing for the impleading applicants in IA 3 of 26 and 4 of 26. Only on the impleading applicant.
Please, ma'am.
Relist tomorrow.
Please, ma'am.
Can it be in the second list itself?
230.
Meanwhile, my lords, state has not come out with anything in between all this. The issue, the core issue, my lords, they are enjoying and keeping
They're happy
quiet.
with all of you fighting.
Core issue, my lord, ಏನು answer ಇಲ್ಲ.
I'm watching the
ಇನ್ನ
entire
ಶುರು
proceedings.
ಮಾಡಿಲ್ಲಲ್ಲ ನಾವು ಕೆಲಸ.
I'm watching
We
the
are not
entire
heard you
proceeding, my
only.
lord. My submission is my learned senior is successful in deleting these two people. Then, my lord, we directly have to. Then I will answer directly to his contention.
Yes.
Serial number 13.
My lord, 13 and 14. My lord, a learned arbitrator has recused himself.
ಅವತ್ತು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡೋವಾಗ್ಲೇ ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲ, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದಾಗ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ, ಬರೀ ಸೀರಿಯಲ್ ನಂಬರ್ ಮಾತ್ರ ಗೊತ್ತಾಯ್ತು ನಮ್ಗೆ. ಆಮೇಲೆ ಇಟ್ ವಾಸ್ ಲಿಟಲ್ ಟೂ ಲೇಟ್.
District judges. Can we appoint Mr. Bhimanagowda ke party? No, Dharwad ಅವರು.
Lord, serial number 80, 135, 140. Lord.
Mr. T.T. Puttaranga-Swamy, ಬೆಂಗಳೂರಲ್ಲಿದ್ದಾರೆ. Any conflict with any of you?
No.
Quite order dated. November 25 in CMP 46 to 25, this court had appointed an arbitrator. The arbitrator has recused himself from the matter on account of conflict. Hence, a letter has been addressed by the Director, Arbitration Conciliation Center, Bengaluru, for appointment of a substitute arbitrator. In that view of the matter, with the consent of both the councils, Sri D.T. Puttaranga-Swamy, a former judge of the district judiciary, he is appointed as a sole arbitrator to arbitrate the dispute between the parties. The rest of the order, terms of the order dated 14 November 25, remain undisturbed. Second,
Right.
14 is also same?
Same.
14 same.
The date of arbitration may be fixed, my lord.
The party shall appear before the Director, Arbitration Center without requirement of any notice on 10th August 2026.
Great.
Grateful, my lord.
Serial number 50. Puneet Kumar.
This is the matter, my lord, for compliance, where this is the integration of the e-Janma portal, my lord. On the last date of hearing, I had made a submission that the UID authority or the central government would be the party. The learned DSGI also was here, my lord. He had another matter, my lord. He requested me that if there is a judicial order, my lord, they'll get the information from the union government also. Now, my lord, the council appearing for the BBMP in the judgment, he has made a submission that they import all the details on the hospital, my lord, when they issue the birth certificate or the death certificate. Now, this compliance is arising out of a dispute with regard to the name that was entered in a birth certificate, and subsequently they had challenged under section 11 of the RBD Act, my lord. Now, my lord, what has happened is the two aspects to it now. One is the government as e-governance is involved, and the BBMP. You know, my lord, BBMP says they do not have much to be done after issuance of the certificate unless it is integrated. Now, my lord, what happens is even if those hospitals or the authorities where the birth or the death happens, if they have the Aadhaar card, now assumingly the Aadhaar has the correct name, my lord.
So DSGI wants a
Direction from
issue
this
so he can-
honorable court so that he can collect the information and place it before the court, my lord.
DSGI is direct to secure instruction and make a submission as regard the possibility of integration of the e-Janma portal with the UIDA Act, released on 18th August.
Your Lordship, I'm filing amended cause title, Your Lordship, including respondent number 5.
Amended cause title filed by the petitioner is taken on record.
I may be permitted to amend the cause
Carry
title.
out.
Please.
Serial number 16. DL Sanjeev.
Who is to report compliance? Oh, this is that software
Yes, my lord.
demonstration.
Yes, my lord.
Any VI? Anything there today or?
No, nothing today, my lord. Nothing today.
The request and AGA relist, the AGA relist on 24th August to report further compliance.
230 mood matters. A. Chandrachud.
One more notice, Mr. Ron.
But 64A proceedings,
Yes, two of them have been already stayed and they are pending.
under 64A, if my lord sees at page 48, this 238, this one, 48 may be seen.
Hmm. Yes.
Appeal lies under 64A 3.
Yes, we already are seized. We are already seized of two matters. These are all people who are residing there.
No, this is only in respect of what happened. There are about 290 acres of land which is taken.
Hmm.
If they give an undertaking that they are not going to alienate those lands. Now, what is the
This is by
immediate
HMT,
concern
madam.
is, my lords may kindly, I'll just
Oh,
point out.
you are HMT.
My lord,
Don't alienate them.
My lord, my matters as per their own application before the Honorable Apex Court for deforetization of my particular property is still pending consideration. My application is also pending consideration before the Apex Court. Now, as far as that particular aspect of alienation, until and unless the matters what are seized before the Honorable Apex
We will
Court.
not indulge you in this matter also.
Well,
Then we won't pass you any orders in this matter. You approach the Supreme Court.
No, my lord, my only question is under 64A, there was an initial order, my lord. 64A,
Mr. Chandrachud, if you are going to say, undertake that you are not going to alienate this property, then we'll consider granting this interim order. If you say, no, I won't do that, I'll continue to alienate, we will not consider this.
on that particular, only on that single point, I will definitely take instructions and make my
When will you
submission.
get the instructions?
As of now, my lord.
When will you get the instructions?
Tomorrow itself, my lord.
Tomorrow. And AGA for respond number 1 to 6.
And in the meantime, my lord, at least there is already a threat which says as per this particular order.
Won't do anything. Yes, next.
Angat Kamath.
Lord, one more point, my lord. On this particular point, initiation of this particular point.
We'll consider all of it later. But you will not be entitled to alienate.
Only on that particular
That's a
point.
fair submission made.
But
if you're not ready to alienate, we are not going to interfere.
But time and again invoking this particular clause.
That is against different people. Now you have come in.
No, this was against me also earlier.
So now we'll hear all of it together. You are the one who are missing in the entire set of.
No, my appeal under section 64 3A is also pending.
Subject to your making that submission.
Yes, ma'am. I'll just because if it was in a private brief or an individual's matter, I could have.
Tomorrow.
Yes, ma'am.
Yes.
Petitioner number 1 is
What is this?
serial number
You have
2.
18 of his objections. Court fee has not been paid.
Court fees paid.
Court fee is paid. 18 of his objections are there.
No, only on translation, or nothing on the substantive.
Rank of parties, blanks to be filled, details of R5, all
Everything's
annexed
clear.
to be marked.
It's clear.
Index not tally. Won't
File
make us the
confirmed.
registry.
Cleared. No, your lordship will see the prayer. I'm not asking anything which may come in the way of that. Lordship will see the prayer at page 18. Petitioner number 1 is a trust. Disputes have arisen relating to the management of the trust. Elections were held in connection with the management of this trust on 5th of July. Prior to the elections, Lord, we ourselves have gone to the police, up to the commissioner, given representations that elections are being scheduled. Please depute a force to oversee the elections. 10 officers have come, videographed, elections have happened. Then subsequently, the erstwhile committee files a complaint, Lord. Please see the complaint your lordship will find on 10th of July at page 202.
Your client did not inform.
I'm sorry, Lord.
Some of the petitioners we have appeared for. Post for a bench of which SGRJ is not a party.
We at first moved the 480 to vote. They said it has to come. Where it is to again vote. I can't ask.
Two of them should have told you. Yes.
Passed over matters. List number 1, serial number 2.
Passed over. Right. 520 past hour andre.
89.
My lord, serial number 2, my.
Any date of convenience. Serial
Why
number
we are not taking past hour is if we take 2 of them, the others will feel bad.
89 my request.
My lord, serial number.
Uh, 89 released on 5th August.
Serial number 93.
Interim order ಏನಾದ್ರು ಇದ್ರೆ extend.
Serial number.
ನಿಮ್ದು ಏನದು?
Serial number 89 interim order.
ಎಫರ್ ಏನಾಯ್ತಪ್ಪ
List
ಅದು?
number 2, my lord, that my colleague Maltesh Shekhar was
ಹಾ.
appearing. He was here, my lord.
ಮಾತಾಡಿದ್ರಾ?
He has already. My
17. Serial number 4 list 2.
My lord, serial number 2, my lord.
My lord, serial number 91.
ನಿಮಿಷ.
Serial number 91, my lord.
ಹಾ.
We have filed the vacating stay application, my lord.
Very good.
My lord, a short date may begin, my lord.
Yes.
My lord, a short date may begin.
Serial number 60, my lord.
Ah.
Pass over matter, man. Kindly have any own date.
Any date.
Serial number 89.
ನಿಮ್ದಾಯ್ತು.
Serial number 67.
ಒಂದ್ ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ ಡೋಂಟ್.
Serial number 92, my lord.
Ah.
Filed a memo of retirement. Have given NOC of to the party.
Somebody will appear.
My lord, our interim order was kindly extended.
All interim orders will be extended.
Serial number 67, my lord.
Hmm.
Then have the day after tomorrow, my lord.
Day after tomorrow ಅಲ್ಲ.
For senior
ಏನ್-
citizens, they are going to evict from the property, house property, my lord. On Monday, my lord.
67 Monday.
My lord, serial number 2, my lord, Senior Citizen Act, and I have filed an application for
Serial
implementation.
number 2 Monday.
89, my lord,
93, my
interim
lord.
order.
Serial number 93 lookout circular issue ಆಗಿದೆ my lord and visa next week ಅಲ್ಲಿ expire ಆಗುತ್ತೆ.
93 Monday.
89 ಅಲ್ಲಿ interim order.
Interim order, all interim orders will be extended.
Serial number 53, pass over, ಸುಮಾರು ಸಲ pass over ಆಗಿದೆ. ಅವರು ಅದರ್ ಸೈಡ್ ಕೇಳಿದ್ ಮಾಡಿ.
53 5th.
63.
Regular date ಆಯ್ತು ಸಮಯ ಅಂತ. 53 interim order to be extended.
All interim orders will be extended.
Fifth ಬೇಡ ಆಗಿತ್ತು 11th.
ಯಾವುದು?
5th, my lord, I will not be in station.
My lord.
ಆಯ್ತು 6th. 6th.
Serial number.
ಹಾ. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು? Then we have to pass orders on merits. Yes. Yes. ಹೇಳಿ. ಹಾ. ಹಾ. ಏನಪ್ಪ 41? ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು? 41 released on Monday.
Serial number 60, my lord.
My lord,
Serial number 60.
ಹಾ. ಏನು?
A short date. It is a.
We'll consider it that day, madam.
63, my lord. First week of 58, first week.
Past overs ಎಲ್ಲ 6th August. Remaining 19th August.
71 6th.
Over 6th August. ರೀಚ್ ಆಗ್ದಿರೋ 19th August. Booking ಮಾಡಿ ಅಂದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Pass over 68 ಅಲ್ಲ madam? Pass over 68.
ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಎಲ್ಲ 6th.
ಮೇಡಮ್ 82 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಅದು 6
Past overs
6
ಎಲ್ಲ
ಬೇಡ
6th.
6 ಬೇಡ 19 ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ ಮಾಡಿ
6th ಹೌದು.
ಪಾಸ್ ಓವರ್ 16th 6
91 ರೀಚ್ ಆಗಿದೆ 19th August. 94 19th August. 19ಕ್ಕೆ ಆಗ್ಬೇಕು ಯಾವುದು? ಅದು ಜಾಸ್ತಿ ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀವಿ, ಕಮ್ಮಿ ಕೊಡ್ತೀವಿ. 9 ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. 92 19th August. 94 19th August. ಅದು ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಬಂದ್ರು ಏನದೇನು ಹೇಳಿ ಸರ್ ನೀವು ಯಾರು 6th August ಪಾಸ್ಟ್ ಓವರ್ ಅದು 6th August. ನಿಶಾಂತ್ ದೇವಿ ಅಲ್ಲ ಅಸೋಸಿಯೇಷನ್ ನಂಬರ್ ಸಿಗುತ್ತೆ ಅದೇ ಜಸ್ಟ್ ಪ್ರದೀಪ್ ಸಾವ್ಕಾರ್